For committee members right now, we have several items we want to discuss. One, on scheduling, I do not have a specific date on the first session yet that we're going to have here in the general court room. That was, we know that we had or the date to get our early bills out. That was the 17th. It's been backed over the 10th. Now, when that session day occurs, it's still worked out because the governor's going to give his address and all that and try to mesh the two together. So that's why there's, it hasn't been defined as to exactly which day it's going to be, whether it's going to be a Wednesday or a Thursday, I don't know. And as soon as we find that out. Also, the last week in the month of February is usually school holiday week. We're going to try to have that as a date in which this committee won't be hearing anything or doing anything. But, I can't say it definitively until we know where we are on executing some of the bills coming up. And to make sure that those dates agree with what's going on elsewhere outside of our realm here, like in the school districts and all that. I know up north the school vacation date's always a little contrary to what it is south of. Yeah, and of course, we should really be gearing all this around what we do in the North Country, not what we do down here in the southern part of the state. And
I would agree with that, Mr. Chairman.
Thank you. You and I are on the same page in that one. And you have to use your principal voice. Thank you. The other point is that yesterday we did a great job in getting some bills exec and out of the committee here, and we have a lot on consent. The majority of all went on consent. But I'll remind those that are tasked with writing the committee report, or what we used to call the blurb, please get that in immediately to me. You can send it to my email address, and then what I'm going to do is put them all in a folder and send them to Jennifer. Jennifer then works with people upstairs, or to Lindsay, and then she works upstairs, and then they get across to the Paul Smith, and then on to the speaker for final approval. So we need to get those done because we're going to start getting overwhelmed with everything here, and we don't want to play catch-up ball. So with that, I'd also like to say on the first bill here, after it is introduced here by the prime speaker, we're then going to call the Department of Education up. They have asked for a few moments where they can speak on some of the technical side of things in terms of all these bills they're dealing with today, and we have the people in charge of that program here. And so if you're looking through the charter school bills, which we have on the docket today, feel free to ask the department any technical questions referencing any of those bills at the very start here. We can get them done with their business so they can, get on to other things as well. So Mr. Green and company are here, so we'll do that after we hear the prime sponsor on the first bill here, and it is HB 1074, relative to notice to a charter public school of a special education services meeting. Welcome.
Thank you, Mr. Chairman. Members of the committee, good morning. For the record, my name is Maureen Mooney, a state representative from the town of Merrimack, that's in Hillsborough, district number 21. I've provided written testimony to the clerk or the vice chair this morning, and so hopefully that's been distributed to all of you at this time. House Bill 1074, of which I am the prime sponsor, and for the record I am in support of, does two things. First of all, it corrects a typo, believe it or not, that exists in current law in RSA 194-B, where the word charted appears instead of chartered. Second of all, it inserts into law a requirement that chartered public schools be given prior notice for subsequent meetings of an IEP team. As current law reads now, when a child enrolls in a chartered public school, that child's resident district shall convene a meeting of the Iep team and invite a representative of the chartered public school. After this initial meeting, the law is silent as to subsequent meetings of the Iep team. Although subsequent invitations may not be necessary going forward. Chartered public schools do need prior notice. So just to be clear here, we're asking for notice, not necessarily invitation, of subsequent meetings for successful student achievement. Communication and awareness are critical for special education. With the courtesy of prior notice, the chartered public school can better track, monitor, and communicate a child's IEP plan. It is not in the best interest of a child if his or her chartered public school is completely unaware of subsequent Iep team meetings, which could result under current law. This bill is meant to strengthen the special education programs for children at chartered public schools with a reasonable request that the child's resident district provide prior notice of subsequent IEP team meetings. Now, in concluding my introductory remarks, I want to mention a couple of things. First of all, this bill, as well as others I'll introduce today, are a series of bills that have originated from the ground up, right from those most familiar with the operation of a charter school to this point here, not from top down. Also, I want to mention that throughout the day in this room, collectively, I believe will be close to about 100 years worth total, if you do all the math, of those involved and familiar with charter school, adding up their experiences with operating charter schools, administering them, founding them, being on boards. It goes on and on. Charter school experts and those most familiar on the ground with the operation of a charter school will be here today. And they have requested this bill. So with that, just to emphasize the importance of this bill to special education, to also emphasize the origins of this bill and others I'll introduce today, which is very important to hear from those who know charter schools best. That will conclude my remarks, and I want to thank you all for your attention on this bill and others I'll introduce this afternoon. Thank you, Mr. Chairman.
Thank you very much, Representative Mooney. Are there questions for the representative? Yes, Representative Cordelli.
Thank you, Mr. Chair, and thank you, Representative Mooney, for being here. The child with disabilities who is attending a charter school might well have an IEP, but also being part of the regular education program at the charter school. Would that be a correct statement?
Yes.
Thank you.
I have one question, and then perhaps we can get to the department. You're saying prior notice of subsequent meetings is silent in our statutes.
That is my reading.
Is it silent in the administrative rules and in federal law?
That would be a question for the department and those speaking after me. However, my interest today, my motive to bring this bill forward is to clarify it in the state statutes.
Thank you. Further questions? Yes, Representative Nelson.
Thank you, Mr. Chairman. Thank you for taking my question. You emphasize invite over a notice. Why would you do that?
Thank you for the question. Very good question. Because there's a big distinction. An invitation, which is in current law for that first meeting, means the chartered school team is invited to attend that first meeting. But we're looking for notice thereafter, not necessarily an invitation. And there could be reasons for that. It's possible a parent doesn't choose to have the chartered school at the team meeting. So thus they wouldn't want an invitation. We wouldn't want to force that on the parents. So we're looking for the minimum of notice to be given to the chartered school, with all due respect to those that are on the IEP team, including parents, resident district, teachers, etc. Huge distinction, and I'm glad you brought that up so I could reemphasize that again today.
Well, thank you very much. What I'd like to do now is, if there's no more questions for the sponsor of the bill, I'd like to invite, as I mentioned earlier, Nate Green and company that are with him regarding the charter schools as they're are administered through the Department of Education. If we have questions for them regarding this bill and perhaps what's coming up, they will be around so we can follow up questions, but they're going to try to give a little view of how the charter schools function. So thank you for Representative Mooney, and we're going to invite up now Nate Green.
Thank you very much. Just give
Yep.
me a moment. I'm going to wipe this down per the note on the table.
Oh, okay. I guess I've never read the note.
Just have to remember to turn it on. Good morning.
Good morning.
For the record, my name is Dr. Nate Green. I am the Bureau Administrator for the Bureau of Educational Opportunities with the Department of Education. With me is Tal Baer. Tal works within my bureau and is the administrator over the Office of Chartered Public Schools. We're here, and as the chairman mentioned, we'll be here for a majority of the day to provide technical assistance across a variety of charter school bills that are here today. But I want to turn it over to Tal to just provide a little bit of brief background on the current charter school system within our state.
Good morning. Just real quick to give you a quick summary. Currently, we have 31 charter schools across the state of New Hampshire. Of those 31, 28 are currently open, with 3 slated for opening in fall of this year. In the pipeline for additional schools, we have 10 prospective schools that have filed letters of intent, and they are all at different stages of the process for charter authorization. Charter enrollment is currently at 5,020 for this year, which is approximately a 10% increase over charter enrollment from last year. I would add probably regarding the charter school grant, we have 7 schools that were awarded the charter school grant in the first round, which occurred in August. 4 of those were startups, and then the remaining 3 were replication and or expansion. Thank you.
I know that several of the bills that have been proposed today are bills that make small alterations or provide some additional technical aspects to current law already. Some of this has helped to fix some of the problems that we've seen within our current charter school system, and we're happy to take any questions that the committee has.
Yes, Representative Cornell.
Thank you. Thank you for taking my question. I was just wondering, do you know how many students within the 5,020 are students with disabilities or on an IEP? Do you have the number for that?
I don't have that information now.
No, not offhand, but we can
Okay.
provide that information to the committee.
I was just wondering how many
Yep.
students this bill would affect.
As a percentage,
Yeah.
sure, or total. Yeah, we can get that information.
Okay,
Yep.
thank you very much.
Further
you.
questions, Representative Woodcock.
Thank you, Chairman Ladd. Good morning, gentlemen. Thank you for taking the question. You said there's about a 10% increase in the charter school population this year over last year. Can you give us a ballpark what grade level that you saw most of it in?
I don't have a breakdown by grade level, but I can certainly pull that information.
Thank you so much.
Further information. I had one question and maybe you all don't have that, or maybe I should go to special ed folks to do that. But we on this particular bill, we've heard that it is silent on how we address or notify on subsequent IEP meetings. Is it silent just in statute, or is there administrative rule which explains the process and that we have to follow in the schools.
I do know that Becky is here from the department, from the Bureau of Special Education.
Okay.
And
more.
so she should be able to answer questions that are specific to the federal part of the special education law.
Okay, we'll hold that question for Becky then. Are there other, yes, Representative Mullen?
Thank you, Mr. Chair, and thank you for taking my question. Tal, do you receive complaints from parents in your role?
In my role, I do not.
Okay, so would either of you have any sense of how many families have raised this as an issue?
That's something that we can get information on for the committee. We do have a particular individual at the department that handles special education related complaints. I'm not sure if they track whether the student is a charter school or a traditional public school in particular, but we could take a look and see if we have breakdowns of those numbers.
Can I?
Yes, follow up?
Yes, thank you, Mr. Chair. And also, is there anything, I don't believe there's anything in statute that would prevent a parent from inviting a member of charter school staff to attend a meeting at the home district. Is that correct?
To my understanding, the parent is the one that has the ultimate control over IEP meetings, who's attending, the makeup of that meeting within what's allowed by current federal regulation. I will obviously defer to Becky on the exact specifics of that, but I do know that the parent ultimately has the most control when it comes to the makeup of the IEP team.
Thank you.
Thank you. And we'll get Rebecca up here in due course. Are there further questions? Thank you very much. And just hang loose a little bit. Maybe I'll be back up there.
Sounds great. Thank you.
Thank you. I'd like to invite next Jane Bergeron from the New Hampshire Association of Special Education Administrators. For that we do from them as the technical support. They are, let's see, we'll put them right on Becky's card.
Good morning, everyone. My name is Jane Bergeron, and I am the Executive Director for the New Hampshire Association of Special Education Administrators. Thank you for the opportunity to testify before you this morning. My comments will be brief. As you will see in my testimony, and as you have already heard and know, the resident district is responsible for all aspects of the special education process, from referral to the funding to conducting of all meetings, which of course includes the Iep team meetings. As you all know, that when a meeting is held, the law requires that in writing that the Iep team be provided written notification 10 days prior to the meeting. And in my testimony, I've listed who the Iep team members need to be by law. And that includes the special ed teacher, the general ed teacher, the parent, the LEA rep, as well as any other individual that has knowledge or expertise of the child. And so all of those folks get notice of any Iep team meeting, whether it's initial one or subsequent meetings. And our school districts are responsible for notifying those folks, which includes the charter school. Therefore, we feel as though this bill is really not necessary. It really duplicates something that's already required in state and federal law. So we find it to be unnecessary. We're here to oppose the bill and would open it up to any questions. The other thing I would add is we're not aware that this is a challenge, and we would ask the question, what kind of data exists that would say that there's been a pattern or trend that would warrant some kind of new bill, and also would note that the Department of Ed does monitor local school districts on a regular basis when it comes to special education in a variety of ways, and that includes those students with IEPs enrolled in charter schools. So I would open it up to any questions that you might have.
Thank you very much, Jane. Question, yes, Representative Lakis.
Yes, thank you. I noticed that on the thing that you handed out, it says, additionally, any other individuals who have special knowledge and expertise can be invited. And I think the bill is about making it shall be notified, so as opposed to just can be.
Well, and that's the language from federal and state law. And, you know, the parent can invite anyone that they want, and the general ed teacher typically is the teacher at the charter school. So they would naturally get an invite because they are responsible for the vast majority of the instruction for the student.
Thank you.
You're
I believe
welcome.
that's in in law. Further questions? Not seeing any. Thank you very much.
Thank you.
I'd like to have next Kim LaValle from Mount Vernon.
Thank you, Mr. Chairman, for the opportunity to speak. My name is Kim LaValle, and my background that brings me here to testify on this is I've opened 2 charter schools. I'm a co-founder for 2 New Hampshire charter schools. I'm working on several other charter schools, and I also chair the New Hampshire Charter School Foundation, which is a nonprofit with volunteers to support charter schools in the charter application writing or their startup to help them avoid some of the challenges that happen when you're doing a brand new startup. I've also had 2 of my own boys graduate from a charter school, and 1 had an IEP. I speak in favor of this bill. We, at charter schools, I don't believe it's intentional from the resident districts, but there are notices that do not arrive for these meetings. Meetings are being held, the school is unaware, and it makes it challenging. The thing that we're trying to do is increase that communication, that dialogue. That's what will benefit the students. If everybody is talking on the same page, we're all doing the same thing for the student, it's going to benefit the child. So we're requesting that this please be changed. Do you have any questions?
Thank you. Are there any questions? Yes, Representative Mullen, and then
Thank you, Mr. Chair, and thank you so much for joining us this morning and taking my question. In these situations where you've had kids whose resident district has not notified you of an Iep team meeting, have you reached out to those school districts, and what has the response been to your initiating? Yes, I believe all the charter schools, when this happens, we reach out, and it's not intentional. It's not intentional. I don't believe there's ill will there. I think sometimes the charter school is it's an afterthought. So while the parents may have that opportunity to invite us, I don't think we should put the burden of that on the parents. I think the schools should be communicating. Thank you for the question.
further questions coming down. Representative Cordelli.
Thank you. Thank you for being here. We've heard testimony that if the child with an IEP is taking part in regular education at the charter school, federal law requires notice. If the child is not in the regular instruction program in the charter school, is that when the problem arises, or is it anytime there could be a problem in receiving notice?
I can speak for the regular ed, and again, that's where I see it happen. Notice is not arriving to the school. People find out about the meeting a week later when paperwork arrives with updates or something. So, and again, I don't think it's intentional, but I think putting it in writing is a good step in the right direction.
Follow-up questions? I have one for you. You've worked with the charter schools. You've had a youngster in a charter school with an IEP.
Mm-hmm.
When this failure to get notice of an IEP has occurred, has there been an effort on the part of the charter school or yourself to notify the Department of Education that what is supposed to be happening in accordance with federal law and I believe our administrative rules, which have gone through our JELCAR, is not occurring?
I have had conversations not to file formal complaints. Again, I don't think it's intentional, but just as a reminder that, you know, it works better if everybody's on the same page and communicating. As a mother, I did make some phone calls because I I had actually been left off of a notice, so, but it was an oversight, it was corrected. And we reach out to the school directly, typically the resident district, as a reminder, please don't forget us next time. We want to be a part of the team.
Thank you. Further questions? Thank you very much for your testimony.
Thank you for having me.
I'd like to invite Bob Best, Merrimack. We have a conscientious group today, all wiping it down, and on certain days we can go through the whole day and I don't ever see it wiped down.
We'll see what it's like at 3 o'clock.
Yeah, thank you.
Good morning, Mr. Chair, and thank you, members of the committee, for the opportunity to be here to talk about this bill. As to wiping down the desk, now that there's been an example that's been set and followed a few times, there's no way I could not do this. I will be sort of the bad guy in the group. So now we're all committed to it. So let me introduce myself. My name is Bob Best. I am from Merrimack, and I am an attorney at Sullivan and Hollis. I have an orange badge on because I do lobbying for other entities, but I'm not here lobbying for anybody here today. I'm speaking on behalf of myself and my own experiences. I am on the board of 2 charter schools. I provide legal counsel to 4 or 5 others. I've been involved in this issue quite a lot. The idea of notice and what federal law requires versus what this bill will do is an important question to ask. I believe the language in federal law says that the regular education teacher may be invited. I don't know that it requires that that person be invited. They should be. It certainly is a member of the Iep team. And it's critical for the person who's spending the most time every day with a student to be a part of that Iep meeting. But they're frequently not invited. I share Ms. LaValle's view that it's not intentional, that it's an oversight. What happens with charter schools is that they're located in one town and have a lot of students from that town, but then they bring in students from up to 20 other towns around them sometimes. And some of those districts around them could be a little bit far, and they have 1 or 2 students total, and the frequency with which they have a special ed student is less frequent, and it's just sort of not an open line of communication that works very well. But it is absolutely critical that the charter school be a part of that for the reason I mentioned. They're the one that spends most time with the kiddo. But also, as a parent, my oldest son had an IEP. When you have a failure in an Iep team meeting, you've scheduled it a month out, so school starts in September. Sometime in the middle of October, you have your first Iep meeting, and it's a very busy time. And if that meeting fails to have the right people at it, and you say, well, I'd like to have another meeting with all the right people at it, they try to schedule it for mid-November around Thanksgiving, and then it gets disrupted, and sometimes it happens in December or January. And but by the time you get anything going, half the school year's gone. Half the school year's gone. You're thrown off by at least a month, probably more like 2, if you've got to try to reschedule an Iep team meeting, knowing how busy the school districts are. And it's also important to note that what the bill asks here is such a tiny courtesy, an email. There's a meeting scheduled on January 6th at 10 a.m. for Bob Best's son. How difficult is that to do? And if it's the viewpoint of school districts that it's already required to be done, well, then what in the world would be a reason to object to having it here in state law? Now, what that does do is it does allow our own State Department of Education to be involved in it. Finding solutions for IEPs that go wrong under federal law is a very complicated thing for parents to navigate, and it's always the parent that's in the role to do that. They've got to ask for a hearing, they've got to make the complaint and that sort of thing. And even suggesting that it's up to the parent to decide who to invite to their team meeting, boy, that's a bit of a stretch. As a parent, I wasn't on charter school boards when my son was going through high school. It's an anxious moment to go to an IEP team meeting. You don't really know what's going on. The federal IEP system is Byzantine. It's complicated. You really don't know a lot. You kind of expect all the teachers to be there, and then when they're not, you're confused. And somebody says, well, there was somebody in a substitute, and we couldn't find somebody, so we gave you the science teacher instead of the English teacher. But But to expect the parent to sort of have the wherewithal to know that they're the one that's going to be responsible for letting the charter school know or making sure they're invited, well, that's a lot to ask, and it's just unnecessary. Why not just have the people who are already scheduling a meeting, already sending out notices to a whole bunch of people, add one email to the list that says January 6th at 10 a.m., come on over. That's all the testimony that I have. I hope that answers the questions. It does happen quite a lot. I've been involved on behalf of clients that have had this issue with some of the sending school districts. I know that I have had some letters on behalf of clients that have been sent to the state board about special ed issues. I don't recall off the top of my head whether this particular one was among them. I don't think that those letters for the whatever subjects they were sent for caused any particular response or improvement.
Thank you. Questions, Representative Luno?
Thank you very much, Mr. Chair, and thank you, Attorney Best, for joining us this morning. Just to clarify, your testimony, I think, was very helpful. The bill before us right now, I don't think has anything to do with addressing scheduling anomalies or notification of parents. It's specifically about notification to the charter school when an Iep meeting has been scheduled. And I was wondering, certainly given your familiarity with this area of law, when you take a look at 194B:11 Roman 3B, which is in our new books, is on page 594. It's exactly what's in the bill here. When a child is enrolled by a parent in a chartered public school, the local education agency of the child's resident district shall convene a meeting of the individualized educational program team and shall invite a representative of the chartered public school to that meeting. In your interpretation, does that only apply to the first meeting at the beginning when a child is enrolled by a parent in a chartered public school? Or does that first sentence, when a child is enrolled by a parent in a chartered public school, apply to the entire period of time the child is enrolled by a parent in a chartered public school?
That's a great question, and thank you for it. Your initial comment about the bill not addressing scheduling anomalies, though, I want to just comment quickly on that. When the charter school doesn't get an invitation and isn't present, the Iep Team Meeting isn't as productive and and that's what creates the anomaly that has to get rescheduled. So it does sort of create these anomalies. I would have thought common sense and courtesy would have resolved this kind of a question easily enough, or even just a reminder once in a while, easily enough. Why wouldn't you want to know from the teacher that is spending the most time with the student what's going on and what's going to change and all of that? Now, the outcome of an Iep Team Meeting is that the IEP may be amended, and that needs to be immediately known by the people that are going to spend their time with their kids. And so that's what the importance of it is. I would have loved to come here and say that this bill is unnecessary, that this language that's in here that talks about an invitation to the initial meeting implies that everybody should be invited to all the meetings. But unfortunately, that's not the case. I don't know what the interpretation is by the school districts. I don't know whether they've gotten some legal advice that says to do one thing or another, or like I mentioned earlier and Ms. LaValle had mentioned, whether it's just simply inadvertent. But it's important, it's critical to the student that the Iep Team Meeting be there. So why don't we just close the loop on some unclear language and reinforce it? And then at a minimum, the charter school and the parent has RSA 194B:11 3B to show to the school district to say, you should have done this and you didn't do it.
Quick follow-up, Mr. Chair. So no, and I understand that, and I question whether or not putting another thing into law that's already in law somehow makes it stronger or more legal than it or more required than it was before. But do you think maybe something like a technical advisory coming from the department to school districts might and to charter schools might help to maybe put a little bit more light on on this than maybe
Yep.
injecting another sentence into law that's
Yep.
already there.
That's a great comment. So as an attorney, I am keenly aware of redundancies in laws and how you wonder why in the world do we need to do this again when it's already somewhere else. Wherever it is today, it's not effective. Now, would a technical advisory work? I think it would for a while. I think when it immediately arrived, it'd be on everybody's attention span. But some technical advisories and technical bulletins that come out of agencies are around for years and years and years, sometimes decades before they're updated. And they're just not on everybody's attention anymore because they're not searchable. There's not a database. They're not an RSA. It's somewhere on a website. And sometimes for some state agencies, you find things that look like they were photocopied a dozen times over and originally typed on a typewriter as a technical bulletin, and nobody even knows what it means anymore or that it exists. And so when you pull it out and you show it to somebody, they say, well, that's a different time and a different circumstance, and I'm not even sure what that means. And that's one of the reasons why, for it to be absolutely clear, and it's really a simple concept to make clear, in the statute that's published, everybody can search it online, it doesn't get lost, it doesn't get forgotten over time.
Great, thank you very much, Attorney Best. And Mr. Chair, I've got to excuse myself to be in a subcommittee upstairs in Commerce. Fine. Great, thank you.
Representative Porter?
Thank you, Mr. Chair, and thank you, sir, for taking my question. Having taught in an elementary school for a long time, having many children who had IEPs, and I was the classroom teacher, when the IEP meeting is scheduled, it always created a conflict in my classroom schedule. Who's going to cover my class? Will it be during my planning period? Will it be during lunchtime? Is it before school? Is it after school? If the teacher that provides the most service to the kids can't be present, does that mean that the meeting has to be rescheduled? I have a follow-up on this too.
Sure. I think that the parents' role in determining the IEP team's construct and whether they were able to meet with the correct number of people or the right individuals makes all the difference in the world in that. I don't think that it's a hard and fast rule, but I do sympathize with what you're saying, and I didn't sort of offer it as part of my introduction, but my wife is the special education coordinator for the Merrimack School District for a couple of other elementary schools, and she arranges those meetings and sends out all those notices and does exactly what you're talking about to find the substitutes for the teachers to get there. So I absolutely understand that circumstance and how challenging it is.
So I have a follow-up.
Yes, go ahead.
So if I'm a teacher at a charter school that's 4 or 5 towns away, and an IEP meeting is called, and I can't have anybody that's covering my group of children for the time it takes to get there, attend the meeting, and come back, could be half a day or more. Will that, if this is in place, this language is in place, will that invalidate the meeting? Will the meeting need to be rescheduled? You understand where I'm getting at this? If it's, it's not, she's not right there in the building. She's 30 miles away on the other side of the mountain. How, and she can't get there. What happens then?
Sure, absolutely. I think today when you have the IEP meeting without this change in law, if the parent thinks that the right people weren't at the IEP meeting, the parent can pursue that kind of remedy, and that doesn't change by this bill in any other way. But what this notice does in a positive way is 2 things. Even if the school teacher can't come, it's possible that they can provide information, provide an update, provide some communication, make a phone call, send a report, do that kind of thing. Or if that's not possible to do or not wanted by the parent or not necessary for the team, at least the school district, the charter school knows to be alert to a potential change in an IEP. Even if I couldn't go to the meeting or wasn't invited or the parent didn't want me on the team, at least I know to be on the lookout that something might have changed in the IEP that I need to be aware of as a part of the team. So it accomplishes a lot, even if it doesn't always guarantee every single person, has their bottom in a seat at the IEP meeting.
Thank you. Are there further questions, Representative Tanner?
Thank you for taking my question. You mentioned, and I just want some clarity, you mentioned that you had many, I believe was the word you used, had to do many letters and complaints on IEP meetings. And I was just wondering, out of that many, how many are specific? Were you talking just specifically charters, or were you including the other IEP complaints to the regular school district? That
Sure,
you might have
absolutely.
dealt with?
Let me clarify that as best I can. I have represented charter schools and had this issue come up many times. The actual letters that I've written to charter schools are not, it's a handful. The letters to the department are a couple. It's not many times that I've, complained to the department, but the issue comes up quite a lot. And also, maybe it's helpful for the discussion, and a question that came up earlier is sort of what percentage of charter school students are on IEPs. And it varies from each charter school to charter school, but it usually sits somewhere in that 10 to 20% range. Sometimes as high as 25% of the students have IEPs. So it's a lot. It's a good number.
Could I have one follow-up on that? Could you quantify just a little bit more than many or several, like in a given, let's say last year, how many complaints you had?
Yeah, sure. So in one charter school in particular, I can recall there were at least 2 or 3 school districts that each had between 1 and 3 students for this charter school where notices weren't provided for the whole block. If it happens for one, it sort of happens kind of across the board because the communication link is somehow broken down. So, for example, if a charter school has a relationship with town A that has 3 students in them, they'll miss the notice on all 3 students for that. So, could I tell you that overall through the whole state it's 25 or 28 or whatever? No, I don't really have that kind of data available to me. At the same time, for such a simple fix, 1 is kind of too many, isn't it?
Thank you.
Thank you very much. Yes, Representative Nelson.
Thank you, Mr. Chairman. Thank you for taking my question. It was mentioned earlier that if a parent decides who they want at the meeting, say, I'm going to give you an example. There's somebody, I'm a former special ed teacher, and I believe that the parent wants an aid for the student. I, as a teacher, special ed teacher, feel that that's not right. They don't need the aid. You're only enabling them. Can the parent eliminate me so I can't give my opinion?
Oh, gee, I don't know. I don't think they can necessarily stop the opinion coming forward by saying you can't come to the meeting, but honestly, I've never had to address that question. And this was a little bit implied in Representative Tanner's question as well. I don't do general special ed representation for school districts in traditional public schools. I don't represent parents and do that work regularly. My work is exclusively on the charter school side and representing the schools. So I've never had to cross that bridge. I don't know the answer.
If we have some specific questions that are relative to the department, because they're the next ones up here, maybe we can hold those questions. Representative Woodcock, can you hold that for Rebecca? Yes, Representative Mullen.
Thank you, Mr. Chair, and thank you, Attorney Best, for taking my question. So in the situations in which you've had the school district that has not been providing notice of the IEP meeting and you've gotten involved, what has the outcome of those situations been?
Usually those situations have had other faults as well, which were greater than the lack of notice. The school district not contracting to provide the services that are in the IEP with either the charter school or anybody else, or huge gaps in the scheduling. Sometimes students haven't gotten their special ed services started till October or November at the beginning of a school year. And so although you reach out to the school district and you try to improve things, and for the moment you might get a little bit of a response, that one particular issue has never sort of existed on its own, where it becomes kind of the center of the discussion. That one is sort of the small potato in the big scheme of things. So it tends to just get almost, it's sort of by the way, don't forget to give me notice, and that's kind of as far as you discuss that. So I can't say that I could give you a clean sense on if we ask them for A, we get B, what that's about. So.
Thank you very much. With that, I think we're going to thank you for giving testimony today, and we're going to invite Rebecca Fradette from the Department of Education, who is in charge of that special ed program. Thank you.
Thank you for the chance to be here, and I appreciate all the questions. I'm sorry that pushed me behind over the couple of minutes that I was actually hoping that
that's okay.
take from your morning.
Good morning.
Good morning, Chairman Ladd. Thank you for allowing me to speak today. My name is Rebecca Fradette. I'm the State Director of Special Education at the Department of Education. I first want to provide some background information on how special education works in charter schools in New Hampshire. We have a very unique situation for for the only state in the union that runs our charter schools the way that we do. Our charter schools are not, in special education, are not their own LEA. The LEA responsibility remains with the resident district, and that is why we're in this situation of cooperation between the resident district and the charter schools. Every law that we have and every law that is within IDEA bases the relationship for this process on the relationship between the LEA and the parent. And so everything that we discuss relates to how the LEA works with the parent to come to these agreements. The relationship is not with the charter school the way the laws are written. Not that they should not be involved, they should be involved, but if we are just looking at the basis of the law, everything is written to go between the LEA and the parent. So that's where I will speak from, because it kind of gives you a grounding of where we are when we look at these things. For an Iep team meeting, we follow federal law, and it's in our rules under 1103, and it gives you who the Iep participation members are, and any member of that team needs to be a person who is knowledgeable of the student. So if you're inviting people to the meeting, you might not necessarily invite the head of the charter school. They may not be knowledgeable of that student and that student's needs, but you should be inviting the regular education teacher who provides services to that student in the charter school. And the regular education teacher is a required member of that team. So that is one of the listed people within it. I'm just looking at my notes because I took notes as we were going along so I could address this. One of the other pieces that may cause confusion with this bill is that if we're using the terms prior notice, written prior notice is actually a defined term in IDEA, and that is the notice that the LEA gives to the parent to say what action they are proposing or refusing to provide for the student. So if we then use that language over here where we are providing prior notice to a charter school, I believe there's going to be confusion as to what a prior notice is. It's clearly defined in IDEA. It has been in IDEA for the entire time IDEA has been alive. So, and we provide trainings on what written prior notice is. This would deviate from what that definition says for written prior notice. The charter school should be invited. The charter school participants that are listed should be invited to that meeting, and they should be receiving notice as the regular education teacher for those meetings. I think. And then in regards to the memos and the technical assistance that Representative Tanner had done, we follow one of the Office of Special Education Programs practices with the federal government, where they put out memos or technical assistance, and they provide fact sheets that we are able to look up on their website. We follow that same practice. So there are fact sheets that are on our website. There are what we call memos that have information that clarify practices. We refer to them frequently when working with the field. If there has been something that we've needed to clarify, it is something that we refer to on the website and say, you can find it here. We will send people the link. I know that Natasha Lupiani, who works with many districts and parents, will also refer to many of those memos to provide that technical assistance that may be needed to clarify some of those rules. And that's a practice that we have taken from OSEP. And I would be happy to answer any questions that you may have.
So I have one question, and then we'll go Representative Bowman and others on the committee. So you say the LEA should be sending notice to these charter schools.
Yep.
Obviously, if it's going to be held at the charter school, you're going to have to have a schedule and a space available and a time that's appropriate. Has your office or any office over at the department received the concerns that we are not being invited to the IEP or the subsequent IEP? I'm looking at subsequent IEPs. I see all IEPs as an IEP.
Yep.
And so it shouldn't be a subsequent IEP. It's an IEP meeting, whether it's the first year annual or it's every 3 years you're in the neighborhood of doing that. But I'm really concerned that if, I would say, it's my guess, but I know of several districts where I live, they are doing this. So then maybe it's a best practice. I don't know, but I thought it was law and rule what action has the department taken? If you hear, is there communication trying to clarify the law with the directors of these LEAs, the special ed? Is there a corrective or improvement, letters sent out saying you need to get on and do this thing correctly? What's the DOE doing?
Sure. So we have gotten probably in the 2 years that I've been in my position, maybe 3 or 4 phone calls regarding not receiving notification on the part of the charter school. What we would do, I will go back to, again, the relationship is between the LEA and the parent. So a charter school cannot file a complaint with us regarding something that the LEA has not done. The parent can file a complaint, but the charter school cannot. So, but we would reach out to the district and remind them of their responsibility to invite the members of the team that are appropriate, which would be the regular education teacher at the charter school, and would clarify that role for them. They have no obligation to invite other members of the charter school because, as I stated, it's only members who have a knowledge of the student, unique to the student, and would be able to contribute to the meeting. So while the regular education teacher would be somebody that they're required to invite, the principal or head of the charter school would not be somebody that they're required to invite.
And I have just one follow-up question. When I was a school principal for all those years, when we had these IEP meetings, we would get substitutes for the teacher that had come into the meeting, or teachers, plural. Is the LEA responsible for providing the funds for a substitute at the charter school?
No.
No. That was quick. Okay, so going around, Representative Bohm, then Representative Tanner, and then Wood.
Thank you, Mr. Chairman. And I've been holding this question. In the case of a charter high school, which we have a few, who is the general education teacher that's going to be invited, or are all of them?
So typically what would be done in a public school is that you would invite all of them, but typically you would get one of them. So that would be the same case of all the teachers that they have at the charter public school. You may invite all of them, but usually it's, I'm not able to, can you? And then they figure out of those, or where does their disability impact the most within the classes that they are taking? If they have a specific learning disability in reading, you might want to ensure that the English teacher is the one that's invited rather than the science teacher. But there's no requirement to say that all of those teachers would need to be at the meeting.
That same issue occurs at the elementary schools as well.
Yep.
Middle school.
Yep.
Representative Tanner?
Thank you, and thank you for taking my question. The previous speaker mentioned that this bill allows our own New Hampshire Department of Education to get involved. And I was just wondering if that is how you see this bill, that this bill allows the New Hampshire Department of Education to become more involved in these notifications of IEP than currently exists under our own statutes and federal IDA laws.
Sure. So our involvement may change slightly from what it is because we would be reaching out and saying you are required to provide notice to someone at the charter school. But again, we go back to the relationship is between the LEA and the parent. So there would be no way for a charter school to file a complaint if they did not receive notice. It would have to fall upon the parent to again file that complaint to say the charter school was not invited to my meeting. So we may provide technical assistance like we do now and change the way we word what we're saying, but it really wouldn't change our ability to do anything different if we were to receive that complaint.
Yep.
And just to make clear in my own mind, so this bill doesn't make it any different with the charter school either, does it, as far as whether they're involved or not? It's still the LEA.
Yep.
Okay, thank you.
Representative Woodcock?
Thank you, Representative Ladd, and I appreciate your consideration. I have a couple as I've been waiting. Just off the top, and I assume you have the answer, do you know how many charter schools are high school focused?
I do not. I could give you special ed facts. I could not give you the charter school facts. I apologize.
Do we know that, Representative Ladd, how many actual charter schools have high school components?
I don't know, but, I would imagine that there's a number of kids there that go from middle school into that level, so that we can get that information.
Okay.
I'm sure that we
get that
can
for
get
you.
it from DOE.
So, but back to my original question.
Yeah.
Thank you.
Yeah.
Thank you for taking my question. In the law, or as we read it, and looking at the proposal on 1074, I just want to make sure my assumptions are correct.
Sure.
On line 5, which it doesn't matter if you don't have that, it just says they shall invite, and the initial, didn't say initial meeting, it says shall invite the representative. So my assumption is that if I get an invitation, it's an invitation to participate. But the law, in the second one, it says all subsequent meetings, as you said, there's no relationship with the active violation, actually.
Yeah.
Not a relationship with the charter, but it says that they would just provide a notice. So I'm assuming that a notice is different from a invite to participate.
If I were to look at the wording, because of the definition of written prior notice, I would say that it is something different. However, if we wanted to have them noticed of the meeting, the charter school representatives beyond the regular education teacher could be listed as another participant as appropriate. So you have these required members that are typically listed on your meeting notice, your regular education teacher, your special education, and then you also can say, we're also going to notify Sally, who has been providing some speech services, but she may not be able to make it, but the speech pathologist is here. So they could be listed as somebody else who is an other participant, but may not necessarily be at the meeting. But any participant has to have knowledge of the child to be participating in the meeting.
Okay, thank you. Just so clarity then. So you're saying then that if the charter school receives a notice,
Yep.
Either in this case maybe vis-a-vis the parent, but if it receives a notice, that means in your mind that's the same as an invitation to participate. It's not just after the fact, we're having a meeting in 2 weeks on student X. We're saying that's the notice. But what we're saying now is you're welcome to send a representative and participate.
If they were, yes, it would be an option to participate. It wouldn't be a requirement to participate. But if you added them to the meeting notice, it would give them that notice of, we're having this meeting, but it wouldn't require them if you listed them as a separate member.
Thank you, Chairman Ladd. Appreciate it.
Thank you very much. Representative Porter?
Thank you, Mr. Chair. Thank you for taking my question. I'm not sure you can answer it, but you mentioned at the very beginning of your testimony that New Hampshire is unique in how we handle special education and charter schools. Can you give me an example of how other states, what they do with this?
Sure. So most other states will make their charter schools their own LEA, and then that charter school is responsible for the provision of special education services.
Can I follow up?
Follow up?
So the charter school would be responsible for funding that as well?
Yes.
And do they get funding from the state to help them out?
Yes.
Or is it a tuition that they charge?
They get it from the state to help them out, but many of those states have income tax or have other means to be able to provide for those pieces.
Thank you.
Representative Ford?
I wonder if one of the aspects of this problem might be addressed if we inserted the word timely in front of notification in this, and when we're all talking about, to give the sense that time is of the essence.
Yep. So for a notification for a meeting, we must provide 10 days notice, so that is already within the language. If a charter school needed more than 10 days notice, it would be something else we would have to add in. But currently, any of those notices for meetings is a 10-day requirement from the date of the meeting. And typically, a district provides more than 10 days. They may provide 30 days, and some of them are reaching out to parents and trying to find that day that works, and it might be 3 weeks from now rather than 10 days from now. So.
Thank you. Thank you very much. Are there further questions? Yes, Representative Nelson.
Thank you, Mr. Chairman. Thank you. I'm a little bit off, but does the parent have a right not to have somebody come? The school district wants somebody to come to the meeting, and the parent says, I do not want them. Who's right?
So if it's one of
Right.
the required members, they would not be able to sit, like if it were the classroom teacher or the special education teacher, we have to have that at the meeting. If it were somebody else that does not have knowledge of the child and is not going to provide any information to the meeting that's supportive, then yes, they could say they don't want the person at the meeting.
Yes.
If it was another teacher in the school, not the classroom teacher, would they be counted as somebody that could come, or would the parents have veto power?
If the teacher works with the student and has knowledge of the child, they could participate in the meeting.
Thank you very much. Are there
President
further?
Ladd?
Yes.
Just has one quick one. Thank you. Thank you. Appreciate the. Thank you. Thank you. based on your information and the information you just gave us about notice and the IDE definitions, right, and the process you currently use, the way this bill is worded, do you see it as redundant and unnecessary, or do you see it as necessary?
I think that there's obviously a concern if this has been brought to this level where we need to discuss this, but I'm not, I had expressed my concern about using the language of prior notice. I think that there is the requirement for a regular education student who is a member of the charter, not student, excuse me, the regular education teacher who is a member of the charter school to be invited to that meeting. I think that clarifies that, and maybe some technical assistance might be needed, but I'm not sure that changing the language would necessarily change the outcome.
Okay. Thank you, Representative Mullin.
Thank you. Representative Mullen.
Thank you, Mr. Chair, and thank you, Rebecca, for taking my question. Has there been any discussion at the DOE about providing technical assistance to LEAs and/or charters about how to make this happen?
No, but there will be.
That was going to be my follow-up question, so thank you for jumping right on board.
Thank you very much. I think that's an excellent point. Further questions? Thank you very much.
Thank you.
And we have no more cards on that particular bill, so we're going to close this hearing and go into the next.
Mr. Chair,
Yes.
as of this morning, 4 people supporting this bill, 7 opposing, and 0 neutral.
Thank you very much. The gatekeeper, Representative Porter, and I appreciate her doing that for us. Okay, going on down to the next one, it's HB 1141, and relative to special education services for children in charter public schools. I'd like to welcome Representative Cordelli.
Thank you, Mr. Chairman and honorable colleagues. For the record, I am State Representative Glenn Cordelli, representing Tufton Borough, Moulton Borough, and Sandwich in the Beautiful Lakes region. HB 1141 is a resubmission of a bill 1636 from 2020. Legislative Services will tell you that there is no such thing as a placeholder bill, but this is a placeholder bill. I submitted this as a vehicle for amendment after work was completed at the end of October by the study committee for House Bill 581 in relation to special education. I have an amendment which replaces the entire bill. It also modifies some sections of the 2020 bill, but the amendment addresses several of the concerns that we heard in our study committee over the fall. I have copies of the amendment and would be available to talk about that at any time.
Thank you very much for your testimony. Other questions, Representative Porter?
Thank you. I just want a clarification, Mr. Chair. If the amendment is introduced and it's changing the entire bill, is there an opportunity for the public to comment and justify, or is this the only opportunity that the public would have to discuss this bill?
Well, if the amendment changes the whole nature of the bill and the title and germaneness, yes, we would have another hearing. I have not seen that amendment, so I can't tell you what's in it, and so I can't make that decision. But a bill that totally changes and goes to a different statutory reference, changes title, obviously it's going from nuts to bolts, then we would have a hearing.
If I might, Mr. Chairman, it does change the title and replaces everything after the enacting clause.
Okay, so the chances are we could. I'd have to read it. I can't, but it's not an early bill, so there's lots of time to do that. Yes, Representative Tanner.
Is there any reason we're not seeing that right now, if it's available?
I think he was just saying there is an amendment, he's giving us information. He did not go into any specifics about that amendment, knowing that he's been advised, and we've all been advised not to do that. So it will be made available to us, and we'll like I just said, Representative Porter, we'll look at it and see where we go next.
Mr. Chairman, when we finish, should I hand out copies of that amendment to the committee?
Yeah, the amendment, of course, will be introduced by this committee at another time. It's just information being provided to us. So, yes, there's no harm in information coming to us rather than waiting for an executive session. Oh, by the way, I've got this amendment. I think it's wise to do it now. Yes, Representative Woodcock.
So for clarity, Representative Ladd or Representative Cordelli, the amendment we may see in a few minutes, that we can't talk about today, but we'll talk about in the future, is going to totally change this.
Correct.
So it's probably not valuable to waste our time discussing this. Would you say that?
Correct.
Thank you. Do you agree with that, Representative Ladd?
Well, I believe we have a bill in front of us right now, and there may be those, I haven't looked to see what we got for pink cards. It looks like there's some there. So we have in front of us, not that amendment, we have this bill. So we'll continue having the hearing on this bill, but we won't be discussing that amendment at all.
Thank you.
Representative Porter?
Thank you, Mr. Chair. And this does, I think, fall under the purview of the bill we're looking at, and it's something that I've wondered about, and perhaps Representative Cordelli can answer my question on. If at an IEP meeting it is determined that a youngster who's going to a charter school needs a one-on-one assistance in the classroom, who, under the current law or under your bill, who is responsible for hiring that assistant? Who is responsible for paying that assistant? Who is responsible for the benefits allotted to that assistant, and who would be responsible for firing that assistant if there was a problem?
Thank you for the question. My understanding is that the resident school district is responsible for services for that child in the charter school, and therefore would be responsible for the aid.
Go ahead.
Oftentimes, in a public school, the one-on-one assistants will take other responsibilities on when she's not or he's not with the child that needs her assistance right away. So in other words, a lot of the paraprofessionals that were in my school would be with their child when they needed to be with them in the classroom, but when that child did not need them, that para would go and do a lunch duty or a recess duty or go to the library and watch the kids while the teacher had a break, that sort of thing. Would the paraprofessional that the sending district is paying for be doing those kinds of roles at the charter school, do you suppose?
Can I say,
It's
plead
really
that I
jumping
don't
off
want to
the topic a
suppose?
little bit here, but the LEA is totally responsible for that. That which is the sending, the district where the special ed person, is coming from. Paris coming from.
I do
Like-
think,
Go ahead.
I'm sorry. I do think it speaks to the relationship between the resident district and the charter school and the communication that is required.
Management of personnel, supervision of personnel, all that comes into play. Further discussion from, yes, Representative Mullen.
Thank you, Mr. Chair, and welcome back, Representative Cordelli. So as I read through this bill, I kept writing, isn't this already law? And I wrote that with regards to the LEA being responsible for services, the written consent, the least restrictive environment, and the involvement of parents as full team members. I wrote, isn't this already law, next to each one of those things. So I guess my question is, isn't this already law?
Thank you for the question. The bill in 2020 was introduced because of discussions I had with parents, or maybe they had with me, in relation to problems they encountered with having their special needs child at a charter school, and break down in various areas of that provision of services. So that's why I introduced the bill and tried not to dictate any one thing in terms of where the services were to be provided or anything like that, but keep it general, just to provide some direction for, in particular, the parents, so they knew also special ed law is quite complicated, as we have heard, and based on the questioning by this committee, whenever there is something of a bill with relation to special education. So I was trying to keep it generic, but provide some direction, especially for the parents, as to how that relationship should work within the charter school, resident school district relationship.
Go ahead.
So for my own clarity, Representative, I hear you, and I think we've heard that there are problems and people are trying to solve them in a variety of different ways. But my question is, the points that are raised in the bill, are they not already part of federal and state special education law?
I believe they are in federal law, yes.
Representative Lakis.
Yes, one of the emails we got on this bill from a charter school person was wondering about the shall be full participants on, that the parents shall be full participants on the IEP team. And their question was, what if the parents don't want to participate in this? Currently, they can still go ahead and currently they do in the LEA go ahead and have a meeting just without the parents so that the kid can get whatever help they need. And would this, by saying full participants, it seems to imply that the parents would have to be there, and what if the parents aren't willing?
I think that is addressed in federal law in that, as you said, there are provisions in law for a parent not being at a meeting, and there are requirements as to what happens when that situation arises in terms of notification. If the parent doesn't show up, there has to be documented all the attempts to contact that parent, for instance. So I think that there are provisions to address that in law that I didn't feel necessary to go into in this.
Thank you.
Thank you very much. Not seeing any further hands right here for the representative. Thank you very much, Representative Cordelli. We do have some other folks. We've already heard from the department, and then we also have Jane Bergeron from the New Hampshire Association of School Administrators. Welcome, Jane, again. Representative Cornell.
Thank you. This isn't even the bill we're going to be discussing, though, when it comes time to.
Well, that's debatable. That the amendment's not even on the table. We'd have probably a different hearing if it's totally changed. So we have a bill in front of us.
Okay.
And we own that bill now.
Okay.
And so we have the courtesy of providing all that input.
Thank you.
Thank you very much. Welcome.
Thank you very much. My name is Jane Bergeron, and I'm the Executive Director of the New Hampshire Association of Special Education Administrators. I won't take a lot of your time. I'm here to represent over 270 members within our association when we are in opposition of the bill. And I'm providing you with my testimony, but much of it you've already heard this morning. As you know, the resident school district is responsible for the provision of a FAPE for all students with disabilities. That includes those who are enrolled in New Hampshire's public charter schools. We feel as though this bill as written is duplicative of what is already required of school districts in regards to providing a FAPE as well as as mentioned, the issue of parental consent, which is required and necessary that the parent be a part of all aspects of the child's IEP development and the process. And would again raise the question, has there been any kinds of identification of noncompliance around the lack of provision of FAPE for students who are enrolled in public charter schools, and that IEPs are being amended without the consent of parents? It's not something that we're aware of. It's not something that the Department of Ed has made us aware of. And we check with them regularly in terms of things that we should be aware of, and working with our charter schools to change. So I would take any questions that you might have.
Thank you very much. Are there questions of Jane Bergeron? Not seeing any. Thank you very much.
Thank you.
Do we have any other cards on this one? That's Jane. Does the department have anything to add? You have a card in on 1141. Are there any questions? Yes, we do have a question for you, Rebecca. Yeah, she's got one in. Okay, thank you very much for visiting us again. Representative Woodcock.
Thank you. Representative Mullen and I had similar questions. We just had highlighted different, one in pen and one in pencil. The law that's proposed here, do you have a copy of that?
Yes, I do.
Okay. So I'm looking at the section of line 13 and the particular section line 9 through 23, which addresses the question of parental consent and parental participation. So can you tell me if those two attributes of this law are currently in effect in New Hampshire?
Yes, they are.
They are, okay. So can I follow up?
Yes.
So based on the information currently provided and the attempt to change, is it your position, or what is your position, is this bill necessary or is it redundant?
Anything that is within the bill currently is something that is already currently within law. It may need clarification. Obviously, there's some concerns, but it is already currently in law.
So your position is it's necessary or it's redundant?
I don't take it. I'm neutral.
She does not take a position on her pink card.
Yeah,
The
I do not
department's
take-
here for
I'm neutral.
information.
Oh, I get that information. Thank you.
You're welcome.
You read between the lines and figure that one out. I have one question for the department, and it'd be a quick one. A number of years ago, the representative sitting right directly behind you to your left and I sat on a committee over at the School Boards Association in that building dealing with special ed services to charter schools. And that went on for numerous meetings. Least restrictive environment was always a hot topic, especially with charter schools. Least restrictive environment can be interpreted, you're going to serve me in my school, which would be the charter school. And of course, statutory law says, no, we don't have to do that. We can have that service delivered back in the sending or in the LEA. Have you had any issues with least restrictive environments, language being used with charter schools, or everything seemed copacetic?
So for charter schools, because they are not an LEA, we do not currently approve special education programs within charter schools. So anything that is provided within a charter school is considered regular education. If you needed a special education environment, you would need to go back to the public school to obtain services within a special education environment, unless somebody is sent to the charter school to provide those services. But a charter school does not have any special education programs per se, so they would not have any.
I understand, so I don't think you're really hitting on what I'm asking. Child needs speech pathology, and there's a similar class back in where that individual comes from, where there may be 4 or 5 kids can get together, and this youngster over there would benefit from that group. However, there's also the opportunity to send a speech pathologist to the charter school, which does happen. Are we encountering any issues with how we're interpreting least restrictive environment?
So least restrictive environment only applies to those programs that I had discussed. As to the issue that you're addressing, I know that there are issues with staffing, and so there are many times currently that they cannot get somebody out to the charter school to provide a service, and then they would need to have the child come to the public school, the regular public school, to get those services. But that wouldn't relate, as we calculate LRE, that wouldn't be within our calculation of LRE. Am I making sense? Is that clear, or
LR,
least restrictive environment?
least
I'm sorry,
restrictive.
I'm talking alphabet
the
soup.
jargon, I understand least restrictive environment, and, I dealt with that. Thank you for your information. It's a hot topic. I don't think we're going to have a resolution here today on that. Further discussion from the committee? Yes, Representative Lakis.
Following on a previous question, when you say that it's in law, is it in state law or federal law or where?
Both. Its different parts are in different, I mean, I could kind of quote all of them for you if you wanted to, but they're all in different places.
Thank you.
Yep.
Thank you very much. Yes, Representative Wells.
I just have a question. Are there rulings by federal government like OCR or by the courts defining, addressing this issue about least restrictive environment in charter schools?
So we go back to New Hampshire is what OSEP referred to as a unicorn in how we address charter schools. So we do not address charter schools the same way. LRE is calculated the same way in other states for charter schools because they are the LEA responsible for special education. Because we do not have the charter school as an LEA for special education, we can't calculate LRE in the charter school. It's based off of approved programs within the state.
And are we the only state that does not recognize the charter school as an LEA?
Yes. As I understand it, yes.
Thank you very much. I don't see any further hands. And I don't see any other pink cards for this particular bill, so we're going to close 11:41.
Mr. Chair,
Yes.
at this time, 8 in support, 3 in opposition, 0 neutral.
Okay, we're going to enter into 1193 relative to charter public school fees and enrollment policies. Welcome, Representative Cordelli.
Thank you, Mr. Chairman and colleagues. For the record, I'm State Representative Glenn Cordelli, representing Tufton Borough, Moulton Borough, and Sandwich in the beautiful Lakes region. I've worked with the department and actually the two gentlemen from the department behind me on this legislation, which is based on some complaints the department had received in relation to what was going on in a few charter schools. And I want to emphasize that these are not broad complaints, but targeted complaints about a few things, a few issues that are going on. First, beginning on line 2, there was an issue with fees being charged by charter schools over and above the tuition provided to the charter school by the state. So we've added the language that any fee charged to the students shall not be a condition for enrollment. There was some concern about that the fees were making it difficult for the parent to afford to go to the charter school even. So that's why we thought it necessary to put this in statute. The second, it's a new subparagraph beginning on line 5, addresses really border charter schools where they can and do enroll out-of-state students into the charter school and actually can charge tuition to those out-of-state students. And there was an issue about whether the state enrollment for a charter school, what happens if they're accepting out-of-state charter school students who are paying tuition, and that's crowding out basically resident New Hampshire students from enrolling in that charter school. So that was the reason for this new subparagraph, and excuse me, specifying that preference in enrollment shall be given to in-state students to try and address that situation. And again, these are not broad-based issues that are happening within our charter school community, but more isolated incidents. But we felt that they needed to be addressed for the benefit of New Hampshire parents and students.
Are there any questions of Representative Cordite? Representative Ellison?
Thank you, Mr. Chair. Thanks for taking my question. Can you give us some examples of those non-application fees that were being charged that people contacted you about?
They contacted the department, and I do not recall in my conversations with the department whether any specific dollar amounts were discussed, but just that some felt it was a barrier in terms of attending that school.
Thank you.
Are there further questions? Yes, Representative Porter.
Thank you, Mr. Chair, and thank you, Representative, for taking this question. When my husband and I ran our little school, one of the extras that we offered to the kids was piano lessons. We had a woman who came in and taught kinder keys, and it was a wonderful program, and they enjoyed it very much. But it was also a little bit pricey. So in order to keep our rates down, we charged the parents a fee for having their kids take the piano lessons. Is that the kind of fee that you're talking about here, or is it some other kind of fee? I mean, are the fees that are being charged, are they for extras or add-ons, or are they part of the regular curriculum?
I think that might be better addressed to the department as they had discussions with the parents involved.
Further questions? Not. Representative Whitcomb.
Thank you. Thank you, Representative. Thank you, Representative Codielli. On the same sentence on the non-application fees, when you're talking about the term enrollment, it's not as a condition of enrollment. Is that enrollment? Are you talking about not as a condition of acceptance, or as a condition of maintaining enrollment?
I believe that the issue was fees that were expected when the child was applying to enroll in that charter school.
Okay, so that would be application enrollment, right? Okay, application fees. Okay, thank you, Representative.
You're welcome. Any further questions of Representative Cordelli? Not seeing any hands. Thank you very much. Do we have any other bills on pink cards on this bill? It doesn't look like we have.
Mr. Chair,
Yes.
Mr. Chair,
Yes.
I don't want to draw this out, but could we get some clarification from the department about what kind of fees we're talking about here? Because there seems to be some confusion about what fees we're dealing with.
Is there anybody in the department that could, you must have heard what Representative Ellison was addressing, that might have some pearls of wisdom for us?
Nate Green, New Hampshire Department of Education. I'll try to provide some pearls of wisdom for you. We do have a number of parent complaints that we've received over the past couple of years in regards to this issue. It is both fees that are charged as a condition of enrolling in the school that may be not titled an application fee, but are as such. And then there are fees that are ongoing that as the student comes back each year, there are fees that are expected as part of returning to the school, which we would look at as going beyond an application fee. For the most part, these fees tend to be listed under the category of things like supplies and curriculum materials. So it's money that's being provided to the school so that they can then provide art classes, textbooks, and supplies for carrying out the educational curriculum at the school. We've seen some of these fees be as high as $1,000.
Thank you.
Representative Tanner.
Thank you, and thank you for taking my question. I just, again, would like a little bit more detail quantifying a number. You said a number of, you've had a number over the past couple of years. Is it like tens, hundreds, 5?
I would say somewhere between a dozen and maybe 15.
Okay, thank you.
Thank you, Representative Woodcock.
Thank you, Representative Track. Thank you for taking my question, Mr. Green. Two, a question from before. Can you tell me approximately how many charter schools have high school divisions?
Sure. So of the approximately 30 charter schools we have in the state, about 15 of them have high school programs. So
Okay.
it's roughly half.
Okay, great. That I didn't have a clue on that one. Thank you. The second one, if I may, as regards this particular bill, I asked Representative Cordell the same question. I just want to make sure we're getting the same answer. Not that it wouldn't be the same answer. On line 4, when we talk about enrollment, is that enrollment? Do you have the other, Nate? Do you have it in front of you?
I do.
Thank you.
Yes.
Does that enrollment mean enrollment for admission or continuing enrollment?
For both.
Okay. All right.
Yep.
So, and one final one. So these fees that you, non-application fees, that's pretty clear. I can't have an additional fee to apply for the school. I understand that. But the fees that Representative Ellison was talking about, these non-fees that you mentioned, the supplies, the curriculum, the art fees, those pieces. So under this bill, none of those will be applicable. Is that correct?
So they wouldn't be applicable in terms of being a condition for enrollment. So we have some situations right now where we have charter schools that charge a fee for supplies and materials. As I mentioned, sometimes it runs as high as $800 or $1,000. In cases where students and families haven't been able to pay the fee, the charter schools have provided opportunities for parents to do community service to the school. But in particular, some of the complaints that we have received involve students that maybe come from single-parent homes where the parent isn't able to come to the school and donate that level of time in order to make up for the fee. And the way it's presented to the students and families is that they either have to provide the community service or they have to pay the fee in order to stay enrolled within the school. And that's what would be prevented by this particular language.
Thank you. Thank you, Representative Wyatt.
Thank you. Representative Cornell?
Thank you. Just one question. Do you know how many students come from out of state and attend our charter schools?
I don't off the top of my head, but that's something that we could take a look at and provide to the committee. One of the things that charter schools are able to do when they accept students from out of state is they're able to develop their own contractual relationships with the sending districts where the students are coming from out of state. And those districts or those families pay a tuition to the charter schools. Oftentimes it's a much larger amount of money than the state of New Hampshire is providing to the charter school for students. So it's an opportunity for charter schools to make money off of the students that they're enrolling in other states.
And if that student needs special education, who's the LEA?
The services would have to come from the sending district, which would be out of state.
Okay, thank you.
So I have a follow-up to that. We've had a lot of discussion on charter schools and where there's a number of applicants and the charter school can't house them all, there's a lottery. So if we have a student coming in from Maine that wants to go to a charter school or Massachusetts, and they're willing to pay this fee, are they displacing kids that are coming from a residence in New Hampshire in this lottery?
It's possible. So the way the lottery is set up right now, there isn't a preference for in-state versus out-of-state students. So if during the course of that lottery an out-of-state student was selected and an in-state student was not selected, that would be a case where the out-of-state student is displacing an in-state student. This particular language would provide preference within the lottery system itself so that out-of-state students would then fill slots that have not been filled by the lottery.
Wow. Okay, Representative Woodcock had his hand up first.
Thank you, and I
Representative
appreciate the lottery clarification in Representative Cordelli's bill is that the New Hampshire students should have first priority. If a charter school requires funding for supplies and curriculum, and they're a public charter school, I'm confused because in a public school, we can't charge for curriculum supplies. I understand field trips and the add-on stuff, but the fundamental piece, how is it that a charter school can charge a family for fundamental supplies when they're a public school?
I think this is something that we're trying to correct with this particular language. There are some instances where that may be appropriate. For example, in our traditional high schools, there are often times when a student wants to take an AP course where the cost of taking the AP exam that comes with the course is covered by the student and the family. But paying for the exam is not necessarily a condition of enrolling in the AP course. You can take the class for free without having to take the exam at the end. So there are things like that where we don't want to eliminate that with this particular language. We're just trying to eliminate instances where fees charged to students are directly related to a condition of enrollment in the school, which, as you said, these are public chartered schools. They should be free, open, and public to all students who want to enroll.
Thank you. Thank you, Representative Lyon.
You're welcome. Representative Tanner?
Thank you for taking my question. So does this apply to continued enrollment? So let's say an out-of-state student applies year one and is able to get in because there's room, but then by maybe year 2 or 3, now the charter school has a lot more applicants from in-state. Does that bump out that person, that student that's been in that charter school paying a yearly fee for those 3 years because they're now getting bumped out by in-state students?
At that point, they would not be bumped out. They would continue their enrollment in the school because they would not be part of the lottery. They're already a registered student.
Further questions? Not seeing any. Thank you very much.
Thank you.
Interesting topic. Yeah. Okay, we don't have anything else on that, so we're going to take a break and stretch because we have one more bill, I believe, before lunch, and that's the charter conversion school. So we can take a break here and start that back up around 11 o'clock.
Not many signed in any way in this bill. 0 support, 1 opposed, 0.
It is interesting.
Yeah, I just question the wisdom of getting involved with kids out of state when all of a sudden you have a pandemic come up and all everybody's shouting to get in the charter school, but they can't because we got the in-state kid in there.
Right.
Yeah. Hi, how you doing, Ken?
Good morning.
I face mask bill that you canceled for tomorrow.
Yeah.
Has it been rescheduled yet?
No, I haven't done that. We couldn't get Reps Hall. Labor had it.
I figure it's going to be a huge group.
Oh, we've been told. We've been told a huge, huge group. No, I had one of the reps right here say that my whole school district wants to come and talk on that thing. And that was Hobson. And so with that, we have to go. We couldn't go to finance. That's being used, that room. So we're chasing. I'll probably do that after we can get through this early bill crap. And
So it'll be a late bill.
it's a late bill. So it'll probably be in March, somewhere at the top part of March.
Because I've got the calls. What's going on?
Yeah,
Yeah,
it's-
I know it's
yeah.
canceled.
I
Well,
heard
it's just,
Social media's been blowing up over
Yeah.
it's
Conspiracy theories also.
Oh, really?
it's just been postponed because of safety and security issues and being able to house all the people. We couldn't do it.
Got the busiest committee.
Oh, we have 102 bills, that's right. Yeah.
Doing a hell of a job.
We got the conversion bill coming up next. Local district can spend, what, 80% on a kid? I think, I haven't seen that in law, but that rings my bell.
I'm glad of the changes because it makes it all, it was written to make it almost impossible.
Oh, yeah, that's the way it was written. You had to have the recommendation, the
Everybody
principal and
had to be in
superintendent,
favor, but two-thirds.
and then you had the 2/3 of the teachers had to approve it.
Teachers union would have to okay it.
Yeah, of course, that's gonna raise hell here with the committee, but, I'm just gonna be very brief. I'm gonna say this is what it does. It makes, look at Washington DC and how the charter schools are the dominant achievers down there.
And I think after Katrina, Louisiana went to all charter schools. Louisiana.
Oh, they did?
Yeah.
Really? I didn't know that.
I believe so. We're back, committee. Um, Thank you. We'll move on to our next bill, which is House Bill 1132, relative to the application for a charter conversion school. And I will recognize the prime sponsor, Chairman Ladd.
Thank you very much, Representative Cordelli and members of the Education Committee. For the record, my name is Rick Ladd. I come from Haverhill, New Hampshire, and representing that area of Grafton County. In introducing 1132, it's relative to the application for charter conversion schools. We have in the statute right now a law which enables charters to become charters by two different routes. One we've been talking about earlier is just there's a separate funding stream, and if you become a charter school, you apply through the State Board of Education, etc. The charter conversion school is one that can be done locally in your local school district. We've had one in the past here. I believe that's no longer in business. But what this bill does, it removes certain voting requirements that we currently have in the process of a public district deciding to move into the charter conversion school format. And it adds the requirement that you have to have a majority vote of the school district at a regular meeting to attain that status as a charter conversion school. In looking at the bill the way it is right now, there's a number of hurdles or hoops one has to cross before you can become a charter conversion school. The charter conversion school right now, of course, you have to have the vote of the school board to become a charter school, but now you also have to have several other hurdles which you must cross. One of which is you have to have a 2/3 vote of the teachers employed within the school district, and secondly, you must have the written approval of the superintendent and principal of the school. Right now, it's my opinion that by having the latter two requirements I spoke to right now are just basically saying we won't have any more charter conversion schools. That in order to get a 2/3 vote, that's like climbing a cliff that's straight up, and getting the written permission of the superintendent and the principal, which I feel oftentimes don't even live in the community. I think that's outmoded legislation in itself, especially when we have superintendents and principals that have a higher instance of moving from one district to another throughout the state, and probably the average tenure of a superintendent used to be about 5 years. It's probably even less than that right now, and we have 12 vacancies in the state at this current time. So what this does, it just rewrites the legislation and inserts into, you have to have a majority vote of a special meeting, of the annual meeting or at a special meeting, and that you have to have a warrant article that's passed by your community. This would enable a school district then to move down the route of having their public school turned into a charter public school. And we know that there's places in this country where charter public schools have shown better achievement results, i.e. Washington, D.C., where minority groups have had an opportunity to really develop and grow and expand their achievement, which that's demonstrated by various instruments which we assess, up at the NAEP and AEP, which is given, demonstrates that the proficiency levels in that particular city now with the charter schools is much higher than it was prior to that. So I will close my testimony because it's just that succinct, that it changes the format and the way of becoming a charter conversion school, which then the costs are borne by the school district. They still have the responsibility for funding the charter public conversion school, and it's controlled by that board itself, and the funding comes through their allocation at 80% so that they have monies to run the charter school. Thank you.
Thank you. Representative Porter saw your hand first.
Yeah, right. Got it right up there. Thank you, Representative Cordelli, and thank you, Representative Ladd. So I'm not really familiar with the rules that are working around conversion schools, but I understand that in charter schools, only 50% of the teachers need to be certified teachers. Is that accurate?
That's true of the charter public schools, the
Yes.
ones we've been talking about.
Yes.
The charter conversion school, it's also true of that.
Okay,
That-
so
that-
can I
answer your question? Yeah.
No, because I have a follow-up. So if a school decides, a school district under your bill decides to go to a charter conversion, which I'm not against a charter conversion. I think there might be some good things to it, but if that were voted in by the district, half the certified teachers in the district could be let go and replaced with uncertified teachers. Is that accurate?
It's a hypothetical, I believe, that I would think that to move in that direction, a school board would be looking at where they are. And I'm not familiar, I wasn't in this state when we had, I believe it was Pace, the charter school, which was a conversion. I don't know how that transition occurred initially. Perhaps there might be those that behind me that may have a better handle on that. I don't want to be subjective and not give you an answer on that. I just don't have the information.
Thank you.
Representative Ellison.
Thank you, Mr. Chair. Thank you for taking my question, Rick. I raised this before in previous discussions about this issue, and I guess I'm just getting back to it again, and it's a what if, since we don't have any current charter convergent schools. What would happen to labor agreements that had been agreed to and the school district and the school board had signed and had in place 3-year labor agreements with their teachers if, in fact, they then decided to go to a conversion school? Would those labor agreements still be in effect?
That's a technical question, and perhaps you might ask the department. They're available for this one as well.
Thank you.
Representative Tanner.
Thank you, and thank you for taking my question. Could you put in a statement or two of what the basic intent of this bill is?
Well, right now, that I believe that charter schools provide that option that's necessary for a lot of students. And we know that we've seen charter schools, if you want to call them conversions, whatever, down in DC, they work. And they're able to provide students what they need, the majority of students, what is necessary for them to grow and achieve. So I feel that it's an option we ought to have available. I know that we've had discussions whether people should be certified or non-certified, or whether, for example, like I always go back to career tech, but remember how we looked for alternative certification there, where it was based upon the history of the person working in a technical field before they, and they retired, and they were going to come in and offer that school some of their background information. Rather than having the PhD, it's just plain ordinary Mr. Brown or Mrs. Brown that has all that good technology and understanding. I believe that exists in public education too, that we have folks that come in that are not necessarily certified but are excellent, excellent teachers.
Yes.
So my question is, what is the intent of this bill by removing any input by the people that are running or involved in the particular school? Because a conversion charter school is actually where, let's say there's an elementary school in Bradford, New Hampshire, and that's part of the Kearsarge district, and they decide, well, let me take an easier one. Grantham has an elementary school. They aren't part of a co-op, and the town decides that they want a charter school and that they'd like to use the charter school that's the Grantham Elementary School. And so they put it on the warrant article. I assume that's when it's taken at the regular annual meeting, that would be a warrant article. And so what you're doing is, what's your intent of taking out
Teachers and
the input of the educators and the professionals at that particular school? What's the intent of that?
change is tough in education. We have a system that's entrenched, and some call it bureaucratic. I call it, it's just an entrenched system that's always last to seize and recognize often that change benefits all, and that we're in business not for the money I put in my pocket, but to help the students and provide them that choice of what's best for them. If, in fact, the community says, we're looking at this and we see this as a better option for our students, and we'd like to see what the charter conversion can provide versus the way we're doing it right now, I think it's up to the majority of voters in that town to make that decision. I do not think it's the job of an employee to make that decision. I don't think it's the job of the teacher or the principal to make that decision. This education system we have in America is for the students and the public, and therefore this is, to me, is a logical thing that would go to the regular meeting of the town or a special meeting to make that choice and that decision, and go on from where the decision's made.
Representative Mullen.
Thank you, Mr. Chair, and thank you, Representative Ladd, for taking my question. So when you make the comparison to the District of Columbia, you're talking about urban schools. This bill addresses what's going to happen in a district where or a town has a single public school, and they want to, for whatever reason, convert that school into a charter option. I don't object to choice, but if you have one public school in a town, what are the benefits of converting that school to a charter?
In your charter, you could write, for example, if we have a public library in that small town, you wouldn't have to duplicate that public library in that school. You could provide that resource without having to have somebody with that credential. You could have a public librarian that's had his expertise in the field. You could also have then the services that are provided to the students to achieve the academic areas provided by people that maybe aren't licensed. And I know there's a lot of people here that don't agree with that, but I feel that it's a viable option, and if the community deems that that's where we want to go, they ought to have the choice to do so.
Follow up.
So New Hampshire Public Schools representative are consistently high flyers. We score at the top of public education scales. Who's going to make this determination, and based on what, that somehow or another the needs of the students are not being met in a community that has one public school? And well, I'll leave it at that.
We've had a little discussion on that so far. We had a budget bill come in the other day dealing with performance outcomes. And we know the performance outcome in that district versus that district is not always the same. We also know that we like to boast in this state that our children are highly educated and rank always in the top 5 states in the country as far as achievement. Where's the bar placed, though? You know, when we look at our achievement scores in mathematics, if we're in the top 5, wow, that's a real concern to me. Whereas I know now the proficiency level is very, very low. That bar is a low bar. And when we have 48%, we used to have in mathematics achieving where we want them at proficient or higher, and now it's only 38%. I would say that if I were looking at my child being in education, I would say, wow, what can we do to improve this? And we've been on this steady, flat line or even a declining line for years. It's not all result of COVID or the pandemic. We don't seem to be making the gains that I'd like to see, and it's concerning. And I'm looking now is maybe the structure of how we function, the organization of how we function. You know, there's a lot of issues out there that I have always advocated that it's not going to be necessarily a dollar that nets achievement and growth. It's going to be the attitude of those teaching in that building or in that site. It's going to be the administration and supervision. It's going to be the aspiration of the community. It's going to be the involvement of parents. It's going to be the leadership and the expectation. There are a lot of issues come into play of achievement that you can't always gauge by a dollar bill. And I've seen schools that are very in poor areas. The achievement levels in some of those small K-8 schools is high. And what's the common denominator? Good teaching, good parent commitment and involvement, and on the list goes. All those tangibles that you have to measure a different way.
Representative Bohm.
Thank you, Mr. Chairman. Thank you for taking the question. wouldn't it also be in large town like Derry, even Hudson, where they have multiple public schools, multiple elementary schools, multiple middle schools? That would be more of what this could be for?
Charter schools provide options. You could have one in a town like that. I oftentimes look at the charter school in my neck of the woods, and it's the only one, but it's one of the finest charter schools you can, North Country Charter, which there's a high percentage of those youngsters which are special services within that facility. We all have a seat or so to go there from the various committed districts. The superintendents got together, and we put this thing together. There's a need for it. There may be a need for having a charter conversion school within a school district, and you could put that on the warrant, and you could, we've had those optional type schools located in many states. There were a number of them when I was up in Alaska and Anchorage, which we had schools which were highly oriented in sciences. There were some that were old-fashioned with their discipline, and that was part of their charter. I think there's a place for this in our society. I'm not saying it's good for everybody, but I think for us to get there, we're never going to get there if you have to have 2/3 vote of those which are employed in the building.
Representative Woodcock.
Thank you, Chairman Cordelli. Representative Ladd, good morning.
Good morning again.
Nice to see you in a formal way. Or I can ask you questions.
I hope this is a little informal, but.
Thank you. Just clarity, Rick, on line 3, it hasn't changed. It says an existing public school may vote by the school board. So that's step 1. And then it goes into the continuation using the school district and the warrant, those things. So,
Yes.
so it's actually a 2-part process.
It's a process,
Okay.
yes.
So the first part is it has to be the public school board of that school.
Correct.
Okay. So that's the first question. Thank you. The second one, you referenced multiple times the success of the charter school in Washington, D.C. Do you know if the funding level of the school in Washington, D.C. is similar to the funding level of the public schools in Washington, D.C.?
I don't know what their funding level is, but there again, it speaks to what I just said a few moments ago. I don't think it's always the dollar, and these charter conversion schools would be operating on less dollars than the current system within that community.
My thinking was perhaps the public school was funded at a much higher rate. So
Yeah.
that would be helpful to them. And the third thing, I just want to follow up on Representative Mullins' point, where she indicated the lack of the school folks in the decision, particularly in a single school system. And your response was, if I heard it right, that they could use the public library and they could use other things to help the academic resources. It sounds to me like what you're really saying is this is a dollar issue. This is a cost savings issue. You're outsourcing a lot of the services that our current school professional people provide.
That's a definite benefit. It is. It's a benefit. Anytime you can save $1, that's huge in terms of property taxes.
Okay. Thank you. I just want to make sure that was the intent of that. Thank you.
Representative Moffett.
Thank you, Mr. Chair. Would you believe, and then a follow-up if I may, would you believe that I once served on a school board in SAU 48, the biggest SAU in the state, 9 towns, and the superintendent wanted to have one of those towns, one of the schools problematical, convert to a charter school. That was from the superintendent. And of course, given the current law, it was daunting and almost impossible. Would you believe that occurred?
I believe anything you say, Representative Moffett.
Yes.
Okay,
Yes,
I heard some no's. Let's take a vote on it.
Representative Moffett is a follow-up to that, I'm sure, right?
Yes, so my follow-up to that is, as I read this proposed legislation, removes that 2/3 faculty requirement, as well as the superintendent and principal's requirement. And as I mentioned earlier, my superintendent wanted a charter conversion process. So my question is, if I read this correctly, is it correct that 51% of the voters in a district could bring about a conversion despite the opposition of faculty and administration?
The faculty and administration would no longer be part of this equation. It would just be the majority vote, as you're saying. And the recommendation that, existing public school may by a vote of the school board. So you have that as well. And then you have the process of that vote, and you have to have the warrant article.
Got it. Thank you.
You're welcome.
Representative Porter.
Thank you, Mr. Chair, and thank you, Representative. So, 3-part question. If a town that has one public school goes to a charter, who is responsible for the special ed program and how is that funded? Second part, what about the budget? Does the town still get to vote on the budget for the school district, or is there no longer a school district? It's a charter school, so what public oversight do we have of that? And three, would there still be a school board, or would it go to a board of directors that's not elected?
Those are all technical questions, and we do have the folks behind me with those technical answers. But yes, you will have special education services provided, because this is a dollar which still comes from the state of New Hampshire to the charter public school, conversion school.
Representative Cornell.
Thank you, and thank you for taking my question. I can't understand from reading this how this would work in Manchester, the largest SAU in New Hampshire.
You don't have to have all your schools as charter conversion schools. You
But
could have
if-
one. Maybe some of those elementaries that you have now could be turned over to a charter conversion
No.
school.
Follow up? My question is how it would go about happening, because we don't have annual meetings, warrants,
Or the
Governing
governing charter.
which the people on the charter have to be elected and have long meetings, and then the citizens vote on the charter, and,
I would suggest you move to Haverhill.
because this would not be able to happen in Manchester,
Representative Mullen.
which is the largest.
Thank you, Mr. Chair, and thank you, Representative, for taking my question. Have you given any thought to what the tenor of a school district would be in which the superintendent, the principal, and the teachers would be told that they are going to be employed in a conversion charter the following year without any input? Or have you given any thought to a mass exodus of teachers, or whether or not the superintendent and the principal are now out the door? Or I'm just trying to figure out in my head how this is going to play out in real life.
In real life, I'm sure that the community recognizes that Mrs. Smith, being a superlative teacher, would keep that superlative teacher in the charter conversion school.
Follow up?
But Mrs. Smith will have to give up the New Hampshire retirement system and the collective bargaining benefits that come with being employed in a public school. Is that not correct?
I can't answer that right now. We're getting now into retirement, and I have not looked into the retirement or aspect as far as when you get out after so many years, you get this. I would imagine that as a public school teacher, and if you're still certified, you're still working within a public institution, and you'd qualify for that retirement.
I'll
It
need
might be something
clarification on that, yeah.
There
Thank
are
you.
folks here.
Thank you.
Any further questions? Seeing none, thank you,
Thank you very
Representative
much.
Ladd.
It's always a thrill.
We all agree. Next, Jane Bergeron.
Thank you very much. My name is Jane Bergeron. I'm the Executive Director of the New Hampshire Association of Special Education Administrators, and I don't have written testimony, just a few questions so that I can better inform our members. I'm wondering if we can get a little bit of clarification in regards to how special education would work. It's my understanding that the resident district is the LEA. This would now be a charter school. Who would be the LEA for this charter school?
Really, this is really not the time to be asking. If you wanted to contact Representative Ladd and ask him, or maybe the representative from the department might have some input to that.
Okay, so I will just pose questions then, and I guess that would be one of them. And I would also ask the question, is this open enrollment? So I would use Manchester as an example. If one of the elementary schools decided that they were going to become a conversion charter school, could kids from other elementary schools leave that school and go there. So how does that all work when it comes to special education? I'm wondering if that's been thought through. The special education aspects brings forward a lot of questions, and I'm wondering if that's been a part of the thinking. And if there are any details around that that we can share with the fields.
This is just a public hearing. We're receiving your input, so thank you very much for those questions.
Thank you.
Were there any questions? I'm sorry. No.
Good morning, Nate Green, New Hampshire Department of Education. Happy to answer technical questions, of which I'm guessing there are a couple. Sure, yeah, I can try to hit the ones that I was trying to take some notes here and listen. So maybe I'll start with, I know there were some questions around unions and collective bargaining. So there is a section within charter law that governs collective bargaining and unions within charter schools themselves. And I'm just going to scroll down so I can give the correct RSA. So RSA 194B 14 applies to collective bargaining. In the cases of chartered public schools, charter school employees can form collective bargaining units. Those collective bargaining units have to be separate from any other collective bargaining units that might exist. So if we're talking about charter conversion schools, the teachers within the charter conversion school would be able to form a collective bargaining unit, but it would not be able to be the same collective bargaining unit as the one that's in the district. And that's because there is a different board of trustees over the charter school. And for all intents and purposes, the board of trustees is considered the employer, which is separate from the local school board. I know that was a question as well, whether the local school board would have authority versus whether there would be a board of trustees. They do operate in partnership, and local school board members can sit on the board of trustees over the charter school, but there has to be a level of distinction, and they cannot be the same makeup. So you can't have the local school board be the board of trustees, but you can have membership across both of those.
Further question, Representative Ellison?
Thank you, Mr. Chair. Let me take that one step further then. Given the what if we have a 3-year negotiated agreement between the local school board and teachers union, for example, and after the first year of that agreement, the school board decides to go to a charter conversion, does that negate the last 2 years of the existing labor contract that's in fact in effect?
I would love to defer that question to someone that has a legal background or an attorney, because we're getting into contract law and education law there, and I'm not sure I'm the best person to answer what would occur in that what-if scenario.
Thank you. Representative Luno.
Thank you very much, Mr. Chair. Thank you very much, Dr. Green, for being with us again today. Representative Ladd in his introduction spoke about the potential savings to the school district if the school district was to go in the direction of a conversion charter school. And I was wondering if you could speak a little bit to how conversion charters are funded compared to state board authorized charters.
Sure, so the funding mechanism is a little bit different because the funding mechanism still comes from the local dollars. And so if you have a charter school that's a charter conversion school, essentially it's run by the local district, it's funded at no less than 80% of the per pupil cost of the students that are in that district. So if you were to fund the charter school at that 80%, you would be looking at a 20% cost in terms of the per pupil expenditures. You can, as a district, open up your charter school then to other surrounding towns, and you could develop tuition agreements with other towns where they would then send their students, and you would be able to have varying levels of tuition agreements at that point that would not necessarily be governed by that 80% local district funding. So for my example, if a student came from a town that was not part of the district, that local district would not be responsible for that student. The state would pick up the cost of that particular student, just like any other state charter school. So in a charter conversion school, you may have two different streams of funding. The state stream of funding that would come in for non-resident students, and then the local funding for resident students.
So follow up on that?
Yes.
Thanks. So just clarifying a couple of points there. If you could sort of, repeat and maybe rephrase how the state funding works for students, non-resident students attending a school district chartered conversion charter school, and also whether a conversion charter school receives any direct funding from the state as state board authorized charters do.
Sure. So it's a little bit difficult because right now it's a hypothetical. We don't have one that's operating within the state. But if it was a state student, so a non-resident student attending, they would receive the base adequacy payment that the state pays for any other chartered school student in the state, as well as any other differentiated aid that might be part of that student. If they're a free and reduced lunch student, third grade reading, special education, those particular amounts are all dictated by the state for that particular fiscal year. For the local resident students, they would be funded by that local set of dollars at no less than 80% of the per pupil cost. And then I believe the state would still pay the differentiated aid amounts that go into that as well.
Okay, and a final follow-up on,
Yes.
on that. And you just mentioned that the state doesn't have any operated or operating conversion charters right now. We have had one in the past. What happened?
I think with some of the dwindling enrollment that they were seeing and the costs that were associated with upkeep of that particular program, they determined just within the past year that they were going to close that school. And because the school was operated by the school district, it was a district and a local decision. And so the state did not have much of a role in terms of that particular school closing, as we would have if it was a state charter school.
Representative Porter.
Thank you, Mr. Chair, and thank you for taking my question. I still have some concerns. The school would be a charter school, so there would no longer be an elected school board that was running it. It would be a board of directors that would be appointed with maybe a few school board members on it. Is that what you're saying?
Yes.
Okay, can I follow up on that?
Yes.
So when it's time for the local voters to approve a budget, do they get that opportunity? How does that work? If they don't have an elected school board to work up the budget, and it's not a public school anymore, how do I, as a voter, get to say, yes, I approve this budget, no, I don't approve this budget?
Sure. So in terms of the funding for a charter conversion school or any chartered public school that is being opened by a local district, so a district-run charter school, there is, in addition to the charter that sets out the programmatic offerings of the school, there is a contract between the nonprofit and the board of trustees of the charter school and the local district and the school board. And that contract sets out the funding mechanism, the rate at which the charter school will be paid by the local district, the different services that the charter school is going to then provide based upon that funding. And the contract is put before the town as part of a warrant article, and the town has to vote on that.
One more
Yes.
So who writes that charter? Who writes that application?
It could be a
If the-
variety of
if-
people.
If the teachers aren't involved and the superintendent's not involved and the school board is not involved, who is writing the charter?
So within RSA, there are three different groups or three different types of people that can start a charter school. So it would have to be one of those groups. Generally, it's done with collaborative. So my assumption is that if a school board and a local district is looking at doing a charter school, it's going to involve local members, probably of the school board and anybody else that would be interested in setting up and running and operating that particular school. It's usually a group of people that are considered the founders of the school that write those documents. The document itself does have to be approved both by the local school board as well as by the State Board of Education prior to going before the town for a warrant article on the financial contract piece.
One more.
So why would we want to go this route and not perhaps make our public school a public magnet school and open it and keep a school board and a budget and all that kind of stuff, and options for kids and attract kids from other places, then become a, it makes me very nervous when we have a non-elected board overseeing money that comes from my personal taxes. That makes me a little nervous. So I guess I would like to know how I can be less nervous, and why aren't we talking about magnet schools and not charter schools?
So I would say I probably can't speak to whatever the intention would be, because I think, this is a very local decision that we're talking about being made. And so I think there could be a variety of different intentions in creating a district-sponsored charter school or a charter conversion school. And I really don't want to, put words in other people's mouths, because I'm not sure what each individual town within the state might be considering when they're making these kinds of decisions. The one thing I would say is that the pathway already exists within state statute. It has been from pretty much day one when we created charter schools within the state. So any district right now can create a district-sponsored charter school that would exist in the same manner and structure that I've proposed here. It's just this particular bill looks at the pathway where a local public school would become a charter school. But a district can create a district-sponsored charter school now in a very similar pathway.
Representative Tainer?
Thank you. So I'll give you a question based on a hypothetical, but I hope you can answer it. So there's SAU XY, okay? And SAU XY has one school, okay? Let's say it goes K through 8. And the people in the town are agitated, and so they decide that they're going to convert that to a charter school, all right? Doesn't that dissolve SAU XY? Doesn't that dissolve school district, XY? And so therefore, I think the question is, if there's no school district, no SAU left, because now it's charter and it's gone over to a board of trustees, who's responsible for special ed? That's come up like 2 or 3 times and hasn't been answered. It's been kind of goofed around a little bit. And what does the community, if at all, when they're raising taxes, they're still going to be raising SWEP taxes, and I'm not sure how else it affects funding. Maybe Representative Luno can get to that. But if the district is dissolved and the SAU is essentially dissolved, the school board's dissolved because of this single school, please answer directly about the special ed, but then the ramifications for collecting property taxes related to schools. How can they even collect property taxes for a local school if a local school doesn't exist? And what happens to the statewide education property tax?
So there wouldn't be able to be a situation in which the SAU or the local school board would be able to dissolve, because they're the only ones that have that ability to do the local taxation. And so they have to exist because the contract for running the chartered school is done with the local school board. In a similar way to the way we operate Pinkerton Academy or Co-Brown, where they are public academies. Essentially, they're nonprofit organizations, but they contract with a variety of local school boards and SAUs to provide the public school services for the students that attend there. This would be a very similar type of relationship or situation, where the chartered school would provide the education and the services, but they're doing so under a contract through the local school board. And so the local school board would have to continue to exist. They would have to continue to provide the taxation base in order to operate that charter school. It's just that instead of doing that through a public school in the current traditional structure, they would be doing that through a contract with the chartered school, which would have as well its own board of trustees. In terms of the special education, that's another reason why the local school board and the SAU would have to continue to exist, because they would still have a responsibility for providing those special education services to the charter school, most likely through the contract language that they would have in setting up that charter conversion school.
Could I follow up on that, please?
Yes.
So you don't have a school. You've got a SAU, the SAU XY, that has to exist, which I don't know if that's in statute or not. I'd be very interested to see if that's in statute. So in order to have an SAU, you have to have a superintendent, okay? and probably this, you have to have a business manager and you have to have a few other things, but they aren't able to set a budget because the Board of Trustees are running the ghost school in that particular SAU. It just, I don't know if it's been thoroughly thought through on this whole thing, but in these small districts in the north and west, and probably even some, there was a real push to combine schools, and then all of a sudden schools started breaking apart. And there are SAUs where there's only one school. And it just seems, I don't know.
Your question?
Where in statute is that you've got to have an SAU if you don't have a school?
I would have to take a look at that.
Yeah.
At the very least, you'd have to have the school board because that's the contracting entity. So the school board has to continue to exist. And because the charter schools are public entities, their budget is publicly available, and the budget would be part of the contract with the local school board. So the local school board would provide the funding. The budget piece would come from the charter school.
One more follow-up, please.
Okay.
How did the conversion school go back to being a regular school? Or did it? Or did it just fall, did all of a sudden it just crumble, the whole?
So the charter school that had closed was Pace Charter School in Pembroke. It was a district-sponsored charter school. I don't believe it started out as a charter conversion school. It was a district-sponsored charter school. And so when they closed, the students that were attending that just went back to the schools that were within the district already.
And there was no input from the teachers or the superintendent or the community that had to vote that this conversion school was all of a sudden defunct?
No, it was operated by a board of trustees, and so they had to take a vote within the board to dissolve the school.
Representative Mullen?
Thank you, Representative, for allowing me to ask a question. Thank you, Doctor, for taking my question. So I want to go back to eliminating the superintendent, the principal, and the teachers from the decision-making process here to the opening statements that you made about collective bargaining. So it's now my understanding that the teachers, the employees in the charter conversion could in fact unionize, but they could not be part of, for lack of, just so that we're speaking in common language, they could not be part of NEA New Hampshire or AFT New Hampshire if somebody on the staff had been part of that unit prior to this.
So they could still theoretically be part of NEA New Hampshire or AFT. They just would not be able to be part of the same collective bargaining unit that they had been when it was the traditional public school. So that particular collective bargaining unit that was governed by that specific contract.
Got it. Okay, but they could be conversion school number 1.
Yes.
Collective bargaining unit. I had a second question that I asked Representative Ladd. Oh, could I have a follow-up, Representative? Thank you. I had a second question that I asked Representative Ladd. I don't know if you know the answer to this, but it has been my understanding, and I would love for you to correct me if I'm wrong, that teachers that are employed in the charter school system are not part of the New Hampshire retirement system. Am I correct in that?
So the statute actually does allow charter school teachers to be part of the state retirement system. If you're a teacher in a charter school, you can elect to be part of that system. And the years that you've taught in a New Hampshire public chartered school can count as service towards the teacher retirement system.
Follow up to that?
Yes.
Thank you. So who pays the portion of the school? I mean, as it stands right now, a faculty member will pay in their contribution, and then the school pays in theirs. Who does that in the charter conversion equation?
So my guess was that would be probably have to be part of the contract that they would set up. And it could be part of collective bargaining agreements that they go through as part of setting up that charter conversion school.
Okay, thank you very much.
You're welcome.
Any further questions? Representative Moffett.
Real good. Thank you, Mr. Chair. And by the way, earlier when I said SAU 48 was one of the largest districts, I meant geographically, as not in terms of population, just to be clear. So right now, according to statute, if a conversion is sought, it could be blocked by 2/3 of the faculty vote. And my question is that given that many districts feature faculty members who live out of district, that's not, I can think of, and I know of many districts where most of the teachers don't live in the district. So according to current statute, am I correct to understand that faculty members who don't even live in the district could thwart the will of the local people who may want a conversion? Or is that 2/3 vote is what they get to vote whether they live in district or not? Is that accurate?
So the way the current statute is set up, it just refers to 2/3 of the faculty. So it's regardless of residency, whether they live in the district or not.
Okay, thank you.
One question for Representative Woodcock.
Thank you, Representative Cordell. I appreciate that. Just wanted, I thought I heard you say during the early part of your testimony that you referred to this as your bill. Did you write the scripts for this bill?
No, I'm sorry. If I said my bill, I apologize.
Thank you.
You're welcome.
Representative Porter. That was a one finger up, so that's one question?
One finger up, but now I've forgotten my question. Oh, no, you did that to me. Oh. I'm sorry. Catch you afterwards in the hall.
I'm here all day.
2 in the morning I'll call when I remember.
Any further questions?
I got it. Okay.
You're saving the 2 a.m. call,
I know,
Dr.
yes.
Green.
He's
I
going to be
appreciate
glad that
that.
I've got it now.
Yeah.
Okay, so does this vote of majority, can this vote be held, can a special meeting be called by voters in the district to address this? For example, can you get 25 people to sign on to a petition that says they want a special meeting to talk about charter conversion and then have that special meeting and vote on this and need only 51% of the people there to approve it?
I don't know, and I admit I'm not an expert in town meetings and what's required to get something out there and to hold a special election. Or a special meeting, excuse me.
Thanks.
I do not. I see Representative Porter's last minute hand. Did I? Representative Ford.
Thank you, Mr. Chair. My question is a somewhat more general question. A lot of the ones that have preceded earlier have been talking about specific aspects of how would this affect this group. Isn't most of this considered just a general process you would go through when you have change of any sort, and then wages and conditions of employment would be handled through negotiation and that sort of thing? And so it would shift with whatever the employer is now this group instead of that group, but the entity still stands as a school or a whatever.
Yeah, I would agree with that. This just creates a different structure and framework for that to happen within.
Well, my experience being with universities, but when suddenly universities decide to do away with deans, and the dean is the first person you grieve against, then how do you continue with your contract, and then you negotiate how you're going to do that sort of thing. That just seems to me to be a process thing, and that all this would work out, is basically is what I'm saying.
I don't know if you want to answer that as a question.
Or is worked out. That's just what I'm
Yeah, so my understanding of the bill is, so there's a process that exists now for chartered conversion schools, and this particular bill changes the process by which that chartered public school comes into being.
Thank you very much, Doctor. I see one more question. Representative Nelson.
Chairman, thank you for taking my question. Can somebody, say someone makes the switch, a town, can the following year they switch back?
Yes.
Seeing no further questions, thank you, Dr. Green.
Thank you.
I will close the hearing on HB 1132, and we will be open for lunch until 1 o'clock.
We don't have to debate that.
Okay, we got to get going on this afternoon's agenda. But again, I'm going to do this every time we sit down. For those reps that owe me blurbs and committee reports, please attend to them because this is going to snowball on us. You know, we're going to end up having more and more and more. And so please get those together. We did a great job getting through all that stuff yesterday. Let's just complete that job by getting the reports in. You're welcome. Got that, Mr. Colonel?
I sent mine to you, Mr. Chair, last night. I'm innocent.
Okay. So as they said, I don't have to administer an article what in the service? Yep. Okay, welcome back, everybody, for our second half of today's hearings. We have one scheduled, started 5 minutes ago, HB 1212, relative to charges for charter public school transportation. And the sponsor is right here with us, so we're ready to go. Thank you for attending, and you have the floor.
Thank you, Mr. Chairman, Mr. Vice Chairman, and my colleagues on the House Education Committee. For the record, my name is Maureen Mooney, a state representative from the town of Merrimack in Hillsborough County, District number 21. I'm the prime sponsor of House Bill 1212, an act relative to charges for chartered public school transportation. I'm also in support of the bill as it is. Before I launch into this testimony, which in fact I've provided a written copy for each of you that I know is distributed by the clerk, thank you for that. I just want to give a small background on charter school busing. The way it works, and this is for my next bill as well, so it'll be helpful. The chartered school is located, can ride the district's buses to and from school. As an example, if you are a resident of Manchester and you attend a Manchester charter school, you can ride Manchester buses to and from your charter school. If you live in Windham, Merrimack, Bedford, Amherst, and you attend a Manchester charter school, you cannot take Manchester buses to and from that school. That's the background. Now for the bill. Chartered public schools can make their own school schedules and calendars independently from the school districts where they are located. Thus, there are days when the chartered public school may have a full or a half day when the school district where the charter school resides does not. As an example, a chartered school located in Manchester may have school on a day the Manchester School District does not because it's election day. And the Manchester public schools are being used for polling locations, but the charter school is not. So the charter school independently, making their schedule, making their calendar, submitting it on time, designates election day as a day when they have school, when the Manchester School District does not. On such occasions, the chartered public school, as in the example I just gave, should not be charged for bus transportation on that day. If the public school district calendar is not an exact match to the public chartered school's calendar, then this cannot result in an excess fee to the chartered public school. As I mentioned earlier in my bill this morning, and I mention it again, this bill is part of a series that comes from the ground up. This has been experienced at public charter schools. This is a real situation. In real time it happens, and was requested of me that no charter schools best As I mentioned, in this room collectively at lunch, actually, we were talking, I think we now have over 100 years worth collectively of charter school experience here with us. So with that intro, I want to conclude my opening remarks. I know there are those that want to testify after me, and thank you so much once again for your attention.
Thank you very much. Are there any questions of Representative Mooney? Yes.
Thank you very much, Mr. Chair. Thank you very much, Representative Mooney, for bringing this in this afternoon. Is this going to affect the calculation of base adequacy under 19840A?
You know, Representative, I thank you for that question, and at the precise moment you got to the crunch of the question, that door slammed, and I'm sorry I didn't quite catch the most pivotal point of your question. If you could repeat.
Sure, thank you. So as you're probably aware, our current school funding formula includes the most significant component of which is called base adequacy.
Yes.
And that base adequacy cost was calculated, I believe, in 2014, and it includes a transportation component. So I'm wondering if this will, since this is a requirement on public schools, to provide transportation beyond what those schools would be providing for their own needs, would it then affect the calculation of the base adequacy cost?
Thank you for the question. I know there will be those that testify after me. I would say no, because it wasn't enlisted on the fiscal note. And to me, your question makes so much sense and would be so evident there, but I don't see that here. So I'm going to have to answer the question based on the bill I see and its fiscal note.
Thank you very much. I had a similar type question, so I'm just follow it up. When we initially set up base cost and adequacy back in the 2008, we had an amount of $3,456 as base cost. Of that $3,456, I believe $350 of it was made up of for transportation for those students within that district. Now we're talking about students which are above and beyond that district that are charter school students, right?
Yeah.
That's what I'm talking about too. The school district doesn't receive base adequacy for those students that are not attending. That's where I'm going. And so they're not part of our ADMA. So not receiving that funding, is it then not a financial cost? I'm looking at the fiscal note, which says it's indeterminable, but there is that caption at the end, therefore the additional transportation costs, if any, the public school district will financially be financially responsible for under this proposed bill is indeterminable. So that it means that the district's going to be responsible for the cost of this additional day or 2 or 3 that you're talking about. Is that how you see it?
Yes, because that's why the district asks the charter school, tries to charge the charter school for those extra days. Yes. My opinion. Others after me may
So
have
just
more.
my follow-up. So the charter school is going to be receiving funding from the state to incorporate that cost built into that base adequacy that they receive. So they are receiving the money, but it's needed on the other side of the coin for those extra days.
Well, that's where I appreciate that, and that's where this bill, I think, would clarify things on that very subject.
Well, thank you. Representative Tanner?
Thank you, and thank you for taking my question. Is your intent with this bill to state that the local school district would have to provide transportation for any time that the charter schools met outside the school district calendar?
Yes.
Thank you.
Further question, Representative Woodcock.
Thank you, Representative Ladd. Representative, thank you for taking this question. Sometimes I have a difficulty understanding things and taking things out of context. But I'm looking at lines basically halfway through 7 and through 10 have been bolded. Now, if I read the topic, Charter Public School Transportation, and read those 4 lines as a separate entity, that might say to me, we're providing transportation for all charter public schools students. It does not specify the district. I know what it may appear to refer to up above where you're talking about that specific day when not there, but as I read that as a separate entity, it says to me all students, charter public school students on a full day. It doesn't say anything about those above, those in local town. So if you extract that, some may believe that this is giving charter public schools full transportation from the public school system. Could that be interpreted that way?
Thank you for the question. I'm going to say no. And the reason why is because I put this bill in to have that section be tacked on to the existing language that clarifies what you're talking about. If it were to be interpreted as you have suggested, I would have put this bill in and stricken every single thing in that section except the bold language, but I didn't. I tacked it onto that, so charter schools only can bus within, use the buses in the resident scenario that I described earlier, within a resident district that they're located in. So I would have to say, bottom line, no to your question.
Thank you. Thank you, Representative Ladd.
Representative Porter?
Thank you, Representative. Thank you for answering my question. I'm over here. Sorry. So, let's say it's a large city and there are 6 charter schools within the city, and they're all open on the day that the public schools are closed for the election. And there are 15 students that go to those 6 charter schools. The district would be responsible for driving all over the city and picking up those 6 students and sending them to the different charter schools all over, or they may need 2 buses, or that would be on the school district who is not having a class that day. Is that what you're saying?
Yes. And thank you for the question. In the statute that I was discussing earlier with Representative Woodcock, public chartered school students are allowed by law to use the bus system where they are located for the students that reside in that district. So following that, the answer to your question would be yes.
Yes, go ahead.
So is it usual within a district that has many charter schools to just have one bus that picks up the charter school kids and delivers them to the charter schools? Or do those students go on the regular school buses and get dropped off at the charter school as they go by them?
Thank you for the question. All sorts of combinations to make busing possible with the routes and the like. I am unaware of any circumstance where a public school bus is designated to pick up all of the charter school students in particular. Not to say it couldn't happen, but I'm going to say if it does, very rare.
I've got a question, an observation first. We have another situation where we have career technical education centers operate on different days than the regular school is maybe in session. It's the responsibility of the student attending that CTE to transport themselves to the school, the resident school, and then transportation costs from the resident school to the CTE center can be made up as a component of the tuition and transportation formula we have for reimbursement. So I question, we have a situation which is very similar here, that the transportation from home to school is not provided on days the school is not in session. Should this not be the same then for the charter schools that are on a different schedule than the regular school or the resident school?
Thank you for the question. It sounds as though that scenario would be contradictory to what I'm proposing, so I'm going to have to say I'll stick with the language I'm proposing.
Okay, thank you. Representative Woodcock.
Yes, thank you, Reverend Lott. In the towns, in one of the towns I represent, they have 2 charter schools. Both of them totally different. One is primarily an outdoor-focused charter school, and they're terrific. They very rarely have ever heard the term called no school days for snow, because they do bulk of their work outside. So are you suggesting that the days that one charter school in my town is closed, the public schools is closed, but the outdoor charter school is open because it's a snow day and they focus on outdoor activities, we should have the public school buses on a no school day when it's unsafe to drive?
Thank you for the question. I had to very carefully follow that scenario, so I
I can
appreciate it.
simplify it for you if you need.
No, I've got it. I think I got it. Inclement weather would be closed for everyone.
They don't know what that word means, inclement weather. They do the bulk of their teaching outside at that charter school.
So you're asking if they would still have to be bused?
Based on this law that you have here, yeah.
I would say no.
So this
That
law
sounds
would
like a local,
This law would not be applicable then?
sounds like a local issue with regards to canceling or not, so I would leave it to the local district.
Are further questions? Not seeing. Thank you very much.
Thank you.
You're welcome. Bob Best from Merrimack. He testified, I think, this morning.
Good afternoon, Mr. Chair, and members of the committee. Thank you again for the opportunity to be here. I'll spare you the reintroduction of who I am since I spoke at the hearing earlier this morning, but got a lot of involvement in charter schools, and I think this bill is a really important one to consider. I think that there's always discussion about costs and some details of coordinating schedules and things like that. But I think that the overriding concern here is making sure that children have access to school, that they have access to school for the whole school calendar, all the 180 days or whatever are the number that are scheduled here. And the existing statute, which is reflected in the bill that's before you as plain text, I think it was intended to do that and go a long way in that direction, which talks about, as Representative Mooney had offered, that if you live in the same district as where the charter school sits, you're entitled to ride the buses. And then it also talks about using the same routes and terms and conditions and the same routes and schedules that already exist. And I think that the inescapable conclusion of that is that the intended law is that charter school students are public school students like any other. They're entitled to equal treatment. They're entitled to parity. And that means that they're entitled to have a school bus ride to school if they're lawfully and legally entitled to do so. The consequence of this isn't so much about the cost of a bus or two, and it's typically the number. I think one of the bigger charter schools in Manchester, I think, has 4 buses that provide students over to it. But it's the cost of a bus, while important, isn't as essential as making sure that the child gets to school. Because as we've seen throughout COVID, when we've had all of these discussions about schools being open and schools being closed, when the student doesn't have access to school, they stay home and their parents have to do something. Charter schools are often younger kids. Some of them are kindergarten and on up. The one that I'm involved with in Manchester begins with 6th grade. Next year it'll start with 5th grade. And those students, some of the younger ones, are just not able to stay home alone. So now the parents have to make some arrangement, which they weren't necessarily planning on because there's a surprise in the school schedule. Beyond that, maybe, I don't know, pick a percentage of students that ride the bus. The other students who are brought by their parents and are in school are going to continue with their lessons. And that student that doesn't have a ride to school, maybe their parents can get them to school, maybe they have to stay home and miss school. More often they miss school. They are obviously disadvantaged by having that day out of school. And those have to be the top concerns for us. Those have to be the priorities for us, taking care of the kids. Yes, there is a potential for a little bit of cost. It isn't that the charter schools are getting the transportation money and it's not going over to the school district for transportation money, because charter schools don't get transportation money. That's not part of their formula since they don't provide any transportation. It's also the case that other private schools in a district, separate from charter schools, have this same provision where their students are allowed to ride buses. And so we as a state, we've already sort of decided, let's get the kids to school. Let's not sort of parse, are you in the right kind of school? Are you in the public school? Are you in a public school, but it's a different school because it's a chartered school, or it's something else? The overriding priority always has to be, let's get the kids to school for all the days of school so that they can participate fully. What would happen if the day where the schedules misalign is exam day, or is a critical day of education in the curriculum that the school's after? Obviously could end up being a big problem. Election day is one small example. Professional development days are usually the ones that create the most disparity, because the school district can put those anywhere on the calendar that they want, and there's usually 4 or 5 professional development days. And frankly, the charter schools are not picking a schedule intentionally to be sideways. More often than not, the charter schools get a peek at the school district schedule and they do their best to try to match them up, but sometimes it just, there's something that misaligns. A half a day of schedule instead of a full day or something like that. The added cost in the big scheme of things, certainly it isn't a significant portion of a school district's budget. You know, if you think that they provide transportation to all of their schools for roughly 180 days a year, the idea that they'd have to do a couple of buses, a couple of extra days for one day of year, isn't even 1% of their transportation budget, much less, you know, a percentage of their entire budget. But it's critical to the students. It really makes a difference for them.
Thank you very much. Are there questions? Representative Bohm?
Thank you, Mr. Chairman. Thank you for taking the question. Aren't the residents in the town where the charter school is, aren't they also paying school property taxes to that town?
Yes, very much so.
Also,
oh, I'm sorry.
a follow-up, you're from the town of Merrimack. Would you believe that Merrimack provides transportation to the CTE Center even when they don't have school?
I don't know the details of Merrimack, but I wouldn't be surprised. But isn't that our goal? Let's get the kids to school. Now, CTE Center schools, and I heard the discussion earlier, I honestly know exactly how those work because I'm not involved with them, but to the extent that there's some provision for the student to be brought to the school, and then from there they can get transportation. A lot of the charter school students are much younger. You know, they're kindergartners, they're first graders. It's very complicated it's very frightening to put a 4-year-old or a 5-year-old or a 6-year-old on a bus and hope that it all works out, or they get transportation to one place and are not taken directly to their own school. So that's why it makes a lot of difference for them.
Thank you very much. Further questions? Representative Luno.
Thank you very much, Mr. Chair, and thank you very much again for being with us today. You've obviously got a lot of experience with not only the charter schools that you've been with as a parent of a student, but also, as you mentioned this morning, your representation and work with charter schools.
All of my kiddos went to the Merrimack public schools. They didn't. My kiddos didn't go to charter schools.
Oh, okay. I'm sorry. No, I misunderstood that. I'm
I have
sorry.
4, but they all went to the and
that's not really where my question is going. You had mentioned in your testimony just a few moments ago that one of the charters in, I think you said Manchester, has 4 buses maybe or something like that.
That's my understanding.
Why do they have 4 buses, and why aren't they using the Manchester transportation system for?
That's a great question, and my answer wasn't as clear as it should have been. Manchester School District provides them with 4 buses.
That clarifies that,
It takes 4 buses to service them, or whatever. Okay. You would figure that out.
And thanks. And are they being charged by the Manchester School District for transportation services?
For the school days when Manchester is in service, no, the charter school's not. When they're not in service, There's been discussions about the cost of it and charging for it. I don't know if the bill has actually ever been sent and paid, but there's always sort of this discussion about we're going to send you a bill for, I don't even know what the number is, but it's, so yes, there's been a discussion about it. And then on the other hand, there's just questions where it's just not available. We're not coming, you can't have a bus on Friday because our schools are closed and yours aren't.
Okay, thanks.
Thank you very much. Are there further questions? Not seeing any. Thank you very much.
Hey, thank you very much.
Yep, you're welcome. Barrett, Christina? School Boards Association?
You're welcome, Barrett. Good to see you.
Thank you. Good afternoon, members of the committee. Chairman Ladd, thank you for taking my testimony. Barrett Christina from the School Boards Association. We are opposed to House Bill 1212. Some of the reasons have been brought up primarily by Representative Luno and Representative Ladd relative to the cost that would be incurred by local school districts and the transportation aspect that is embedded in the adequacy aid formula. I would caution this committee, or at least remind this committee, that the lack of sufficient transportation funds from the state to local school districts is a key component of the Conval lawsuit. And if you were to pass this bill, you would simply be adding more costs that are already insufficiently funded by the state for transportation. So you're essentially adding fuel to the fire, and you'd be making Conval's case that state funding as embedded in the adequacy aid formula is not sufficient for all the other obligations relative to transportation that the legislature has imposed on local school districts. The second aspect that NHSBA has for opposing this bill is by adding new requirements for a school district to provide transportation on students, for charter school students on days that the public school, the traditional public school, is not operational, may interfere with contracts that we already have, whether or not that is a contract with a private transportation provider, or perhaps, I believe in some cities, I'm guessing, I don't know per se, but some of our transportation providers may be operating under collective bargaining agreements with their pertinent cities, so these may have days and vacations and things of that nature embedded into whatever contract we're operating under on, whether it's a contract with a private vendor or a contract such as a collective bargaining agreement. And last, everybody on this committee knows that statewide there is a significant bus driver shortage. We have had to get, meaning public schools, have had to get significantly creative the last number of years in providing bonuses and providing training and providing other bonus incentives to get more people to become bus drivers. We don't have enough bus drivers for the routes that we're currently running. If we're currently being obligated to run routes on days when the public school is not open for either an election day or for inclement weather, or if a charter school was doing some sort of curricular component on a Saturday, I don't know where we're going to find those people. We don't have enough people to meet our current obligations. By adding more obligations, it's going to be, you're just adding to the stress level, both from a workforce standpoint and as well as the fiscal aspects that the local public school would be incurring that we would not be being reimbursed for. So for those three general reasons, NHSBA opposes House Bill 1212.
Questions? Representative Tanner?
Thank you, and thank you for taking my question. At least at my school, one of the more headache-type jobs was that of kind of a oversight person for the school buses, a school bus director who ran kind of the dispatch, kind of the care and, for the school buses.
Transportation coordinator, representative.
Yeah, and took all the headache calls back and forth. Do all schools have that? And if they do, that person wouldn't work on certain days, and so that cost has to be added in as well.
Thank you for the question, Representative. Do all school districts have a transportation coordinator? I don't know. That's a good question. I'm going to presume not. I would presume in some of our smaller K through 3, K through 4 districts, that's probably left to the responsibility of the principal or the superintendent. That's a presumption on my end, so the simple answer is I don't know.
Further questions? Representative Woodcock.
Thank you, Representative Ladd. Mr. Christina, thank you for taking my question. Do you happen to have the copy of the bill in front of you?
I do, yes.
I'd like to ask you the same question I asked Representative Mooney and see if we have the same answer. One a representative's answer and one a legal answer. I'm reading 7 through 12, and I'm wondering if a public school is closed for a snow day and the charter school is not closed for a snow day, are our public school buses that are off the road because of safety now required to go on the road and provide transportation?
Thank you for the question, Representative. As I'm reading, I believe it's line 9 through 11. If the district doesn't have a full day or half day of school scheduled on the day the transportation shall be provided to charter public schools on all the full days and half days the charter school requires attendance. I'm reading the bill, and it says if the district doesn't have a full day or half day of school, then the charter school cannot be charged. The charter school cannot be charged implies that we're still obligated to provide those transportation services when the public school is not open for whatever reason the public school is not open. My interpretation of the bill is that if the public school is closed for whatever reason, elections, inclement weather, whatever it might be, but the charter school is open, that the public school is still required to provide transportation services. That's how NHSBA is interpreting the bill.
Thank you. Thank you, Representative Ladd.
Thank you. Further questions? Representative Likas.
Yeah, just looking at that, I noticed it says full day or half a day of school scheduled, and if it was a snow day, it would have still been scheduled, right? It would have just been canceled.
Thank you for the question, Representative. That's certainly an interesting interpretation that one could make that argument.
Thank you.
I'd suggest you speak with the sponsor of the bill, though, to ascertain intent, though, relative to a distinction between scheduled or canceled.
Representative Ford.
Thank you for taking my question. I'm a novice here, so if I ask a question that everyone knows the answer to, please forgive me. But when we were discussing EFA kinds of things, I learned that school districts report for people who report for attendance on students who are following other routes. I'm wondering if in this case they also report for attendance, hence they are able to receive federal funding, et cetera, et cetera, et cetera. It's not out of that part of the thing, but they're still funded for those students even though they're over here.
Thank you for the question, Representative. I may need some clarification. So the public school is tracking students who ride the bus or are eligible to ride the bus? I apologize, Representative. I guess I didn't understand the question.
I'm saying it's a principle kind of question, I guess. If we have a principle that if you report to student for attendance, which they do, and then receive funding for that, then why, if they need some additional assistance in getting to school, would that be an issue?
Well, thank you for the question. I think I understand. Well, the issue would be that you would be running buses and paying for gasoline and paying for bus drivers that you, one, had not necessarily budgeted for, two, may run afoul of contracts, as I mentioned, and three, to my understanding, those charter school children that are riding the buses provided by the public schools are not, the public school district is not receiving any funding for those students.
And my understanding was they are receiving funding, not for that purpose, but they're receiving funding.
The local public school districts, traditional public school district, my understanding, if I'm mistaken, Representative Ladd or Representative Luno, perhaps you can correct me. My understanding is that if I'm going to call it a traditional public school because I fully understand and recognize that charter schools are public schools, just for that distinction. My understanding is that if a public school district is providing transportation to students who are attending chartered public schools, the local public school district is not receiving funding for that.
for that purpose.
For the purpose of providing
No, no, I
transportation to
understand that.
charter children.
I understand that, but they are receiving funds because of that registration that they report.
The state, yes, sorry, by all means, Representative.
The only place we have direct transportation reimbursement by way of formula is career technical education. We reimburse at 25 cents a mile per student, and we budget approximately $680,000 for that purpose. The actual cost to districts is closer to $2.7 million, so we're not fully funding that. When it comes to the area we're talking about here in the regular public school, the funding for transportation is built into the base cost. There's no transportation formula where you get X number of dollars school district. It's built in that $3,456, now $3,700 something, and it's there. Now, if the other school also receives costs like that, or funding, revenue, and it's built into their base, they're receiving also that transportation cost per student, which is approximately, well, 350 times cost of living. Now it's a little bit more. So it could be as high as, $450 on a per pupil basis for the year. So that's the only source of transportation revenue the districts receive on this. It's not a money-making affair, and that's the issue. We have buses running now with 1/3 capacity on a 66-passenger bus for elementary kids. It's not paying labor, it's not paying insurance, it's not paying, replacement, any of that stuff. So I think that's how we're.
Thank you, Mr. Chair. And Representative Ford, I'm going to read from the Conval lawsuit. The current state funding incorporates a base universal transportation cost of $315 per pupil. So the state, as part of your adequacy aid, the $3,800 that public schools get per child, 315 of that is to provide for transportation services. Next paragraph from the Conval lawsuit. There is not a single district in the state with 10 or more pupils whose transportation costs are less than $400 per pupil. So the argument is that districts are being expending more than $400 per student to provide transportation services just for the traditional public school children. We're only getting reimbursed we're not even reimbursed, we're only getting revenues of $315 per student, and now we're being asked to add additional students on different days that we have not budgeted for and we're not getting any adequacy aid for. The other aspect to that, if I may, I wasn't planning on going down this route, but your annual meetings are in another 6 or 7 weeks. So our budgets are pretty much set. Budget hearings were within the last 2 weeks. Budgets are going to be set in the middle of March. So if we're adding costs through this bill, local property taxes are going to go up next October because we're going to have to pay for more stuff without getting any funding for it.
Are there any other questions of Barrett Christina from the School Boards Association? Everybody good? No, Representative Nelson.
Thank you, Mr. Chairman. Thank you for taking my question. On a snow day, okay, are they made up automatically? In other words, if you take a snow day, do you have to make one up at the end?
Thank you for the question, Representative. No, the law requires, we had a little conversation, I forget if you were here or not, Representative, when Chairman Klein from the State Board of Education spoke about, I forget the bill number, when we were talking about the remote instruction versus in-person instruction. The law requires that school districts, when they're building their calendar, build in 60 additional hours for inclement weather. So one snow day, no, you don't have to make that up at the end of the year. Once you start getting into 7, 8, 10 school days, snow days, you would have to tack on days at the end of the school year.
Further questions? Thank you very much.
Thank you very much.
Okay, next and last person I have a pink card on is Kim LaValle.
Thank you, Mr. Chairman, for the opportunity to speak, and committee members. I'll be brief. I think we've covered a lot of this. I think the purpose of this bill is to make sure that the kids are getting to school. That's really it in a nutshell. We're not talking about a lot of days. We're talking about the rare instance where schedules may not align for whatever reason, but we're trying to get the kids to school. The kids that we're talking about, for the most part, are probably K through 8, 9th and 10th graders, perhaps. Some of the districts may not allow the kids to ride the public transit, even in high school. I'm not sure where that lands right now, but I'm hearing a lot of people talk about it's a lot of money, it's a lot of money, it's a lot of money, and it is. Money is important. People who know me will say I'm cheap. I mean, I'm pretty tight with my cash, and we run our charter schools pretty tight. But at the end of the day, we're talking a couple dollars per child per day, and we're talking about maybe a day, one trip or 2 trips. The kids that are going to be impacted are the kids that need to be in school. Their parents are working. They don't have transportation maybe to bring the kids to school. We need to rely on the buses, and it's not for a lot of days. Other issues, we're hearing contracts, collective bargaining, et cetera. Those are important, but they'll get worked out when this is resolved. Again, we're talking about 1 or 2, 3 trips out of an entire school year. I certainly would never expect the district to bus children if there's bad weather. I just wouldn't expect that. I wouldn't want to put bus drivers at risk. I wouldn't want kids on the buses if it's that bad. So I'm not sure that was ever intended to be that way. The rest of it, I think we can work out. It's not a lot of money. I think it's more important that we're getting our kids to school safely, making sure the kids that don't have transportation, if there's not a bus, are getting to school, and then they're able to get home. Thank you.
Thank you very much. Are there questions? Being familiar with a charter school and how it runs, is there an attempt on the part of charter schools to try to align calendars so they're agreeing with the district calendar, for example, starting at a certain time either prior to Labor Day or after Labor Day? That's been contentious throughout the state. And then, of course, you have the other days within for professional days, in-service days.
Yeah.
So is there an attempt to try to align these calendars so they are on the same scheduling?
I can't speak for every charter school, but I can speak for the school leaders that I've interacted with, which is quite a few, and we all try to work with our districts. We call and ask, this is when we're looking to start, this is when we're looking to end our day. We're looking to get a copy of their calendar so we can build our calendar as closely as possible to it. Everybody wants to collaborate with the districts. It's just once in a while there's an off day, whether it's exam week or something comes up. Sometimes it's just something's missed. But we want to make sure every child has the opportunity to be in the school when it's open.
Thank you very much. Representative Porter, I see your hands up.
Thank you, Mr. Chair, and thank you. As I'm sitting here thinking, there are different models of education. Some schools have 6 weeks on, 3 weeks off, that kind of thing, a different form of calendar. If one of our charter schools was to decide that one of the ways they wanted to innovate was to play around with the traditional school calendar and like go through the summer and have longer breaks at one time and shorter breaks at other times, if they did that and that was part of their contract or their application, would then, say they were open 2 weeks when the schools were closed, or they were closed 3 weeks when the schools were open, would the public schools then be responsible for transporting those students during, I'm not trying to be difficult here, I'm just trying to think of something that might happen in the future. My ideal school was open all year long and having blocks of time that were different than the traditional, and I thought that might be beneficial to the learning of kids, especially over the summer, et cetera. So if someone came forward with that, would passing this bill then require the public schools to transport the students when they were not even open at all for long periods?
I would venture a guess that yes, but that wasn't the intention. The intention is to operate within the normal school calendar year and try to cover those days that are missing. So not looking to transport children outside of a normal calendar year.
Are there further questions from the committee? Yes, Representative Tanner?
Thank you, and thank you for taking my question. You said about, you concentrated on working it out with the districts as far as calendar issues were concerned. Have you tried to work it out as far as the amount of money the extra days would cost for transportation or anything on that line?
We've received the cost per bus, per trip from one of the districts that we have a school in. We're trying to work it out with them. That's why we try to align our calendars as best we can. Again, most of these days are just, it's an off day, whether it's exams or there's something going on that the school is participating in. On the other side of it, I know some schools have longer days, more days off, and the school districts don't have to transport them for, maybe it's the week of Thanksgiving at all, or they have a longer holiday break. They have different days off where the school districts do not have to transport. And we work very hard to make sure that they have access to those calendars and are aware of that at the beginning of the year.
Right. Just as a follow-up on that,
Yep.
my question was not about the calendar, because you've made it quite clear how you tried to work it out with them on calendar. What I'm asking is, have you tried to work it out with them financially on how much it costs the district to provide that extra busing and how much they're charging you, in other words, to come to some agreement that way financially?
I can't speak for every school. I can only speak for the ones that I've been involved with. And we've had discussions about the cost, and I could be wrong, but my recollection, this was about 3 or 4 years ago, my recollection is that they have a set fee for their buses per day to use it.
More follow-up?
Yes.
So could you give me an idea of what that fee was?
I want to say it was roughly, for some reason, $238 one way is what's sticking in my head per bus. So I could be wrong, and that's going back probably 4 years now. I'm sure it's escalated with gas and everything else. But, it was significant enough. We were looking one day, one of the schools actually had more buses, and I think we were looking at closer to $2,000 for the day charged to the charter school, and it was for exam week or something for one of the days.
Thank you very much. Further questions? Not seeing hands. Thank you very much.
Thank you very much.
Have a good afternoon.
You too.
I don't believe we have any more cards on that particular bill, so we're closing this hearing and preparing to go into the next hearing we have, which will be 1453. Representative Mooney, you're welcome back. Okay. So the bill we're opening up right now is 1453. That's relative to transportation to a charter public school.
Thank you so much.
Yes.
For the record, my name is Maureen Mooney, State Representative from the town of Merrimack. That's Hillsborough County, District Number 21. I'm the prime sponsor as well as a supporter of House Bill 1453, an act relative to transportation to a chartered public school. I provided written testimony for all of you, and that's being distributed now. I begin it with the background and the scenario that I did for the previous bill just now, so I don't think I have to repeat that. It seems to me as though it's clear as to how it works in terms of busing, so I'm just going to go right into it. House Bill 1453 expands RSA 194-B:2, Roman 5, to ensure the phrase "same terms and conditions" applies across the board when it comes to bus transportation. The bill forbids transfer stations, depots, or terminals if, big distinction here, if the school district where the chartered public school is located doesn't have transfer stations, depots, or terminals for their public school district students. A transfer station, a depot, a terminal is another location where students congregate or are dropped off to essentially catch connecting buses to their final destination. I would provide the example of when you're flying and you have a flight ultimately to LA, but you have a connecting flight you have to catch in Chicago. The same thing happens with busing. A student may be bused at a location, oftentimes another school, dropped off, waits, connecting bus arrives, boards that, gets to their final destination. I'm extraordinarily in awe and sympathetic to the busing transportation companies. They do an extraordinary job. And I've worked with them in Manchester. I'm familiar with the bus coordinators in Manchester, the public school bus coordinators in Manchester. I've never met a more organized professional group in my life. They do a great job. And I know that they're doing the best that they can with routes and the like. However, we are asking, if depots and terminals are not used for public school districts, then they not be used for the chartered school students that are within those districts as well. That will conclude my testimony. Thank you, Mr. Chairman.
Thank you very much. Are there questions? Representative Bohm.
Thank you, Mr. Chairman. Thank you for taking the question. Private schools also have the same requirement, but when our private school in town had students on the public system going to the school, they were all met at the middle school and then driven to the private school. This would not allow that?
So you're saying, could I, thank you for the question, I just want to clarify. You're saying in your scenario that both private school and public school students in that district were brought to a location?
No, just the private school students.
Okay, this
Well,
bill,
oh, they were all met at the middle school, and then a bus took to the private school.
public school and private school students all met at the middle school,
No, no.
just private?
Well, all the students that went to the middle school all met the middle school, but then the students that went to the private school also came to the middle school, and then they were bused to the private school.
Understood. My bill is related only to students of a chartered public school.
But that would be the same instance where that would not be allowed.
Sounds very similar, yes. You're bringing in private schools, which is a whole,
Just the thing.
yeah,
The private schools stopped the transportation because their hours wouldn't jive.
understood. But just to clarify, my bill, public chartered school students.
Representative Lakis.
Following on to the previous one, because we do that in Hudson, and they go to the elementary school and they are supervised by teachers and they have little lines and they get them into the lines before the buses show up. And I think it's more than a bus, because we have a pretty big private school and they've been doing that. I've lived there 38 years and it's been going on all this time. Why would it be inappropriate for a charter school system to use that same system that's been working for the local? Why would it be inappropriate to work for a charter school when it's been working for the local private school for all these years without a problem?
Thank you for the question. I know that those who are going to testify are closer to this issue at this point than I am. However, when I was involved in this and had been exposed to it, not every school that's designated as a depot, as a terminal, is as ready, perhaps well-staffed or coordinated as the one you just described. It could sometimes be a safety issue. It could also be a delay in transporting the students and so forth. So it sounds like in that scenario it may work, but it doesn't always work that well.
Yes, go ahead.
Would it not then make sense to, instead of forbidding it, putting some guidelines on it that says they have to be supervised by school personnel or something, instead of just saying you can't do it? when it's something that is working for some towns?
Very good question. I appreciate it. I agree with that. I would be open to that, but I hesitate because yet again, another layer of rules and regulations bearing on the backs of our administrators and our teachers to now come up with a new set of rules because they have students coming in and being dropped off at depots, and there's a period of time where they have to be supervised. So I'm torn on that, open to it, but torn on it knowing the realities of when rules and regulations come bearing down from Concord on our administrators and our teachers. Thank you for that question.
Thank you.
So I have a follow-up to where we are with this conversation and questioning the issue of supervision. We have a responsibility, all educators have a responsibility to make sure that these students, all my youngsters, are under proper supervision. And you come in from home to school A where the transfer is made. You might have several buses coming in from different directions, so you could end up with a number of kids there. On the days that no teachers are there, and oftentimes it's the teachers on the playground which are supervising other students going to that resident school right there, who also supervise these students which are going to go on, whether to a middle school or to a charter school, and that's common. What will we do on those days when there's nobody there to do the supervision, and the bus drivers couldn't leave unless there's an adult there supervising? How's this going to work with the supervision that's needed of the students which are being dropped off at that transfer site and waiting for students come in from another site, and then all those students get on to go to the charter school?
Thank you for that question. I can only think my bill would help in that scenario, in that it would now forbid this kind of hypothetical, as you describe, where we're having more terminals and depots. My bill would reduce that.
Okay, thank you very much. Representative Mullen.
Thank you, Mr. Chair, and thank you, Representative, for taking my question. So I'm trying to wrap my head around the logistics. I'm your neighbor in Bedford. Our town is 43 square miles. We've got 6 kids or 7 kids going to a charter, and they're coming from all different directions, and we can't intersect anywhere or for them to get off of one bus and get on to another bus. So do you foresee this as a dedicated bus for those children? The kids in our community get on the bus at home and get off the bus at school, but they're routed and they're all going to the same place. Can you take me on a ride from your house where you're leaving as the chartered school student and not having to get off the bus?
Yes, thank you for that. So if I live in Manchester and I'm a student and I attend a chartered public school in Manchester, I am entitled to ride the Manchester school bus to go to school. There may be a scenario where I am picked up at my home in Manchester and driven to another school, dropped off, have to wait. The bus I was just on takes off. I wait for now another bus to arrive, I board it, and it would then take me to my chartered public school. The place I just was could be another school. I believe for COVID precautions, I believe there was a large depot in Manchester that was not a school, but a facility that could certainly be a terminal and so forth. So that would be the scenario. What we're saying in the bill is, again, if Manchester isn't doing that kind of a route, then it shouldn't, for their public schools, then it shouldn't be done for me, the Manchester chartered public student, to have to make that terminal stop before I get to my final destination.
Yes.
except that the other students are getting on the bus as a group along a route and all going to the same place. So they don't have to get off because that bus is picking them up and taking them all to the same place. I now live amongst those kids, but I'm going halfway there and then I need to go in a different direction. Is there, I mean, I can't see any other option other than having, you know, a dedicated driver pick that one student up, or the 4 students that it applies to, however many. How are they going to get from their home to the charter school without having to stop somewhere?
Certainly, a bus could pick up students from multiple schools and make stops along the way, direct stops. But they can't have a terminal connecting flight, for lack of a better word. So I'm not saying in my bill, you know, a designated bus to go to, you know, this school and another to go to just to that school and another to go to this school. I'm saying bus companies can come up with routes to collect everybody that's going to a different school and making stops then at all the schools of the people I've just picked up without any connecting stops. So when I let you off as the bus driver, my bill would say it's going to be to your final destination. It's not going to be to a median destination.
Could I just have one quick?
Go ahead, Representative.
In our community, we have rules about how long students can stay on a bus. So I believe the goal is to have the little ones on the bus less than an hour. Have you given any thought to how long it might take if there were 15 kids scattered all over Manchester, that somebody had to be the first kid picked up and somebody's going to be the last?
Yeah.
Have you given any thought to that?
I have not, in consideration of this bill, and I'll tell you why. I'm trying to, as best as possible, but succeeding the goal of what this bill intends to do, allow as much flexibility as possible, within reason, of those who so diligently put these routes together. Thank you.
Representative Tanner?
Thank you, and thank you for taking my question. I live up in Sullivan County, and the 2 districts that are really close together where I live, or where I go by as I travel down here, are Sunapee and Kearsarge. And there's a stop along one of the lakes where every morning when I come early for these committee meetings, there's a Kearsarge bus waiting for a Sunapee bus so that they can transfer students. Because in the backcountry of New Hampshire, the roads aren't like the streets in Manchester. And the school district, Kearsarge, has 8 towns, and it's one of the largest geographical school districts in New Hampshire. And they have probably the heaviest transportation budget. And in order to make it efficient, and they've contracted with nearby districts to have these roads that kind of naturally lead to each other, to have these areas where they meet. It seems to me that this bill that you have offered here would mess up their system tremendously, depending on where the charter schools were. And I'm just wondering if you thought at all about how this is going to affect the rural areas of New Hampshire.
Thank you for the question. In the scenario you provided, was there a chartered school involved?
I'm not sure that there's a charter school. There's a couple of private schools in our area, and those students, although there's this bus switch between districts at a certain location where certain students go back and forth, but then they're transported to their individual schools, whether it's an elementary school, elementary/middle school. And then from there, if there's further transportation, then the bus, another bus or that bus, depending on how, they work it,
Yes.
would go to the private school or assuming the charter school, which it seems like you're saying that's not acceptable.
Thank you for that clarification and question beforehand. I would argue that my bill does not apply to the scenario you described because of the big if word. The bill says if the school district where the charter school is located isn't doing it, you can't do it for the chartered school students either. But in your scenario, it sounds to me like the school districts are doing it. So therefore, it would continue to be allowed.
Yes.
So I don't know if it's that much different than Representative Mullen's idea. What it seems to me that you're saying, and just this is like a question,
Yeah.
are you trying to say that even in our rural areas, that if there's a charter school within that rural area, at some point, kid A, who's a charter school student, gets on bus 1, and that same bus 1, whether it's from Kearsarge, Sunapee, or whatever, has to end up at that charter school without any connection anywhere? Because that's what it seems to me like you're saying in this bill.
Thank you for that. If the destination is to the chartered school without a terminal or a depot in between, that's okay.
Even if part of that depot is the buses sitting and the kid has to change from a Kearsarge bus to a Sunapee bus because the roads and the towns intersect?
And in that scenario, it sounds as, and thank you for that, in that scenario, it sounds as though because your school district is doing that sort of exchange, they could continue doing so. And that would be,
But the charter school student wouldn't get on bus 1 and end up at charter school on bus 1, and that seems like that's what you're saying has to happen.
a transfer of bus would not, necessarily be a depot or a terminal. Being dropped off and waiting for a connector would be. And I want to just further add, yes, I have considered charter schools collectively throughout the state when sponsoring this piece of legislation, not just in urban areas.
Thank you very much. Representative Likas?
If a school, some of our school districts, single town school districts, are very geographically large. And so in order to keep kids from being on a bus for hours, we run a lot of buses, right, to pick from all over the place and bring into the school. But if you have a charter school and you can't let that student ride the bus from their neighborhood, the same bus that all the other kids are taking, to the school, and then have the school collect up all of them to take to the charter school, what you're going to have to do is either run a whole bunch of empty buses, or you're going to have to run one bus, say you've only got 15 kids, or even if you have 20, one bus all over the entire school district at all those disparate places. And that could take hours to do that, to pick up all those kids. And I'm not sure why you would prefer that to having them meet at another school and take a single bus to the charter school.
Thank you for the question. I would just go back to that word if. If the school district where the chartered school is located does transportation precisely like you just described, then it's fine for the chartered public school as well. But the chartered public school student should not be in a situation where they are brought to terminals and depots and the public school students where the school is located is not.
But that was not my question. My question was the traditional public school, all the kids end up at the school that they're going to. They don't transfer them. But a charter school would either have to transfer them there or would have to run a bus over the entire district to pick up all those charter school kids from one end to the other to do it straight. And I'm wondering why you would prefer kids stay on the bus for a couple hours, potentially. I know how long it takes just in my town, if I was to run in and out of all those neighborhoods. Why you would prefer that to having them meet at a public school where they can be bused to the charter school. Because if my town does, if everybody else gets bused to their school.
Just to be, thank you for that. Just to be clear, I don't prefer that students take forever to get home or that they have longer routes than necessary. The purpose of my bill is to make it fair for what's done for public students is done for chartered schools. And oftentimes terminals, bus depots, and the like are not the best scenarios for a route to or from school. The best scenario would be the connecting, the direct flight, for lack of a better word, or the direct route. In a scenario like you're mentioning where it's more complex, yes, I would imagine the bus coordinators would have to do some more routing and organizing in that way, but it is certainly not the intention at all to prolong a student's drive to or from school.
Thank you very much. Further questions, Representative Woodcock.
I'd like to follow up, if I may, Representative, if you take the question, on Representative Bowman's comment. It seemed to me, I know you were differentiating between his public school and private school and charter school fees. But let me give you his exact scenario as it happens where I live in an rural area without using the term private. We have 5 buses, pick up youngsters, come to the middle school. Everybody gets off there, and the 5 charter students as well. And from that site, a new bus comes, it picks just those charter students up, and takes them away. So you're telling me that is not acceptable?
Thank you for that scenario. That is a unique one, certainly. The fact that you start out by saying the scenario is for all public school students and that they're all brought to the middle school.
Those that go to the middle school.
Those that go to the middle school. So when the connecting bus comes, it picks up only chartered school students?
Correct, because all the other kids are at the middle school.
Okay, that would be a depot that would not be.
Well, it's a school, right.
Right.
Sometimes depot, transfer station airplanes makes me seem more cold than it is.
Correct.
So that current system that they've been using for 40 years is not working for you.
But in the scenario, well.
Okay, that's all. I got it. I just want to be clear. I got it.
Let me just add to your scenario, may I?
Sure, if the representative allows it.
Go for it.
If, just to be clear on what my bill does, if in your scenario, the public school district students, the chartered school district students are all brought to the middle school. Some stay because they go to the middle school. Well, this is my scenario. I'm coming up. Yes, please. Go to the middle school. Those that go there stay. A bus comes up and picks up chartered public schools and perhaps some public school students who got dropped off there but they don't go there. They get on as well. My bill would not apply.
But we only have one middle school, so they all get off there.
Okay, we can go hours on this thing and a lot of different scenarios because there are a lot of different scenarios.
There are.
And I just let you know one last one I'm looking at. We're trying to do the same thing with all our students on an activity bus after school. Running that around through Haverhill. We cannot do it and keep those kids on for less than an hour and a half, some of the kids riding on that bus. So the same thing would occur. We'd have to consolidate, instead of using all the transfer sites and the different buses we have, we'd have to use one bus. In that one bus scenario, I'll be honest with you, it won't work in my town. Because we have we have 96 miles of road, and kids are scattered all over, and this is all rural, back in the country type living. They'd be on the bus for well over the time that we're allowed to keep kids on the bus due to education rule and good safety and best practice. So I think that there are a lot of scenarios which we got to work out, and I'd be glad to work with you in trying to work some of these difficult situations out.
Without a doubt. And I think you'll enjoy hearing from the speakers coming after me as well.
Thank you very much. Let's see. Are these the ones we're... Okay, these ones. Kim LaValle. Welcome back.
Sorry, Kim LaValle from Mount Vernon. Thank you. It's good to be back. I am speaking in support of HB 1453. And again, I would just like to stress line 11, public school, unless the use of such transfer stations, depots, or terminals also applies to the transportation of non-chartered public school students. We're looking for equal transportation. I understand that I'm not going to rehash a number of scenarios that everybody's talking about, but just trying to keep it equal, making sure that the charter kiddos are not the ones getting dropped, if it can be avoided, and having them get to their school in a timely manner as well. Thank you.
Thank you very much. Are there questions? Not seeing any hands. Thank you very much.
Thank you.
Attorney Best. Back up.
Thank you, Mr. Chairman and members of the committee, for the opportunity to be here for the third time today to talk about the bill. Again, my name is Bob Best. I'm from Merrimack, and I've got a lot of involvement with a whole bunch of charter schools, and I won't bore you with all the ins and outs and details of that. I think that some of the message that you've heard for the presentation of the bill is what I want to focus on, and I want to make sure that I touch on some of the scenarios that we've heard discussed here. This bill is really, I call it sort of equal protection, the equal treatment. Treat all the students in this district the same. If you use depots for your students, then you can use them for charter school students. That's fine. Kearsarge and sitting on and waiting the bus, if that's what you do for the public school students, absolutely fine to do it for charter school students. Use terminals. As long as you're doing it equally for everybody, so be it. It is what it is, but treat everybody fairly. Don't do it for charter school students if you don't do it for the traditional public school students. And that's what this bill is really all about. And some of the places that this happens, pre-COVID, there were some situations where even though the existing law says use the same buses and routes, they were not using the same buses and routes. They were bringing all the charter school students to a terminal, and everybody else that wasn't a charter school student got some other kind of a treatment. And that's just not fair. Charter school students are public school students like any other, and they don't deserve second-class treatment on that. But if the school district uses terminals and they use them successfully as you described, terminals are hard. You talked about supervision and what do you do when the supervision isn't there. All that has to be worked out. But if you're using terminals for all the district schools, fine. That's okay. Use it for the charter schools too. Just don't use it for one set of students and not the others. During COVID, the use of terminals really expanded, especially in Manchester, with good reason. It was all the reasons that you talk about. Busing is really challenged right now. Hard to find drivers, hard to find the costs, hard to find space on the bus where you have less kids on the bus because you're trying to keep them all a few feet apart, all of that. And so it got more complicated. And the way that Manchester did that was they had terminals located around the city where all the parents had to bring their own kid to the terminal from home, and then from the terminal, they would be taken to their school. And lots of reasons to criticize that and not love it, especially with the little kiddos, the 4- and 5-year-olds, and them sort of all the best supervision that you're trying to impose. It's hard to do. when that system is sort of put behind us for the other schools in town, but the charter school students still have to have their parents bring them from home to a terminal to get on a bus to go to the charter school, you've got a clearly unfair, unequal treatment of schools for no reason other than we have a preferential treatment for public school students and not for charter school students. And that's really what this bill's getting at and is the important thing to tackle. Charter school students are not second-class citizens. They don't deserve, when they go to a terminal, they're actually on the bus longer because they go from home to, you pick the school, they get off the bus and they sit and they wait, and in the wintertime they wait in the snow, or they go into the gym or whatever, and somebody's trying to supervise them, but they don't really know the kiddo because it's not from their school. But they, can count heads, and they do their best to try to keep track of all of them. In one situation with one of the charter schools that I represent, they did have kids go missing at the middle school that they were at, the other elementary school that they were brought to, and cause that momentary panic. But if you're doing all of those kinds of things as a matter of your usual course, fine, so be it. But if you're not, if you're going to give better bus service to the local kids than you are to the charter school kids, that's not fair, that's not right, it's not what the original statute before this amendment intended, and it's certainly not what should happen with this amendment. As to all the scenarios about, hey, this works for us and we've got a scenario and all the kids come to those things, if that's the system you're using in the district for the public schools where you're using transfers or terminals or depots or whatever you want to call them, so be it. Go ahead, continue to use those. Would love it to be better. But the kids on the bus longer, when they come from home, wait around at a bus terminal for the right bus to arrive, and then get a second ride to another place. They're waiting at that school for 5 minutes or 10 minutes or 20 minutes, and then they've got another ride to the other school. That makes the kiddo's school day longer. It makes them experience a different educational experience than other kids in their school district, and that's not right. Those kids have activities and homework and all of that, just like every other kiddo, and the time on the bus matters just as much for them as it does for others. I anticipate there's a little bit of discussion about special after-school weekend, Saturday. Even in the earlier bill, there was discussion about Saturday. None of these bills deal with anything to do with extracurricular activities or club sports or weekends or any of those kinds of things. The statute the original statute only requires transportation to school for school days. It's never required any of those other things. So even a school district that provides transportation doesn't have to provide transportation for the golf team or the baseball team if they choose not to do so. It's not legally required, and sometimes they make choices. Sometimes they allow it for one sport and not for other sports. Those things happen all the time, and it's got nothing to do with what's going on in this bill. This is simply about saying when a parent exercises their choice, which is what charter schools are, educational choice, I want to go to a different school for whatever my reasons, that my kid is still a citizen of the town. We're treated equally. We're all the same.
Thank you very much. Are there questions? Representative Porter.
Thank you, Mr. Chair. Thank you, sir, for taking my question. So you are saying that the scenario that Representative Woodcock had presented, where all the kids in the town are brought to the middle school, the middle school kids go into the classroom, the charter school kids get on a bus to the charter school, is not allowed under this bill.
There was a bunch of different scenarios discussed, and it's important to sort of understand the details of each individual one, but understand that the use of terminals today or that kind of thing is already exceedingly rare. Before COVID, there was a couple of school districts that were doing it, and most of them were doing exactly what could be done in this situation. You have buses that come from around town, they drop the kids off at one school, and then they go to the other school and drop the kids off at the other school. It's 5 more minutes down the road, and the buses are on their way. And that's what Manchester has done, and virtually every other school district where there's a charter school.
But that's not allowed in this bill.
Of course that's allowed in this bill,
Well,
yeah.
But the charter kids were waiting at the middle school for another bus.
That's not allowed. Not unless the school district, I'm sorry, my apology. I get too excited.
The the whole town, all the middle school aged children in the town are brought to the middle school. Most of them go to the middle school, 5 of them go to a charter school. All the other kids go into the middle school. The 5 kids that go to a charter school get on another bus that takes them to the charter school. That's not allowed under your bill.
No, well, I don't know if I get to claim it being my bill, but yes, that would not be allowed.
So what if it was the same bus? What if all the children got off the bus except for the same 5 charter school kids, and they went on the same bus to the charter school? Would that be allowed?
Yeah, of course.
What's the difference?
You're treating all the students fairly. You're treating them all equally. They all get treated with the same system. We don't employ terminals and make kids get off the bus and get back on the bus and know which bus to leave, or maybe they missed their bus at that transfer terminal, which has happened. All of those things are possible. Treat them like you do every other student. Make your, really what happens with this solution is much simpler than that, because the bus companies are really good at making routes and they figure it out.
But all the other students aren't staying on the bus and going to the charter school. So they can't be treated the same because they're going to 2 different places.
I'm sure that if I was asking you to drop them off at the charter school first, we wouldn't even, I don't think I'd survive that conversation. But yeah, I get it. There's got to be some level of difference. Obviously, the kids got to get off at the bus at different places.
Okay, are there further questions? Not seeing any questions. Thank you very much.
Thank you.
And the last individual on this bill is Bear Christina.
My apologies again. I didn't mean to talk over you, Representative Porter.
Good afternoon again, members of the committee. Thank you, Chairman Ladd. Bear Christina School Boards Association opposed. I'm not going to spend a lot of time on this bill. I think the concerns NHSBA have been sufficiently flushed out. First, I do want to thank Representative Mooney for a couple of things. Her desire to try and help kids that seem to be having some challenges is obvious, so we appreciate her dedication to this issue. Second, I would also like to thank Representative Mooney for clarifying what a transfer station is, and she means that in the context of bus transportation. I'm not lying. When I first read the bill, I expected to come in here and hear some horror story that a public school was dropping some kids off at the town dump and they were having to wait for another. I swear to God, that's what I thought it was about when I was expecting to hear. I was expecting to hear that story, which, to be quite honest with you, wouldn't have necessarily surprised me. Anyway, the 2 point, the logistics, I think Representative Mullen, everybody kind of talked about that. Representative Lakes, you talked about how geographically large some of our school districts are. And a kid may live in the northwest corner of Manchester and his or her charter school may be in the southwest. So kid lives in the northwest, the charter school is in the southeast corner. We have to find a way to get the child there. There may be no other option other than having a centralized location just for logistics, for time, for money, for cost. I also want to thank Representative Mooney. She talked about, I think Representative Lakes, it was mentioned, you mentioned maybe have established guidelines for student oversight and supervision and things of that nature. And Representative Mooney did say another level of bureaucracy, another level of guidelines for our teachers and our administrators who are already sort of burdened with other responsibilities. So we appreciate that angle as well too. That's going to conclude our testimony. Everybody, the conversation sort of brought out a lot of the concerns that we have, so I won't belabor the point. We're opposed to the bill, and I'm happy to take any questions.
Are there questions for the School Boards Association? I got one for you. Are we required to transport high school students on a school bus?
Thank you for the question, Representative. No. Transportation is for grades 1 through 8. I don't think we've added kindergarten to that yet, technically, as a matter of law.
That's correct.
Yeah.
So now the follow-up to that is that we call school off because it's, there's no school that day, but the charter school does have it, and it's a charter school high school kid. Are we then bound by, of course, statute says we don't transport we don't have to transport high school kids, but because we normally do it as a courtesy, would we have to then run the high school student?
That's a good question. I don't know if I think the previous bill that we talked about, I should have brought my computer up to pull up the pertinent statute. I believe it says something along the same, the charter school children or students shall be entitled to the same transportation rights, I believe it says, as those in the public school. I should have brought my computer up with me. We would interpret that as meaning that you can't exclude the charter school kids. So, for example, my understanding, some high schools will charge a transportation fee for high school. If you want to ride the bus and you're a high schooler, you pay $100 a year or something like that. I think I would, without pulling up the statute, I think I would probably interpret that as meaning the charter school kid, if they paid the $100, would also be entitled to the same. So I'm sorry, I do have it with me. 194. This is the last bill. 194B2, paragraph 5. Pupils who reside in the school district in which the charter school is located shall be provided transportation to that school by the district on the same terms and conditions as provided for non-charter public school. Pupils who reside in the school district in which the chartered public school is located shall be provided transportation to that school by the district on the same terms and conditions as provided for non-chartered public schools attending in the district and utilizing the same regular bus schedules and routes that are provided to pupils attending non-chartered public schools. So same terms and conditions, I would interpret that. That's current law. Just everybody be aware, that's current law. So if your high school charges a transportation fee for high school students and you have a charter school in your community, I think I would make the connection that yes, the charter school kids attending that high school within your district or your community could also ride the bus, but they'd have to pay that transportation fee as well.
Would then it be possible or a good idea for us to utilize the same policy we have for high school students going to the CTEs, where we reimburse self-transportation at 25 cents per mile? That's statutory language right now.
I mean, I hadn't considered that, Representative. That might be one consideration. There's a similar language in RSA, I believe it's 189:9, that talks about the public school transporting children who attend a private school within the district. And I think the language in that, this is terms and conditions. I think the language in 189:9 talks about the same rights and privileges as the children who attend the public school. And again, we've interpreted that as if the private school does not offer, if the private school does offer transportation on, say, a Saturday, the public school does not have to provide that. And how that works out with the school calendar and vacations and snow days, I would presume would be similar. So, that's for private schools, but I think there's at least some corollary language that and hypotheticals that we could use relative to these last two bills.
Thank you very much. Are there further questions from the committee? Not seeing. Thank you very much.
Thank you.
And that closes this hearing. Representative Mooney, you have two more of these bills. You have two more, I guess. Yes. So the next bill which we're going to go into is HB 1428, relative to the provision of special education services by charter public schools. Do we have any pink cards on that one? You got some right here? Okay. I'm going to give these to you just for a second here, Glenn. I got to leave the room for a little bit here, Technical, Rebecca, Bergeron, that's, okay, and that's hers right there. So I'll be right back.
Thank you, Representative. We'll open the hearing on House Bill 1428. And welcome back to the podium.
Thank you very much, Mr. Chairman and members of the committee. I am Maureen Mooney, for the record, from the town of Merrimack, Hillsborough County, District Number 21. I'm the prime sponsor and in favor of House Bill 1428, an act relative to the provision of special education services by chartered public schools. The intention of House Bill 1428 is to strengthen, support, and ensure special education services for children enrolled in chartered public schools. Also, my testimony is written and being distributed at this point. The bill creates a new section in RSA 194B:11, Roman 3, which does the following. And before I get into the following, you'll notice in my written testimony I have put in bold the time frames that the section addresses. A, in my testimony, at least 2 weeks prior to the start of school, special education plans shall be finalized, confirmed, and reviewed between a district and a chartered public school. Next, if the district fails to provide services to a chartered public school student, then within 2 weeks of the start of school, the chartered public school may hire or contract their chosen specialists to provide the services. In other words, taking that initiative, taking that action. There's a note here in my testimony. The resident district shall continue to have financial responsibility for the full cost of the services. And the third part in the new section, if within the school year, any time in the school year calendar, a 2-week lapse occurs in special education services, then also the chartered public school may hire or contract their chosen specialists to provide the services. Again, with a note, the resident district shall continue to have financial responsibility for the full cost of services. Just to review, the time frames are 2 weeks prior to the start of school, 2 weeks within the start of school, and a 2 weeks lapse anytime within the school calendar. Special education services cannot wait and cannot fall behind. House Bill 1428 will be a tremendous advancement in chartered public school law to ensure special education services are provided on time. This bill is very important. I cannot emphasize, and I am very passionate about this, services have to be, number one, provided, number two, on time, or the results can be disastrous. No more if my bill passes. We owe the students far better than things I've seen, things I'm hearing about, things that come up constantly. I would ask this committee's support of House Bill 1428's passage. Thank you, Mr. Chair.
Thank you. Questions from the committee? Oh, yes. I'm sorry, Representative Nelson.
What if a specialist cannot be found? You know, they don't exist because everybody needs them and they're not around. What happens to the charter school if they can't find them either?
Thank you for the question. I would say in that scenario, assuming my bill, is your scenario related to the passage of my bill and that happens? Okay. If that happens, your scenario, which I hope it doesn't, but it may, you're right, there are very specialized people and it's hard to find them. At a bare minimum, you as a House committee and us as a state would allow the charter school to at least start looking, start finding, and start the process to locate that person, to provide the services that are needed, and to provide them timely. So yes, it may be a scenario, like you say, hopefully not, but that's possible. All things are. It would be unfortunate. Perhaps there could be other alternatives. Perhaps there could be a brainstorm meeting to figure out how to provide the services. But my bill would keep people on a timeline and make sure that conversation happens sooner rather than when it's too late.
Thank you. Representative Moffett.
Thank you, Mr. Chair. Thank you, Representative Mooney, for taking my question. As I read this, it seems to give the charter school a blank check of sorts in that it simply says that if the 2-week period, if the special education services are provided, then the chartered public school may hire their chosen specialist. So I'm concerned about how would you respond to the concern that that's a blank check and they could spend $1 million on somebody?
Right. Thank you for that question. Hopefully we won't even get to the point of this having to be enacted or, having to spend so much money on various specialists and so forth. Hopefully that won't happen, especially if my bill passes, then, it would provide these guidelines so that hopefully services will be provided, specialists will be obtained. But I can only think, my experience with charter schools, those behind me, run such a tight ship with finances and budgeting and the like. I would be hard-pressed to think any chartered school would go wild, not spending money in areas they shouldn't and so forth. I see my bill only assisting the situation, providing the guidelines available, and hopefully we won't even get to the point where a charter school will have to contract someone, but it may happen if the sending district don't keep their end of obligations and so on. So I don't foresee your scenario, knowing how charter schools are run in New Hampshire, happening anytime soon.
Thank you.
Thank you. Anything further? Representative Ellison.
Thank you, Mr. Chairman. Thank you for taking my question. And you may be the wrong person to answer this, but I'll ask you. Do the time frames that are specified in your bill, do they apply to special education plans for students in the public schools?
Well, thank you for that. I guess to answer that, I would say my focus is the chartered public school. And whereas it's been explained earlier, the public school, the resident public school, pretty much manages the special education in conjunction with the chartered school. I tend to think you wouldn't see a bill like this coming forward from the public school system because everything is so accessible there in where they're located. I'm not sure a time frame is in order in that regard, but you're right, I could be the wrong person, and perhaps others can expand on whether or not such a time frame exists for them.
Follow up. Thank you. Only the question would then be, since we don't really know the answer, or we may get it from someone else, before when we were talking about transportation, we talked about parity between charter school students and transportation, public school students and transportation. I guess my question would be, given your bill, if it's enacted, will we have parity between the provision of special education services to charter school students and to public school students?
I hope so.
Thank you.
Thank you. Representative Woodcock.
Thank you, Chairman Cordelli. Thank you, Representative Mooney, for taking my question. I have a couple of them. I was following up on Representative Moffat's question, and I understand the physical priority of the charter school, how well they budget their money, and sometimes how little they have. Right. That being said, however, and I'm looking at Section 2, it doesn't say what the qualifications of the person being hired are, nor does it say what price you're going to hire them for. And I would have the same concern that if in fact a specialist, for instance, was not available, and you knew someone down the street, they say, yep, I'll do it for $2.50 an hour. Okay, we'll pay you 5 hours a day. And all of a sudden, this public school building has a non-certified professional getting paid a couple $1,000 while they're waiting times 10 days.
Yes.
Which you know, as unfortunately as Representative Ellison referred to, sometimes in public education, if you can't get the specific specialist, they're still waiting. And that's unfair to the parents. I'm not suggesting that. But to be able to offer this financial piece. So that's the first part of my question is, I mean, does that seem a reasonable understanding for that section?
Thank you for the question. I wouldn't, my familiarity with charter schools, which is pretty extensive, I've never known them to contract someone who was not qualified for a various position, especially when it comes to special education. A lot of times, special education plans will specifically say who is needed to perform what. And so it comes sometimes from that guiding document. So I don't foresee, like Representative scenario over here, I don't foresee a scenario as you're saying either.
Okay, if I may, so if the plan only calls for a one-on-one aid, and they have the one-on-one aid,
Yes.
that doesn't mean that they, based on what you're saying, so we're not looking for an OT person or a PT person or a speech person. They're saying we need a one-on-one aid to help with child services. So, but this allows this charter school to hire anyone they choose. There's no requirement for professional certification, and pay them what they choose to do under this bill. I understand you wouldn't do it; they may not do it, but a bill allows it to happen.
Yes.
Okay. And the second one is, last one, Ms. Crosby, on Part A, where you're talking about the 2 weeks to start of school. I thought I heard this morning from the director of special ed that this wouldn't occur because the charter school is not an entity in terms of special ed. They would be dealing with the parent. So this, if I'm reading number 1 correctly, you're asking them to finalize a review between the district and the charter public school. But they're saying their connection would be with the parent because the charter school doesn't have a standing as the LEA.
Yes, thank you for the question. Yes, but you see, the chartered public school has to work with the sending district on special education.
And I understand that, but I'm just saying what we heard this morning was that the person that the LEA has to work with is the parent. I'm not suggesting they shouldn't work with a charter school. We're not talking about invitations. We're talking about the way you have it aligned. They have to work with a charter public school, and the director this morning said their point of contact is the parent. That's all. Thank you. Thank you, Representative Clark.
Thank you. Representative Mullen?
Thank you, Mr. Chair, and thank you, Representative, for taking my question. Have you had the opportunity to meet with the special education director in Merrimack to discuss how this would happen or how this would interface with current practices?
Thank you for the question. Merrimack, no.
Have you, can I have a follow-up? Have you met with the special ed director of any public school system to talk about how this would work?
Thank you for the question. I've met with, this is one in my series of, coming directly from the chartered school. I communicate very often with those who operate charter schools or on boards, foundations, and so on. Their experiences in discussing, in working with special education directors where they are located comes into play here. I don't know exactly what their opinions are, the special education directors at the public schools about the timeline that I've put forward. My intent was to look after the special education students who are in the chartered public schools who sometimes don't keep to any timeline because services on the sending district side are not provided.
Thank you. See no further questions. Thank you for your testimony and bringing
Thank you very
forward the bill.
much.
Next is Kim LaValle.
Thank you, Mr. Chairman, I'm Kim LaValle from Mont Vernon, and I'm speaking in support of HB 1428. I'd like to follow up on a few areas of conversation with Representative Mooney. Overall, I would say most of the sending districts are doing their absolute best to work with the charter schools. They're trying. The problem is we're in a different location, we're in a different building, and it's not as easy to run down the hall and try to rectify something. We're in a different place. So what we're really trying to do with this bill is make sure that we have everything worked out, whether they want to send people to us that they've approved from their district, or they want to contract. They want us to contract with them for reimbursement for services, which means we have to hire the appropriate people with the licenses or certifications that are required. And we would hire them as our employees or 1099 them with an agreement through the sending district. We're trying to make sure that whatever the arrangement is, it's in place for the kids on the first day of school. If we're just starting these conversations the second week of school, because it's busy for the districts, we get that. But if we're starting conversations the second or third week of school, we may not see services show up until October. If there's a disagreement on services, it becomes even more challenging. So the goal is to get services in the building with an agreement with the sending district. That's the goal. We don't want to go out and hire people just because, I don't know any charter school that would go out and hire somebody for some exorbitant amount of money who wasn't qualified. I've never seen that. It doesn't mean it can't happen, but I've never seen it. So really our goal is to make this work for the kids that have services so that we can get them in place on time and the kids benefit. If they're missing services for a month or 2 or 3, it has an impact on their education, has an impact on the school, has an impact on their family, and it's just not in their best interest. I'll go back to, I don't think we're looking for a blank check by any means. Our goal is to coordinate with the districts. That's really what we want. And again, most of the districts are really good about it, but there are some districts where, you want an MOU, you're approaching them for an MOU. There was SB 238 yesterday. I know a lot of charter schools want to work out an MOU, and it's very difficult to get a response. I'm not going to give you the name of the district, but I can tell you one, it's almost a year out, and there's still no MOU for the students. So you're hiring people at their instruction, you're hoping the payment comes through, there's no agreement in place for the year, but you're trying to do what's right for the kids. And sometimes you have to hire an extra person because schedules are tighter when a smaller school, less teachers, less classes, and so forth, compared to the large district. So really at the end of the day, we just want the kids to get the services in a timely manner, in an agreement with the sending district. It's their responsibility, it's their document. We want to work with them.
Thank you. If I could just ask a question to begin with. The example you just mentioned, there is a district that has been trying to work out services with the resident school district for a child in the charter for a year, but that has not happened, and the charter has had to hire someone to provide the services called for in the IEP. Is that what you were indicating?
What I'm indicating is the charter school is providing the services in the IEP for a number of students without an MOU in place. There's a need for an extra special educator. I think they just hired one without the MOU. There's no guarantee. You really want that agreement for payment. You want to be in agreement on your payments, what you're paying people, what they're reimbursing you, so that it's nice and clean. So it's an MOU that's missing. Services are being provided.
Are there any other questions, Representative Moffett?
Thank you, Mr. Chair. Thank you for taking my question. So on lines 9 and 10, it refers to the chartered public school may hire or contract with their chosen specialist. Now, by the school hiring, are we talking about an Iep team? Could you clarify a little bit what we mean by the school hiring someone?
I believe the goal is to be able to hire, if it's a special educator, to hire a special educator. If it's occupational therapy and we've agreed that the school is providing it, then we can hire one if the sending district hasn't sent somebody. We want to be ready with services.
And a follow-up?
Yep.
Thank you. So I mentioned before my concern about a possible blank check scenario, which Representative Mooney responded to. But I'm also wondering about a search process. So I don't want to call it a bid process, but if there is a need to find a specialist or specialists, I'm just concerned that with no controls over or limits or guidance or structure in terms of spending or searching, what if there are like two possible specialists and one costs $50,000, one costs $100,000? I'm just wondering, I'm just concerned about quality control, so to speak. Are you tracking my concern? The bill doesn't really, it's fairly open-ended in those regards. I'm just concerned about blank checks and quality control and bids. Can you speak to that at all?
Sure. As it stands today, we try to find the best person for the job in a price range that is compatible with the local districts. They're the ones who reimburse for services when there's a contract in place for that. Otherwise, the districts are looking for them. So I would imagine it would be a very similar process. We would be looking for somebody that we know what they're willing to pay most of the time. We know what those guidelines are, and we would be looking to stay in that range, not trying to hire the most expensive person. It just doesn't make sense.
I'm tracking you. Thank you.
Thank you for your question.
Thank you very much. Are there further questions, Representative Porter?
Thank you, Mr. Chair. Thank you for listening. There seems to be some issues here. Do you think the issues that are surfacing are because the sending district is the LEA, and that perhaps if there was a way that the state could figure out that the charter itself would be the LEA, that would improve things for you?
I think that's a very tricky question, because for us to be the LEA, we would definitely want to see tax dollars following the student for special education. You're welcome.
Further questions? I do have one concern. We talk about this 2-week period of time that if you don't get this service 2 weeks prior to the start of school year, then you go forward here. What happens when we have, and this is where I found as a school teacher and school principal for all those years, that we had kids that move in during the course of the school year, and it takes almost sometimes a month, month and a half, 2 months before people gear up to get the special service for that particular student coming in. You're waiting for records to arrive, yes, but you're having to really gear up again. And do you see this going further than just the 2 weeks prior to school? Would it be also when students come into the district or the charter school and you have a similar type situation?
That's a good question. I would not want to speak on behalf of Representative Mooney. Typically, the transfers, when they come in, the record, in my experience anyway, the records are coming with the student fairly close anyway, and you're able to reach out to the district. But if you were not getting a response for a few weeks and the child was not receiving services, yeah, I think the charter school needs to be able to put services in place. It's in the best interest of the student.
Thank you very much. Representative Mullen.
Thank you, Mr. Chair, and thank you for taking my question. In your dealings with the public school systems, why are the services not being provided?
I hesitate to answer for them, but from what we see and hear in general, I think it's a common problem. There's a lack of personnel, and for a long time, charter schools were sent people from the sending district. They would send folks over to do it. Charter schools are growing. IEPs are growing in charter schools, and they are already short-staffed. I know we've had several districts tell us we barely get by in our own district. We can't send you people. So that's fine. The child's not down the hall. They're down the road and miles over. So The easiest solution for a lot of the schools lately seems to be to contract out people that meet their qualifications for a certain dollar amount. And I think they're just having a hard time finding people. And they're strapped with other, I mean, it's a thing across the nation.
Go ahead.
Thank you very much, Mr. Chair. So it's a two-part question. One, that being the case, why would we think that the charter schools will have an easier time finding personnel? And the second part of the question is, have you shared your concerns with the Department of Education?
Well, I have had conversations with people at the Department of Ed, not the ladies here today, but other people that work at the Department of Ed in charter schools. We've had general conversations about how challenging it can be. And I forgot, you had the first part of that.
Excuse me. The first part was why should we think that the charters will be able to find people easier than the public schools?
I don't know that we're finding them easier, but we are finding them. Slowly but surely, we are finding them. So we're able to provide the services as required in the IEPs.
Yes.
Can you do it in a 2-week turnaround?
If you sit on the phone long enough in your computer, you'd be amazed what you can find. It's not always perfect. I'm not saying we're better than the sending districts, but we're smaller, and sometimes it's just reaching out to your parent community, and they know people as long as they have the qualifications and it's within the financial parameters, and background checks, of course, all the rest of it. But we're able to find them. I know some charter schools, like regular traditional schools, we all are missing somebody somewhere at some point. But we're able to provide the services. You're welcome.
Are there further questions? Yes, Representative Ford.
In a recent conversation with the superintendent in the school district in our town, we had a conversation about finding specialists in special education. And one of the questions that came up, we were just talking about the various disciplines, and I was told that the same position in northern Massachusetts paid $100,000, and that we didn't have any provision for getting anywhere near that salary in that. Is that a situation that's statewide? I mean, I just don't know. It's a naive question. What is your understanding of the availability of those kinds of specialists?
The availability of a specialist for
Any special ed field.
they're hard to find, but you have to, it's a question of just continuing to look until you bring them forward. I would imagine if you're competing with Massachusetts and southern New Hampshire, that may be more challenging. I can't speak for those schools though. The one that I'm familiar with down there has the people in place.
No, I was just giving you that conversation and
Yeah.
not having any
Oh.
data or anything.
Yeah.
I was wondering if you had some.
Well, we've had people go to Massachusetts. They make a lot more money.
Are there any other questions? Not seeing any. Thank you very much.
Thank you so much.
Haven't done this pile yet, right here. Jane Bergeron.
Thank you very much. And for the record, I'm Jane Bergeron. I'm the Executive Director for the New Hampshire Association of Special Ed Administrators, and I will keep my comments brief. As we spoke this morning, it is the responsibility of the local school district, the resident school district, to oversee every aspect of special education and of providing a FAPE, which includes ensuring that the individuals who are providing services are licensed, credentialed, and hold the appropriate credentials for the provision of the services. In review of the bill that we just listened to, we would like to raise a few questions. The first one is really centered around the whole issue of 2 weeks before school providing a schedule. IEPs are written on a yearly basis, so we know what kinds of services need to be provided to all kids. But as someone mentioned just a few minutes ago, at the start of the school year, you've got kids moving in, you've got kids changing, you've got staff who switch positions, you've got staff who resign, you're hiring people, and it can literally be the day before school that you finalize a schedule to ensure that the kids are getting all of their services and the quality that they need. So providing an outside school organization 2 weeks before a schedule that's firm is not at all realistic. So we would raise some questions around that piece. The other thing that we would bring to your attention is around the 2-week lapse for services. And again, you heard about the critical shortages in special education. The state of New Hampshire has identified just about every special education category: special ed teachers, speech and language, our school psychologists, our behavioral specialists. We just can't find them. It's not for a lack of trying. And so to think that in 2 weeks that someone could find an individual, make sure that they hold the appropriate credentials, that you've gone through the background check, and that all of those things could happen outside of the school district being involved, and then not even knowing how much you're going to be charged. So we would ask all of those questions, including what the rate setting might be for those kinds of situations. Let's see what else is in my, I mentioned the critical shortage. So those are our major points. We really feel as though these kinds of things are really the responsibility of the school district. We find that this would be an unrealistic expectation to meet, and would open it up for questions to all of you.
Bob Best?
Good afternoon, Mr. Chair and members of the committee. Thank you again for the opportunity to be here. I am still Bob Best, and still that charter school guy. Very important bill, probably the highest priority one of all the charter school bills to me and my thought. And as before, with each of these bills, we hear folks come and talk about, adults talking about how some of these things are hard, or it's complicated, or things are scarce, or they cost a little bit. And I'm going to come back before you every single time and say, the kids. I don't really lose sleep over the fact that adults have pressures. The kids are the priorities. That's why the schools are there. It's to provide those services that the kids need, and to make sure that they're lined up. And as you heard from Representative Mooney, when you fall behind in special ed, even 2 weeks or 3 weeks or 4 weeks, it isn't a shoulder shrug. That might set that student behind for the entire school year. They may not catch up from not having those services lined up. That's how important this is. A lot of school districts do figure it out 2 weeks ahead of time. The existing statute, we heard this morning in some discussion about how the LEA, which is the school district, is responsible for providing the special education. The statute gives them 5 different ways to accomplish that, 5 different ways. We talked about blank check. Before you can get to a blank check, all of the control resides with the school district. They choose what's in an IEP. They write it up, they develop it with their IEP team, and then they choose how they're going to implement it. And in their own school, they do it sometimes with their own staff and sometimes with specialists. And at a charter school, here's what the statute says. The resident district may send its staff to the chartered public school. Or the resident district may contract with a service provider to provide services at the chartered public school. Or The resident district may provide services at the resident school district, resident district school. The resident district may provide the services at the service provider's location. And then the last one, the resident district may contract with the chartered public school to provide these services. 5 different opportunities to accomplish this goal, which they're obligated by law to provide on an IEP that they designed. And the only thing that this bill does is say, if you've failed at all of those things, somebody else can give it a try. Someone else can go looking for, and I know that there's concern about blank checks, and I hear numbers about a $50,000 expert versus a $100,000 expert. Really, we're talking about special ed teachers that you bill $45 an hour for. Sometimes it's a one-on-one aid that you bill $25 an hour for. So these aren't numbers on the scale of $50,000 or $100,000, but their qualifications and who they are set out in the IEP. The 45 and the 25 are a special ed teacher and a paraprofessional. If it's an occupational therapist or a speech therapist or whatever it is, you can't hire a neurosurgeon for $1,000 an hour and slide them in there and call them an occupational therapist. That's not what they are. And so there really isn't even a blank check even when you get to the bottom of all of that. And moreover, to the concerns that, hey, maybe the charter school would struggle to find people within 2 weeks. I would love to have more time. You heard from the districts that they don't even think they can provide 2 weeks of advance notice. But what's wrong with allowing the charter school to try? And at any point, even if the school district fails and the charter school is called to action by this bill and goes and looks and finds somebody and says, okay, school district, I found a special ed teacher. We're going to do it pursuant to the Representative Mooney bill and charge you for it. If the school district corrects that situation and steps in and starts to fill their role, then the school district stepped up and used its statutory obligations to do so. And it doesn't always have to look out into the industry to find some. Sometimes the school district has a special ed teacher or a paraprofessional. Sometimes the district has it. Sometimes the charter school has it. Sometimes there's one that's shared between schools. Sometimes the folks are available. And when that happens, there needs to be a response to this situation where the first day of school comes and nothing is set up for an IEP that was written and known for months and months and months ahead of time. When that happens, the current system puts that burden on the parent. We talked about, is there a 2-week gap in other occasions when somebody transfers into the district and all of that? Right now, the statute, the state of the law is that the parent would then go to the state and file for a due process hearing to claim that they are not receiving the free and appropriate public education, and they'd prove it to the state, and then if they won and they succeeded, they would either get their services or they'd get what's called compensatory services sometimes, which are another troubling aspect of this because they don't exist either, so you can't find anybody to provide the compensatory services. But to get to that state hearing and get a result and then move on, I dare to say if it happened in a month, it would be lightning speed. It's probably more like 2 or 3 months, which is a good chunk of the school year that gets away from you when you obligate the parents to do it. But you know what happens more often than that? The charter school is there with a student in their building, and there's no charter school administrator or charter school board of trustees that will tell its staff, don't provide those services. Because they have a heart. They're students, they're teachers, they're school administrators because they chose to be in this field for a reason. So the charter school steps up and provides the services, as Ms. LaValle said, with no contract and no compensation. And the school district doesn't respond to that at all. Why? Because the parent is satisfied. Their child is getting services. Parent doesn't care who's paying for it or who's providing it. My child's getting services. I'm not going to go ask for a state hearing. I'm not going to go for a due process hearing. So you end up with the charter school shouldering the cost of what the statute says is the school district's responsibility. Charter schools do everything that they do on a shoestring budget compared to other schools, and they don't receive any compensation for providing special education. Even, Mr. Chair, you talked about substitutes to cover for IEP meetings. All of that money comes from what charter schools had intended to spend on, their other programs. And you do it because you have to do it. You do it because you have a heart. You do it because you care about the kids. But it's not the right solution. The law is that the sending school district is responsible for this. The statute gives them 5 different ways to accomplish it. All we're saying is that when that system goes haywire, the person left out in the cold, the person that shoulders the burden of that, is not a 12-year-old. It's not the student that's left out in the cold when something goes wrong. That whatever solution we come up with for the fact that special education is really hard, the statute's Byzantine, the requirements set people up to fail, whatever we think of that system and those problems, which all exist and are all true, the victim can't be the kid. It can't be the kid that's left out in the cold. There's got to be another solution, and that's what this bill intends to do. I'd be happy to answer any questions. I don't have anything else that I would add to my direct testimony.
Thank you very much. Are there questions? Representative Moffett.
Thank you, Mr. Chair, and thank you for your testimony and your friends who've all testified several times. I applaud you being here and your intent and your passion, and you are good folks. And forgive me for circling back to something I've touched on before, but I've been on my question's coming right up. I've been on a school board, and I see scenarios looking at this language that scare me, and they maybe would never happen, and I'm hearing that, trust you and that you'll do a good job. Line 11, the last part of line 11 says the child's resident district shall continue to have financial responsibility for the full cost of the services. And if this becomes statute, and nothing against attorneys, most attorneys are wonderful, they do their job. And if a parent or a school contracts with whomever, this probably will happen. There'll be a very huge, I've seen it, there's going to be some huge costs, and some school districts will be hard pressed to, the local public school district will be hard pressed to support that. But if this goes into law, the attorneys for whatever family will say, this is the statute, the full cost of the services. In some districts, can you reassure us that we would not be making a mistake? I know I'm peppering you, but that's our job.
Yeah, no, it's fine.
So could you speak to that?
Yeah, absolutely. Thank you so much for the question. I think it's a great question. It's the one that's on everybody's mind. And this bill was intended to be that jolt. That is not intended to say, here's going to be a charter school hiring a bunch of experts at crazy prices. That's not what the bill's intended to do. What the bill's intended to do is to say, school district, choose one of the 5 ways in the statute that you can provide education and do it. Not later, not 2 weeks from now, not some other time. You control the IEP. You got 5 different ways to deliver the service. Pick one and do it. Now, how do you convince somebody to follow the law? You have a consequence that's really unpleasant. They lose control over it. They don't like to lose control over it. Now, is there some $1,000 an hour occupational therapist or special ed teacher? Honestly, no. That's the second part of the answer. You talked about lawyers. I am one, obviously. Here's the deal. Every contract, every agreement, every obligation that anybody has is an obligation to act in good faith. And if I went into a courtroom and I said, Your Honor, you should make so-and-so school district pay me $50,000 for a paraprofessional for 20 minutes 3 times a week, I couldn't in good faith make that argument, and I promise you the judge wouldn't give me the money. And so, those kinds of things are going to sort themselves out in the market. Will somebody pay $30 an hour for a paraprofessional instead of $25? Because that's what it took to pull some retired person off the bench and get them back into the school? You bet. And if that's the extra $5 is the consequence of this bill, money well spent. Money well spent. So Best I could do for your answer.
Thank you very much.
Further questions? Thank you very much.
Thank you all. I don't know if I've got another bill before you today, but if I don't, farewell.
Well, we'll find out. We have one, is the technical assistance from the DOE, Rebecca, do you have something you want to say or, okay, why don't you come forward then, please? Good afternoon.
Good afternoon. Thank you, Chairman Ladd and the committee for allowing me to speak today. There are a few things that I wanted to address regarding the bill. Within the bill, there are some phrases that are not defined within state or federal law. When we talk about a special education plan, there is no a definition of a special education plan. It would be an individualized education program. The second piece would be where the bill speaks to services needed. While special education provides for a child with a disability is entitled to the services set forth in their IEP, it is unclear what is meant by services needed. Is that the charter school determining what services would be needed, or are we stating that they would be following the IEP? And those IEPs are developed not just by the school district, but by the IEP team, which includes the parent. So that is a collaboration between the parent, the student's parent, and the district to say, this is what we have determined the child needs from the evaluations that were completed on the child. It is not the district creating this and then dictating how it would be provided. It is developed with the parents and as part of that team. So without clarity for that language, it could be inconsistent and potentially conflict with the special education process as defined in the state and federal law. A few other things, when we talk about all districts have to go through a procurement process. I hate that word, I'm sorry. Have to go through the procurement process if they are using federal funds to pay for any of these services. So if a district has decided that to pay for the speech and language services that we're providing at these charter schools, I need to use my federal funds, and it becomes a bill that is over $10,000, they need to go through procurement processes that we have to approve and say, yes, you can spend your federal funds on these dollars. If this bill were to be approved, they would not be getting that approved through us. It would be outside of special education law, both state and federal, where we would be providing authority to the charter school to expend potentially federal funds on something that they do not have the authority to spend those federal funds on. So districts have to be able to get that approval from us for them to expend those funds. And then it has been addressed a couple of times, and while I know that charter schools would do every effort to make sure that they get the people that are licensed and certified in the correct areas, they have no authority to say that they have to do that. Their rules are very different than regular public schools, so they could be somebody that does not have the correct credentials providing a service. It could be somebody who has an elementary education degree providing special education services, which we would not allow a regular public school to do. So just the concerns with that as they've already been raised. And I just want to say, I testified yesterday regarding Senate Bill 238, which is the MOU. And this bill, and then Bill 1141, and then 1014, which we heard this morning, all of these might be cleared up with developing a memorandum of understanding. This would provide for districts and charter schools to meet ahead of time to discuss all of these pieces and come to an understanding of who's going to get the speech and language pathologist, how is it going to be paid for, how are all of these things going to be cleared up, so that when you get to that point, you're not saying the child isn't getting services. And I do have to say, I talk with Ms. Bergeron's group on a regular basis. I talk with other directors on a regular basis. This is not a purposeful denial of services for those children in charter schools. It's not a purposeful denial of services in regular schools right now. Everyone is having a hard time finding staff to provide these services. So I just want us to keep that in mind as we look at this. I want every child to get every service they need, but I also understand that in regular public schools, this is also an issue at the same time. Representative Ellison had said, is this something that would provide a different standard for chartered school students? Yes, it would, because there are times when a regular public student is not getting the services they need because they can't find somebody. So this would give a different standard to charter school students by providing this language. So while not directly related, it was mentioned before, parents still have the right to file a complaint, not necessarily a due process hearing, but they have the right to file a complaint if their child is not receiving services. They would call the DOE, they would speak with Natasha Lupiani, and again, I will go back to, she will reach out to the district, but they can file that complaint because they are not receiving services, and they could be awarded compensatory services for the services they have not received. That does not change when they become a charter school student. They still have that right to file that complaint.
Thank you very much. Representative Bohm.
Thank you, Mr. Chairman. Thank you for taking the question. In normal circumstances with the local school district, is there any time limit that they have to start providing services, as this says 2 weeks?
They are saying 2 weeks. We don't have a time limit, but it has to be a reasonable effort. You have to show that you've been trying. As a scenario, if a parent called and said, my child hasn't had services for 3 months, we would say to the district, show us that you have been trying to fulfill this role. Show us what you've done to try to fill this role. Have you even tried to fill this role? Have you even tried to provide these services? Those are questions that we ask. So you have to show that you're providing reasonable effort. If the district has done nothing, then yes, it's going to be an issue.
So follow up. So 2 weeks is not a reasonable.
Right now, I mean, I would have to ask districts to clarify, but from what I'm hearing, no, it is not reasonable.
I'd like to just ask you a couple questions regarding services needed. If in fact you have a student that transfers in and the parent comes in and says, the IEP says I'm going to have speech pathologist, in other words, person with her C's, delivering speech to my child in conjunction with the IEP 3 times per week. And of course, the district that is shorthanded. Yes, there may be a speech pathologist, but the speech pathologist has meets with that child maybe several times during the course of maybe 4 weeks, but has a para delivering the service or the plan within the, to identify maybe those articulation or whatever we're dealing with. Would that be permissible? In other words, we're delivering a service. Are we meeting the need? That's kind of subjective. So how would a scenario like this be treated? Not providing the same service the parent wants.
Right. So it would depend on what was agreed upon within the IEP. If within the IEP we list who oversees the service and then who provides the service. So if within the IEP it says that a speech pathologist is going to provide the service, then the district has not met what was agreed upon in the IEP. If it says that the speech pathologist was going to oversee a speech assistant providing the service, then yes, then need would have been met. But you would also look at whether the student continued to make progress. You would look at whether the district made their best effort to provide what they could, and what that looks like at the end of it. It's always about progress and progress towards their goals. So while we might say to them, you should have talked with the parents and said that you couldn't provide a speech pathologist and would they agree to a speech assistant, they did do their best effort to provide services to that child, so they were receiving services and not receiving nothing.
Thank you. Further questions? Yes, Representative Luno.
Thanks very much, Mr. Chair, and thanks very much for joining us this afternoon and providing some clarification on this. In your experience, do districts do what they can to avoid having to pay for, I guess, compensatory services?
So typically, I would say yes, they do everything they can to avoid paying for compensatory services. However, currently, I know that there are many districts who, when they are not able to provide services right now because they're having difficulty, they are actually tracking services and voluntarily providing compensatory services because they know they have not met the need. But they are having those discussions with parents and saying, yes, we're saying that your child needs 3 services a week for special education. However, I can only do 2 right now. We're going to track how many we're missing with you, and we're going to come back to you and look at what the compensatory services might look like later on.
Great, thanks. So that sounds like working in cooperation with the
It's,
with
and
the
that's not
parents and the
typically what happens, but because of COVID, that was enacted by OSEP to look at compensatory services ahead of time, and we've encouraged districts to continue to do that so that they are still trying to meet that need for students.
Great, fantastic, thank you.
Thank you. Further questions? Not seeing, thank you very much.
Thank you.
So that concludes the last pink card we had here on this bill, so we will close this hearing. And we will get ready here to move into 1499, relative to charter public school eligibility for state school building aid. 1499. Be Representative Mooney. On this, right, including you, there's 4. Okay. Here, just give us that right now. Melissa? Okay, that gets distributed. Okay, we're going to go ahead, as soon as Representative Mooney gets to her chair there, and go ahead with this hearing. Again, this is 1499, relative to charter public school eligibility for state school building aid. Welcome.
Thank you so much, Mr. Chairman, Mr. Vice Chairman, members of the committee. For the record, my name is Maureen Mooney, a state representative from the town of Merrimack. That's in Hillsborough County District number 21. I am a prime sponsor, the prime sponsor and supporter of House Bill 1499, an act relative to chartered public school eligibility for state school building aid. Given the hour, given your patience, and I truly just want to express my gratitude for all of your very thoughtful questions and attention to all of these matters today. I'm going to give my intro and then look forward to hearing what those after me have to say so that we can wrap up in a reasonable time. But please know this is a very important bill and has been a long time in coming, and in many ways, much overdue. House Bill 1499 adds chartered public schools to a series of references within the statutes for school building aid eligibility. Additionally, in Section 10 of the bill, there is a repeal of RSA 194-B:11, Roman 7, which prohibits chartered public schools from receiving school building aid. School building aid is defined on the New Hampshire Department of Education's website as, and I quote, I have it here in my written testimony distributed to each of you, but I think this is worth repeating verbatim from the site. A program authorized by RSA 198:15-a, through which the state of New Hampshire provides financial assistance to local school districts for the construction or substantial renovation of educational facilities for grades K through 12. The passage of House Bill 1499 will fully complete this definition by adding chartered public schools that are and continue to be great contributors as K through 12 New Hampshire public schools. With that, I am going to conclude my introductory remarks. Thank you very much, Mr. Chairman.
Thank you very much. Are there questions regarding this bill to the presenter, co-sponsor, sponsor? Representative Ford.
Just a very basic question. The ownership of this building that might be built in such a way, would it rest with the school or would it rest with the community, the state?
Thank you for the question. The building being the chartered school building, that could vary. For example, there are charter schools now that own their own buildings.
Further questions? Not seeing any, thank you very much.
Thank you.
I have some technical questions I'd like to first ask Amy Clark. Is Amy, oh, you're behind that? Okay, great. For people here, Amy works with the DOE New Hampshire and is in charge of the building aid program. Is your mic on?
There we go.
Yeah.
For the record, my name is Amy Clark, and I'm with the Department of Education. I am the administrator of the School Safety and Facility Management Program, and the Building Aid Program falls under that. So I'm here, happy to answer any of your questions, if I can.
Okay, the first one I would have in regard to the 30 to 60% of the eligible cost of construction. Does that parallel what we currently have in law for the all public schools or districts?
So you're talking about the building aid rate?
Yes.
Is that correct?
Yes.
So currently, Representative Mooney pointed out a very good point in this bill is to note is that building aid, it's not building aid that prohibits charter schools from receiving building aid. It's that repeal, that last line in this bill. So in the current building aid law is the rate of 30 to 60% for public school districts, and charter schools qualify for 30%. So again, charter schools qualify for 30% building aid, but there's a separate part of the law in RSA 194 that prohibits them from applying to building aid. So just keep that in mind. But currently building aid is 30% for charter schools, district public schools, 30 to 60% depending on two factors, which is median family income and equalized valuation per pupil.
Yes, I'm familiar with that. Oh, very much so. So then the question I have is that once we release those applicants that have been approved, let's say on January 15th, and that we're getting ready to go into the appropriation of dollars from the town to facilitate this percentage in all districts, let's say the medium is around 40%. The other 60% is incumbent upon the people that are going to raise the money locally in the town there, and with the understanding that the project will provide 80% up front and 20% upon completion. And I'm just imagining it's the same way in this. It is?
Correct. You mean for charter schools?
For charter schools.
Correct.
Okay,
so they would come up with the 70% locally, meaning the charter school.
So where does the charter school go to get the authorization to raise the money for the other part locally? From their whom? In other words, we have to raise that at town meeting to facilitate the whole thing here, plus what we're getting from the state. Where does the charter school come up with the type of dollar that's necessary for some of these expansion projects?
Yeah, that's a good question. I would have to defer to others how the charter schools would generate their money. It's just not, the state wouldn't be generating any of it. Like currently, right now, they have to generate 100% of it. But how they do that, I would defer to others behind me that could speak to how charter schools would pay for their current construction project.
Okay, thank you. Other questions of the department? Pardon me? Oh, Representative Porter.
Thank you, Mr. Chair, and thank you. This is something I know very little about. So under the current situations that we have, local community public schools own their property. It belongs to the town. My understanding is that many, if not most, charter schools do not own their own property. So I guess I'm wondering how someone who doesn't own their own property could make capital improvements upon it using this money if they don't own it to begin with. It's like when you rent an apartment, you can paint the walls, but you can't, get a $100,000 loan to renovate your kitchen and then move out. So I'm wondering how that would work for a charter school that does not own its own building.
Sure. It's a good point. Thank you for that question. There are two pieces in building aid. One is called building aid, and it's for the construction of a property that they would own. So this would not pertain to charter schools that lease their buildings. It would be to specifically, you're right, not very common, but there are some charter schools that are growing, that are more well-established, that are looking for a place to purchase, and we have some of those that have purchased. There is another arm of building aid called lease aid, which charter schools are eligible for, and that is for when they are in a lease agreement.
How would this bill work for them?
So for the lease, it doesn't impact. They're two separate programs. So a charter school that leases would apply for lease aid because they can currently under the current law. And a charter school that owns their own building can't apply for lease aid because they don't own it. But they
Okay.
also can't apply for building aid because the law prohibits them from applying for building aid.
Thank you.
Yep.
Representative Moffett?
Thank you so much, Mr. Chair, and thank you for taking my question. And I want to follow up on Representative Porter's question. I received a message from someone who's fairly familiar with this area, and he says there's approximately one charter school that owns its own property. I don't know, but to follow up on Representative Porter's question, if there's only approximately one charter school that owns its own building, it would seem that this measure would almost be moot. Do you know if that's true? There's only one.
I don't think it's true, but you might not be too far off. I think the number is low, but as charter schools grow and as they have a longer longevity, they may be looking to purchase. So, but I would say that keep in mind that this bill doesn't increase the cost of building aid. It just allows charter schools to be an eligible applicant to building aid. So whether it be one charter school, two charter schools that apply over the course of many years, it will matter to that particular charter school because they'll be able to be eligible to apply for building aid. It doesn't increase the amount of the grant that's available. It's a competitive grant. So let me just clarify that. Building aid is capped at a certain amount of money, and way more projects we have than the amount of money. For example, I have maybe, depending on what the budget is, I could potentially have $40 million for building aid. I already have applications over $260 million of those. Charter schools would just be one of those eligible people that are seeking that a piece of that $40 million.
I see, and that speaks to the recall provision at the very end that was mentioned. Yes, you said a low number. I said approximately one, so it gave me a little wiggle room.
Right.
Thank you very much.
Further questions? Yes, Representative Cornell.
Thank you, Amy, for taking my question. I'm a little confused. If they apply for the building aid, it's for a building they already own to improve or make bigger. It's not to build new construction, or is it?
Both. So it's a capital improvement. So a common building aid project, there's really 5 of them, would be to build a brand new building, to substantially renovate a building. Again, these are buildings they own, substantial renovation, putting on an addition to a building, purchasing energy efficient equipment that helps a building, and purchasing land. Those are the eligible things. So you couldn't, building aid is not for small projects, not even a small renovation. You couldn't apply for building aid if you wanted to redo this room and do the carpet and the walls. That's not a building aid project. However, if you wanted to gut the things down to the studs and rework the walls, that would be a building aid project.
Yes, Representative Luno.
Thank you very much, Chair, and thank you very much, Ms. Clark, for joining us this afternoon. Does the department track the condition and quality standards of buildings that are currently occupied by charter schools?
We don't, probably along the same line. Well, let me just clarify that. We don't in the sense of, we don't for district public school, local district schools either. So we, as a school approval, so there's a school approval process at the Department of Education that the department reviews 20% of the local district schools every year, and therefore it's a 5-year cycle, 20%, 5 years. It gets so that the Department of Education is reviewing a school's facility as a school inspection. So do they have their fire inspection report? Do they have their health inspection report? Is there mold? Is there are their science, their chemicals being properly labeled? That type of review happens for the local district schools. It also happens for the charter schools. It's just under a different arm because we follow the renewal schedule for the charter schools rather than 20% every year. But it's not a facility condition assessment of charter schools or local district schools.
So it's not like the $3.3 million we're trying to seek.
Correct. It's not, there's no facility condition index, there's no educational sufficiency standard, we don't have a rank, we don't have a big planning document that says these are the top schools that we need to target, which would be great if we did.
Further questions from Representative Tanner?
Thank you. Are there federal funds available for charter schools for building aid?
So currently there's the ESSER funds and ARP funds, American Rescue, ARP funds. They're not through my program, so I'm not comfortable answering those questions, but those are the COVID, like just in general, those are the COVID relief funds, and they're through a different division at the Department of Education. But if you're talking about just general federal funds, other than the COVID relief funds, there are no federal funds available.
Yes.
So I thought that the charter schools, that there was a large grant from and I'm just wondering if that can be used for building aid.
Yeah, I believe Nate Green is here from the Department of Education. There's a startup grant for charter schools, and he's the expert on that, so he could answer those questions. If you'd like me to, would you like Nate Green to come up from the department?
Yeah, Nate can come up. And while he's coming up, I got a question, though, to ask you regarding a little bit of this. When we provide these grants to schools, there's a condition that comes down with it. If you walk away from this school in a period of time, 20 years, you have to pay back the whole loan that you received from the state. Would this be applicable to this particular type of grant? And what kind of assurance are you going to have that the longevity or the bonding power or the dollar that they have will be able to do what we're expecting as a state to recoup the dollar we put into it?
Yeah, those are very good questions. I'd say there's two things that I think that you should take a careful look at this bill. Again, the Department of Education didn't write this bill, but one would be that penalty section that you may want to look at to see if you feel like the state's investment is protected. Currently, it requires a local district school to pay back 100% of their grant if they leave that project within 20 years. So that's a long-term commitment. It's under the commissioner's discretion how they, whether they're going to waive any of that. So, for example, we have had some local district schools close that have been within that 20-year period. Very few, but it typically will happen. It's not happening in the first 10 years. Usually it's happening like year 18, year 19. And what the department has done in those cases is that we stopped paying building aid. If you know building aid, you might know where I'm going with this. But in the old building aid method, I mean, you just give me a nod if I'm going to go down in the weeds, because I know I can.
I know where you're going. You're going to the tail there.
The tail.
And we had a $540 million debt when we started this thing out.
Right.
And we're nailing it down, and it won't be done until 2049 or some such year.
Right. So for those that understand, we just, on year 18, we stopped paying our 18th year of payment. That's how we handled those. So that penalty would be one thing that you may want to consider on this bill. And then the other one is on page 2, line 4 through 6, or line 3 through 6 on page 2.
Yeah.
And that's that percentage. You started with that question about how much charter schools should be. I would just say that the current, this proposal kind of leaves that on my desk. It says the State Board of Education. I know what that means when it's written in here. It leaves that up to me, which I can do that. That's fine. But what I want to point out is the current law does the formula for local public school districts. So to keep that the same, it might be a recommendation that you all determine what that rate is going to be if you decide to do this. Right now it says the State Board of Education shall develop criteria to determine the amount that is closely approximate to what we give local school districts.
Again, local school district's formula is current in this RSA 195, 198.15, and so it might be appropriate for you all to figure out what that formula is as well.
Yes, that's very complex, and you get an alternative stuff too with the 5% added on, and also, there's a lot to this. It's just not easy to put in a sentence, say we got it.
Correct.
Nate Green's back up here now. Can we follow through with the questions to Nate here? Pardon me? I thought there was a question for
yes.
Nate first.
Yes. So my question is about the charter school grant, that federal grant that was received, substantial millions of dollars. Is that going into building aid?
No, so it won't. Part of the conditions of that particular grant is that it cannot be used for any capital improvements to buildings. It can't substantially increase the value of any properties or facilities that charter schools own. The only building projects that could be undertaken using the federal charter school funds are if a charter school is currently using a building that is not zoned for an educational use. They can utilize those federal funds to make whatever improvements necessary in order to change the zoning requirements and make it appropriate for educational use. But anything beyond that would not be allowable with the federal funds.
Representative Bohm, did you have a question?
Yes, thank you. The question is something like you started with. Charter schools get relicensed, I believe, every 5 years, or if they go out of business beforehand. So if we give a grant for build a school, who owns that school? Who owns the property it's on? In the local, well, the town does, or the school district does. With a charter school, it can be anywhere. So if they go out of business or they don't get their license renewed, what happens?
That's a good question. I'll leave that up for others that know charter schools better than I do. Unless Nate wants to.
Yeah, I can speak to that. So charter schools are required to have a plan for the dissolution of their assets in the event that the school does close. And that plan has to be signed off by the State Board of Education. And so there might be a variety of people that would be listed as a creditor, depending on where the money or the assets have come from to that particular charter school. And then anything that is not explicitly spelled out within that dissolution plan, those assets revert to the local resident school district where the charter school is located.
Yes, go ahead, Representative Luno.
So thanks very much, Mr. Chair. And just a follow-up on Representative Bohm's excellent question. If the local school district assumes the assets, do they also assume any risk or liability in terms of maybe paying back the building aid grant dollars if a charter school were to exit or go out of business or cease operations within the 20-year period of time?
I would need to check back on that statute, but my understanding is that the local school district does not assume any of the liabilities. They would just take possession of any assets that have not already been deemed to somebody else through that dissolution plan.
Okay, so and a follow-up on that.
Yes,
So
yes.
the state could end up holding the bag then?
Yes, but I would want to check back on that
Okay,
statute.
thanks.
Yeah.
Are there further questions of the Department of Education?
If I may, can I just make one other comment? I had a little bit of time reading,
Ye-
so
yes, you may, Amy.
I just want to, if this bill does go through, just two things that I would consider for an amendment. One is on line 7. This is on page 1, line 7 and line 21. Both reference an RSA. Both lines reference RSA 198.15U through RSA 198.15W. Though that is the section that calculates the formula for the local public school districts. So if you keep this, you'll also want to reference the section that gives the rate to the chartered public schools.
And is the criteria that we would use for the application to get the 200 and some odd points that we have in it right now, would we use the same formula which has safety, the demographics of the building, all those issues? Would that be applied to these, and would they follow through and have that report also go to school building authority?
Correct. It would be just making them ineligible. They'd follow the exact same process.
Thank
correct.
you very much. Well, thank you very much to the department. We do have some more people to testify on this bill, but that should help us with some of the questions we might ask others. Next one is Kim LaValle.
Thank you, Mr. Chairman. I'm going to be very brief in the interest of time. You've all been very patient today and had lots of questions about the bills. I am in support of HB 1499, and any of my other time, I'd like to allow other people to come up for public comment.
Thank you very much.
Thank you.
Thank you. And then the other card we have here is Bob Best.
Thank you, Mr. Chair, members of the committee for the opportunity to be back again. I thought it was done, but I miscounted. Sorry about that. Very brief comments. I support 1499. I think being able to fund the buildings for charter schools has always been a really complicated puzzle and one of the big barriers to getting them going. In terms of them getting lease aid in the past, that was certainly a big benefit, and I think that that'll continue to be a benefit for the schools. But if you ask why so many charter schools lease their buildings instead of buy their buildings, it wasn't that long ago, single-digit number of years ago, the law actually prevented charter schools from carrying long-term debt. So they couldn't finance anything for over 5 years. And so when that was in place, obviously you don't have, there's no accessibility to buying a property or owning your own property when that law was that way. That's changed, that's been repealed so that charter schools now can do so. But obviously bank borrowing is still very, very difficult for them to do. So not many have done it, most of them have been leased. And to that extent, it won't have probably a ton of immediate effect. But part of the reason why charter schools don't own their property is because they've never been eligible for lease aid. And so it's sort of the catch-22. Not lease aid, building aid. The only other thing that I would add to that, obviously it's a very, very important assistance to the school to help establish the building. The building is, after the teachers, the biggest cost that you have in trying to set up a charter school. And you want those buildings and facilities to be wholesome and conducive to a great educational environment. I think I plan to talk about who owns the building and how do we know we're protected. We're putting public money into a charter school building. How do we know we're protected? But I think that the folks that testified before me, especially Nate, really covered that pretty well. The only thing that I would add to it is that the statute does require every single charter school is also a 501c3 charity, which is governed by the Attorney General's office. The Director of Charitable Trusts, Tom Donovan, supervises everything that we would do with assets. And the one thing that I can say for sure is that there isn't any scheme at all in the plan where the ownership of that building ends up in private hands. There's just, it's not possible to do under all of the various limitations that are out there. So one way or another, the building will always be dedicated to some public entity, some public good or public use. The ones that are out there today that are leased are more often owned by a foundation that had to do a lot of fundraising. And God bless them for being as successful as they have been in doing that with foundations and fundraising. But to the extent that we embrace charter schools and school choice, is private funding, is it relying on the charity of individuals, the chosen method to fund public schools? These are public schools for public school students. And I think it's fantastic that people have come forward to purchase buildings and lease them to charter schools or otherwise fundraise and be very, very philanthropic. That really isn't the way that we ought to approach funding a public need and a public cause. That's all I got. Thanks.
Thank you very much. Any questions? Thank you very much.
Thank you.
Yep.
Now I know I'm done this time, I promise.
Yep, we're down to the bottom of 1499. I don't have any more pink cards, so with that, we're going to close this hearing. And that was the last. Oh, you had a hand up. Excuse me. Well, come on up. What was that bill? The old building and at fair market value? I wonder if they're aware of that. Yeah.
Sell a property for a dollar to a developer. Go out and apply for
Yeah.
this room. So he was told to try to step back and.
I think that was last year.
Yep.
Yep.
Thank you, Mr. Chairman.
Yes.
First of all, my apology. I thought I had the pink card right, but apparently not. So my apology.
Well, looks like Representative Litchfield has it.
All right. Thank you.
There we go.
I'm Bill Phillips. I'm with the National Alliance for Public Charter Schools. Thanks again to the committee for having me. I see how perilous that can be. I almost didn't make it. So we are obviously in favor of this bill. I think though I've given you testimony, but I think the way I'm going to come at this is I was writing answers to your questions as quickly as I could, and so let me frame my testimony to answer as many of your questions as I can. Ma'am, I'm sorry, I don't know your name, but you essentially asked a question of why. Like, why do they need this? That's how I interpreted your question when you asked it earlier. So here's the way I'd put it. If you accept that creating options for kids and families through chartering is a policy good, if you accept that, then you have to face some of the things that get in the way of them being able to do that. That's typically lack of access to startup funds, it's buildings, it's talent. So obviously today's conversation is about the buildings. This issue is particularly relevant once a school gets established. And what I mean by that is typically the schools start small. They get their program in place and they get their operations under control, and then they start to grow, typically per the terms of their charter. It's once they're getting to a point where they have to grow that the building actually becomes an issue. And what I mean by that is it's actually difficult for them to finance their building, primarily because it's lack of access to local bonding or local funding. There's two problems with it, and this is the why. This has a programmatic impact. One of the things I put in my testimony, I think I cited a study, I gave you some statistics. Essentially what it does, it hurts their programming in two ways. You'll see in a lot of cases it makes it impossible for them to do things like science labs and libraries and kitchens. So they're actually, obviously it's hard to do science without a science lab in some cases. The other thing it does to them typically is it forces them to use their operational funding to pay for the building, which obviously has an impact on their programming. Part of what I want to get across is if you agree that we got to find ways to get at the building issue, Representative Mooney, God bless her, has proposed a number of things this session to try to get at this. She's talked about the revolving fund, we're talking about building aid, and we actually talk about bonding a little bit later. Building aid is one of the better ways to get at it, because typically what we're talking, as opposed to like a credit enhancement where you just make the note cheaper, building aid is you give them a grant. You're actually giving them money to pay the bill. So that's obviously a very good way to help the charters. Now, I'm going to try to go through some of the questions I heard as best I can, and obviously if you have more, I'm going to be happy to answer. Something I noticed about the reimbursement rate, you picked, or I think Ms. Clark mentioned it was at 30, which I believe is the lowest number, which I think what that means is typically when you do your building aid, that's for towns that have a better ability to pay. They would obviously get a lower amount of aid. I went and looked, just so you know who you'd be serving here. If you look at children in poverty, charters serve about twice the number of children in poverty as district schools do. It's like 7% to 3.5%, so not dramatic numbers, but the point I'm making to you is the charters are not serving affluent kids or affluent communities. You might, I wish Ms. Clark was here, I was going to tease her. We threw that, hot potato at her for, hey, here the department, make up a number for us, and I see she threw it right back at us. You might want to not have it at 30. If you're interested in doing this, maybe it's the median, which is probably closer to 40. Maybe it's the average, but 30 is the lowest number, and the kids being served are not those kids. Mr. Chairman, I think you asked a question on how do they how would the bonding be done? what they would do is if they were doing a construction project, you do a construction note and it typically gets taken out by private bonding, or you can actually just bond the project privately. What this would do is it would make it easier to get private bonding or private financing. The ownership question. So I think it was Mr. Mr. Best. He was up here 4 times. I should know his name. Mr. Best. He's right on this ownership issue. And what I mean by that is the reason most of the I didn't know about the legal prohibition, but the reason most of the charters are leasing, they can't afford to own their buildings. They literally cannot do the financing for it. So this would actually put some of them in a position to do it. The closure question, the one thing I think we might want to check, my experience with the dissolution process is a charter is closed. They go through a dissolution process, which includes selling off its assets. My assumption, or the way I would recommend considering this or doing this, you sell off the building, you pay off the bondholder, and you pay off the state, which would get at your question, which is like you mentioned that current process is you got to pay the aid back. The way I would do it is to basically when you sell the asset, pay back the bondholder and pay back the state. There was another question asked. Representative Luno, I noticed you ask a lot of building aid questions, so I'm going to assume you were going to ask me this question. So how's this? If I'm wrong, you can get me. Selling off the asset, it works great when the asset is greater than the cost, right? Then everybody gets paid back and everybody's happy. I think the next question comes up is what happens when it's less, right? And the question I would ask is who's in front? This is where I don't have a great answer for you, but I have a couple solutions. You have to put the bondholder in front, otherwise they won't be able to finance the building. The state has to go second in terms of who gets paid. I think there are one of the ways to get at that, and this goes to the federal. Representative Tanner, you asked about there is a federal credit enhancement grant. And what you could do is you could actually apply for that grant, and what you could do is create a loan fund, which you could use as coverage for those cases where the state needs to be covered. Frankly, you'd be more competitive for that grant if we actually had a program like this to point to. So that's what I have. Are there any questions?
Are there any questions from the committee? Not seeing hands. Thank you very much.
Thank you for having me.
Yep. We have a card here from Matt Southerton.
Hey, good afternoon, Matt Southerton with the New Hampshire Alliance for Public Charter Schools. I'll try to make this brief. Oh, sorry about that. Matt Southerton with the New Hampshire Alliance for Public Charter Schools. I'll try to make this brief. I know you've been here all day. So we have 3 schools that currently own their own buildings. 2 schools own their own buildings. However, those are actually owned through foundations that lease the building back to them. 1 school owns property and they would like to build a building on that property. I would like to reiterate that if charter schools were entered into the building aid formula or made eligible for it, this would only be eligible for schools that own the property and the building. So we're not talking about all the charter schools that currently lease facilities. And I think that that's an important part. Above all, I think this is for fairness. Charter schools are public schools. I just believe that they should be eligible. And that's all I had.
Thank you very much. Are there questions for Matt? Not seeing. Thank you very much. Are there any other folks that have cards they didn't submit to us? Then I will close this hearing. Thank you very much. That takes us to the bottom of the docket for today, so we are done. I thank everybody for hanging in there. And tomorrow, pardon me? Okay, yeah. Yeah, we start tomorrow morning at 9 o'clock. Whoopee. Yes.
Just a question. We didn't have a break this afternoon, so I didn't have a chance to get there and disrupt you, or interrupt you. I've got a notice on the general court website. There's two. On the calendar, it says tomorrow, those two.
We've got that taken care of. Where there's the 2 work sessions you're talking about that are in.
I get that, but that was
Yeah.
not my question.
Yeah.
A question on the general court website, because I've had 3 people contact me today who are coming tomorrow. It says canceled health education. They were trying to find the room. And they were coming down specifically for a bill tomorrow from Carroll County. So they wanted to know what the status was, and that's what's out there
Which
now.
bill are they speaking to?
They were going to speak to the one at the end, 1679.
That has not been canceled.
If
I
you
understand
go
that,
to
but
the
this says this says
website,
the whole day. This is the website.
it cancels
It
the
says
whole day.
House of Rep meeting scheduled canceled, House Education on the general court website. I understand what you're talking about, the specific one.
Then we'll have to contact, because that's not what's communicated. All we did was cancel 2 mass.
I know that.
Yeah.
I know that, Representative Lett.
Yeah.
Thank you. I wonder how many other pieces.
We'll get Rep. Cordelli, why don't you call
But how many
Lindsay
other,
or somebody right
my
now and
question
find
is,
out.
other constituents across the state who may want to come down on any of these bills have read that today and says cancel the House is canceled tomorrow. No, when you went, Glenn. Yeah, when you went to committee.
That's not the site. You gotta go to general court. No, that's you're going to the court, judicial side. So, pardon me? Well, I haven't looked at, I believe you. Yeah, I know, don't walk on those wires. You went to the general courts, you went judicial.
So you pulled these 2 out?
Yeah.
Are we gonna work on
That's right.
amendments during that period?
I called Caitlin and asked that Diana could be here,
Yeah,
and so we can look at the ethics thing. We
Yeah.
also will be working at that time on the CTE bill
yep,
with Jeff Beards.
yep.
So,
Great, because we got about 90 minutes. here.
Exactly,
And-
exactly.
And I'd like to,
yeah.
I'll put together a list of things, I'll email a couple of not amendments, but just.
No, I've been working on the ethics thing
Yeah.
with Brian.
Yep,
And he and I chatted for a good half hour, 45 minutes after
Yeah.
everything last night. And then I've also communicated that with Diana, and I think they may have some language for us.
okay, good,
Yeah.
good. So maybe we can pull
So
some
I
of
don't
those
think you have to start working hard on that, because I think we're going to get it.
Okay, good.
And-
And we don't need to worry about subs for tomorrow, if we're not executive.
No, we're not accepting
So,
it.
all right, good.
no.
No, I love the
whole
the ability
I
to
do.
work.
I do too.
Get some stuff off the desk, so, great.
Yeah,
Rick,
yeah,
thanks.
yeah,
Good
yeah.
job today.
Yeah, let me look at this.
No, you're all set, Mr. Chair.
Yeah, why?
It says revised, not canceled at this point. An hour ago, it said canceled.
See, they've been getting some stuff up there, like on Mondays, we had 2 subcommittees, and they had them both starting at the same time, rather than at 10 o'clock and at 1 o'clock. Yeah.
Right.
Yeah. Well, that's
So,
makes
okay.
me feel a little better.
Yeah. I talked to Paul, and he said call IT, and so I guess I don't have to call
Yeah,
IT at
yeah.
this point.
Let's see what it says.
Oh, yeah, no question. You don't get a mortgage unless the bank is in first.
CB, tomorrow is 27th?
Yeah.
Let's see where we,
They were showing me a different
26, 27, education. The bill, 1131 is
Yeah.
still up on the web.
Yep.
Jeez, what's with these people?
That's on the calendar.
That's on the
Itself,
calendar.
itself.
Oh, that's in the calendar, so that,
Yeah. Hi. Yeah, how are you? Yes.
So I'm hoping
revised, okay, good, good. This is this right here, yes, exactly, so it's there. Yeah. Yeah, yeah, they got that up.
I thought you were surprising us with this
Uh-huh.
today, but I guess he was saying we don't have to
Uh,
Cooperatives are gone, effective July 1,
So that's what I read,
2025.
but there was some kind of appeal, right? So how do you?
That's an appeal of your plan that you submit to the Board of Education.
So does it leave us all to our own
Right, and you
And so
would,
there's no provision for cooperatives that want to stay together?
not in the bill now, nope. Yep.
Yes, that might be an issue. There may be some who love what we're doing.
So, you know, the funny thing is that when we moved here 8 years ago,